Is what fresh matters are. Ella after next Tuesday kodi ella. Auto listing ಅಲ್ಲಿ ಬರುತ್ತಲ್ಲ. Maybe. So what? ಹಾ. ಬೇರೆ ಮಿಕ್ಕಿದ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಟ್ಟಿರಿ. ನಾಳೆ ನಾಡಿದ್ದು ಯಾವ್ದು ಇಲ್ಲ ಕೊಡಿ. ಅದು ವೇಟ್. ಮಂಡೇ ಬರುತ್ತೆ ಕೊಡಿ.
Petitioner's employment is at stake.
Being spoken to, my lords.
Wait. 2:30 ನಾಳೆ. ಆಯ್ತು, ಮಂಡೇ ಅವ್ರಿಗೆ ವೇಟ್ ಮಾಡೋಕ್ಕಾಗಲ್ವಾ? ಯಾಕೆ ಮಂಡೇ ಆಗದೇ ಇಲ್ಲ ಬಿಡಿ. ಹಾ ಕೊಡಿ, ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ಅರೆಸ್ಟ್ ವೈ? ಹರಾಸ್ ಪರವಾಗಿಲ್ಲ. No problem.
Petitioner's employment is at stake, my lords. Petitioner's employment.
All of you don't tell at once, one by one. Otherwise, give all the fresh matters. ಕೊಡಿ ಸರ್. ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಬಂದೇ ಬರುತ್ತೆ ಕೊಡಿ. ಕೊಡಿ ಬರುತ್ತೆ. No, 10 times also no problem. It will come, give it.
Petitioner's employment.
ಕಂಪ್ಲೈ ಆಗಿದ ತಕ್ಷಣ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ನೀವು ಮೆಮೊ ಕೊಡಿ ಬಿಡಿ. ಕಂಪ್ಲೈ ಆಗಿದ ತಕ್ಷಣ ಲಿಸ್ಟ್ ಮಾಡಕ್ ಆಲ್ರೆಡಿ ಡೈರೆಕ್ಷನ್ ಇಸ್ ಗಿವನ್. ನೋ ಪ್ರಾಬ್ಲಮ್. ಹೋಗಿ ಚೆಕ್ ಮಾಡಿ ಒಂದ್ಸರಿ. ಕಂಪ್ಲೈ ಆಗಿದ್ರೆ ಬಂದೇ ಬರುತ್ತೆ. ವೇಟ್, I'll come to you. Wait, did I ask for complaint? ಅದ್ಯಾಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್? ಮಂಡೇ ಬರುತ್ತೆ ಕೊಡಿ ಸರ್. ಎಸ್. SC ಏನು ಅದ ಫ್ಯಾಕ್ಟ್ಸ್ ಕೇಳಿಲ್ಲ, ಯಾವತ್ತಾಗಿರೋದು ಕೊಡಿ. ಎಸ್, ಮಂಡೇ ಅವ್ರಿಗೆ ವೇಟ್ ಮಾಡ್ಬೋದಲ್ಲ? ಯಾಕೆ ಲಾಸ್ಟ್ ವೀಕರಿಂದ ಸುಮ್ಮನೆ ಇದ್ದೀರಾ? ಮಂಡೇ ಕೊಡಿ. ಎಸ್, ಮಂಡೇ ಬೇರೆ ಎಲ್ಲ ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ನಾಳೆ ನಾಡಿದ್ದು ಯಾವ್ದು ಬೇಡ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ಏನಾದ್ರೂ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ಅಯ್ಯೋ ಅದಕ್ಕೇನ್ ಭಯ, ಕೊಡಿ ಸರ್, ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ಏನ್ ತೊಂದರೆ ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಲ್ಲ, ಕೊಡಿ ಸರ್.
138 proceedings has been initiated.
Tomorrow and day after don't ask unless there is extreme emergency. Otherwise give all the fresh matters. ಕೊಡಿ, ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. It will come, sir. Give it. Wait, sir. You want to speak urgently? Wait. Yes. ಏನ್ ಮಾಡೋದು ಮಂಡೇ? ಯಾವತ್ತು ತಗೊಳಕ್ಕಾಗತ್ತೆ ಹೇಳಿ? ನಾಳೆಗೆ ಆಗ್ಲೇ ವೆಬ್ ಹೋಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೀನಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ನಾಳೆ ನಾಡಿದ್ದಕ್ಕೆ ಆಗೋಗಿದೆ ಆಗ್ಲೇ. ಮಂಡೇಗೆ ಬರುತ್ತೆ ಕೊಡಿ. Everybody has a problem for Monday?
It's a pending matter, my lords. Petitioner's employment is at stake, my lords. Petitioner's.
Well, see, how many can I take? Adhyakshara. Allah, how many can I take? 1,000? Illa tane. So I'll take whatever is possible. Bharat. Fresh matters ella Monday baratte kodi. See, you should tell all the members. Let them comply with the office objections. If it does not come, you complain. First compliance, amel complaint. You do your job, it will definitely come.
That will ensure.
That I have instructed that once the office objections are complied, no fresh matter should remain in the board. ಅದು ಬರ್ದು ಕೊಡಿ, ಅಲ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. ನೋ ಪ್ರಾಬ್ಲಮ್. ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್ ಅದು ಬರ್ದು ಕೊಡಿ. ಬಟ್ ಕಂಪ್ಲೈ ಮಾಡ್ದೇನೆ ಇಲ್ಲಿ ಮೂವ್ ಮಾಡಿದ್ರು ಬರಲ್ಲ. ದಟ್ ಯು ಶುಡ್ ಎನ್ಶ್ಯೂರ್. ಬರುತ್ತೆ ಮಂಡೇ, ಎಲ್ಲ ಬರುತ್ತೆ ಕೊಡಿ. ಎಷ್ಟಿದೆ ಮೇಡಮ್ ಮಂಡೇ? Monday 200 ಇದೆ. Auto listing will begin from Tuesday once you comply with the office objection. ಇನ್ನೊಂದು 50 ತಗೊಂತೀನಿ, ತೊಂದರೆ ಇಲ್ಲ. 250 or 300 is not a problem. Give it. Yes. Vivek Reddy sir, last 2 days, sir, June 1st and 2nd, your councils have given 900 memos. Where will I go? How can I manage? Tell me. You also should be considered. 900 memos for 2 days.
Very good. There may be about 50-60 memos.
We'll take everything. I'm not saying when have I denied a memo, I don't say that. But how can I take so many? You should also know it. Give it, yes.
It's a
Vacating
pending,
stay ಕೊಡಿ, first ಕೊಡಿ ಅಲ್ಲ. ಎಲ್ಲೆಲ್ಲಿ vacating stay ಇದೆ ಕೊಡಿ ಅಲ್ಲ. All vacating stay applications give. Please give vacating stay application. ಏನಾರು ಆಗ್ತಾ ಇರ್ಲಿ. Vacating stay ದಿನಕ್ಕೆ 10 ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಅದರ ಮೇಲೆ ಹಾಕಲ್ಲ, 10 ಯಾವಾಗ ಬರುತ್ತೆ ಅವಾಗ ಬರುತ್ತೆ ಕೊಡಿ. All vacating stay ಕೊಡಿ. Every day there are 10 memos of vacating stay, give it. Give all vacating stays. ನೀವ್ಯಾಕೆ ಆ ಕಡೆ ಇದ್ದೀರಾ? Women only this side, men come this side.
My lord,
Settlement ಯಾವತ್ತು ಬೇಕು ಬರ್ಕೊಡಿ.
lords, petitioner's employment is at stake, my lords.
So what, sir?
Kindly have it done
ಕೊಡಿ.
tomorrow, my lords, tomorrow.
ಏನ್ tomorrow fresh matter?
It's a pending matter, my lords.
Give it.
They are the only breadwinners to the family, my lords.
We'll see, sir.
The
Give
false
it.
implication from the employer.
Give it.
138 proceedings have been initiated.
It will come, sir, give it.
Against the accused. 138 has been initiated against the petitioner here. She is a lady.
So lady ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ?
4 cases have been initiated, which I have given the police commissioner 4 months before that.
No problem, give it,
That
yes.
they are
Fresh
same as
matter.
will last.
Fresh matter.
Fresh matter.
Monday.
Monday ಗೆ warrant.
Mondayನೇ, yes.
Memo for being spoken to.
Why, sir?
There is an error of the trial court case number. That's
Give it. Yes. ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ? ಅದ್ ನೋಡಿ ಮೇಡಮ್, ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಪೋಸ್ಟ್ ಇಟ್ ಇನ್ 2027. Yes. ಕಂಪ್ಲೈ ಆಗಿಲ್ಲ ಅಂದ್ರೆ 2027. Yes.
My lords, at least on Monday, my lords.
There is a direction from this honorable court to dispose the FDP within 4 months, my lord. 1 year is over. Nothing has been progressed, my lord.
What can be done? You should file another case. ನನ್ ಮುಂದೆ ಯಾಕೆ ಬರುತ್ತೆ?
Revival application.
ಕೊಡಿ.
My lords,
ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿ ಪಾಸ್ಪೋರ್ಟ್ ಫ್ರೈಡೆಗೆ ಹಾಕಿ.
kindly have it on Monday, my lords.
ಫ್ರೈಡೆ ಇವತ್ತೇ ಬೇಕಾ ಮೇಡಮ್? ಯಾಕೆ SVP ನೆನ್ನೆ ಬಂದು ಶಾರ್ಟ್ ವ್ಯಾಲಿಡಿಟಿ ಪಾಸ್ಪೋರ್ಟ್ ನಾಳೆ ಹಾಕಿ, ನಾಳೆ ಬರುತ್ತೆ ಬಿಡಿ.
My lords, kindly have it.
ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ? ಆಯ್ತು ಬಿಡಿ.
My lords, have it on Monday, my lords.
For being spoken to.
ವೈ
My lord, liberty to file a discharge application, but the liberty to challenge charge sheet ಅಂತ.
ಕೊಡಿ. ಎಸ್
But the matter for 230 Malats wherein lookout circular is still continued even though the matter has been quashed based on a.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
ಇಲ್ಲ, fresh matter.
ಕೊಡಿ. 230.
It's Monday, my lords, Monday, my lords.
ಕೊಡಿ. ಮಿಕ್ಕಿದ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. ವೈ ಆರ್ ಯು ವೈಟಿಂಗ್? 230 ಯಾವ್ದು ತಗೊಳ್ಳಲ್ಲ. ವೆನ್ 11th ಅಲ್ವಾ? ಮಂಡೇ ಬರುತ್ತೆ. ಮಂಡೇ ಇಸ್ 8th. ಕೊಡಿ.
My lords for withdrawal, my lords.
ಕೊಡ್ತೀರಾ ಇಲ್ವಾ ಸರ್?
My lords for withdrawal, my lords.
ಥ್ಯಾಂಕ್ ಯು. ಈಗಲೇ ತಗೊಳ್ಳಿ. ಎಸ್.
For reporting settlement tomorrow, my lord.
So I should take it now. It's we'll see. Give it. There's no urgency there. No, sir. Yes. Give it. If you want to give the memos. Or else I'm going this side, I'm not coming this side.
My lords,
What? Huh.
98 and 420 madam.
Hmm.
The only allegation is I'm a homosexual individual and have affairs.
You are?
Homosexual individual, my lords.
ಆಯ್ತು ಕೊಡಿ.
my lords, I had moved the matter, my lords, I had moved the matter yesterday and it was.
Why are you in a hurry? Wait. Yes. There's someone next to you, right? There's someone next to you. Wait. ಅದ್ ಕೊಡಿ. ಅದ್ ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್. ನಾಳೆ ಬೇಡ, ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಮಂಡೇ ಬರುತ್ತೆ.
SC ಆಕ್ಟ್ ಇದೆ ಸ್ವಾಮಿ. Kindly
Atrocities.
230
FR
ಲಿಸ್ಟ್ ಮಾಡಬಹುದು.
FR ನಂಬರ್
ಇಲ್ಲ, WP ನಂಬರ್.
ಕೊಡಿ. 230 ತಗೊಳ್ಳಿ.
My lordship, this is for quashing your lordship.
FR WP ಅಂದ್ರೆ ಮೇಡಮ್, FR ಇದ್ರೆ ಬರಲ್ಲ, ಕಂಪ್ಲೈ ಮಾಡಿದೊರ್ತು. WP ಇದ್ರೆ ಬರುತ್ತೆ. Go and comply. Yes.
Your lordship, this is for quashing your lordship. And for the
Everything is for
respondent,
quashing. Anything else?
kindly post it for Monday, your lordship.
Why?
The respondent, the petitioner is borrowing time all the time, your lordship.
Sorry?
The petitioner is borrowing time and the respondent is not attending your.
You are for the respondent.
Yes, your lordship.
It will come. Give
Kindly
it.
post it for your.
File vacating
My
stay.
lords, I had mentioned the matter yesterday. It was directed to be listed today. It hasn't come up. In fact, when I went to the branch to check memo, the memo was also not found.
What is that?
My lords, it's a criminal petition, your
So
honor. but-
everything is criminal petition. What is the matter?
My lords, it's an aged woman who's been assaulted by her neighbor and the FIR is filed against the victim instead of the neighbor, your
You
honor.
told me. All right. Give it.
It could be listed at 2:30 today, your honor.
30 ತಗೊಳ್ಳಿ madam.
Vacating stay, my lord.
Will you wait? Yes.
Your lordship, for
Vacating
next
stay,
week,
my
your
lord.
lordship.
ಕೊಡಿ ಅದು, if not, date is not given, will not be given.
Vacating stay, yeah, already.
Vacating
filed,
stay
my
ಕೊಡಿ,
lord.
vacating stay ತಗೊಳ್ಳಿ ಅಲ್ಲ.
This is also for vacating
Vacating
stay, but this is a 138 matter, my
Give
lordship.
it, give it,
Discharge
madam.
application, they have added accused.
Pending matter, my lord.
Give it,
Your lordship, pending matter. Advocate matter, your lordship.
stay ಇದೆಯಾ?
Yes, your lordship, your lord.
Give it, yes.
Predicate offense of filed and IA seeking vacate. Tuesday, my lord.
Vacating stay ಅಂತ ಅಲ್ಲಿ ಬರ್ದು ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
This is not a fresh matter, but the petitioner is an aged person. He's getting repeated calls from the police.
Answer the call.
Investigation.
Answer
But
the call.
dispute is- We are, your lordship.
Then do it,
It's a
yes.
purely civil dispute. I'm only requesting a date may be given.
It will come. Yes. Chronic civil dispute.
It's a civil dispute.
Correct. What is chronic?
I didn't say.
Oh, yes. Hmm.
A date may be given, your
It will
lordship.
come.
Petition is filed in 2025, my lords, due to time constraint, court did not reach the city.
Give it.
Kindly have it tomorrow, your lordship.
Why?
The IA further investigation was allowed as per the order dictation, but in the operative portion, only the trial court's order has been rejected.
ಕೊಡಿ ನೋಡೋಣ.
Charge sheet has been filed when
Why did you
predicate
come
offense
this
has
side?
been.
Come this side. Yes.
Your lordships, it's 138 matter filed by the complainant, summoning the bank documents, which was rejected in the trial court. We have already filed. There is a
Fresh
stay
matter.
on our own case, so.
ಓ ನಿಮಗೆ ಸ್ಟೇ ಇದೆ ಕೊಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. ಏನ್ ಮತ್ತೆ ಯಾಕೆ ನಿಂತಿದ್ದೀರಾ ಎಲ್ಲ ಕೊಡಿ. ಗಿವ್ ಎವ್ರಿಥಿಂಗ್. 2:30ಗೆ ಯಾವ್ದಿಲ್ಲ ಯಾಕೆ? ನೀವು 10ನೇ ಮೆಮೊ ಕೊಟ್ಟರು ಪರವಾಗಿಲ್ಲ, ದಿನಕ್ಕೆ 10 ಮ್ಯಾಟ್ರ್ ಆಗ್ತಾ ಇದ್ದೀನಿ, ಅದು ಯಾವಾಗ ಬರುತ್ತೆ. ಅದ್ರ ಮೇಲೆ ಆಗಲ್ಲ ಸರ್ ನನಗೆ. 10 ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ದಿನ ಹಾಕ್ತಾ ಇದ್ದೀನಿ, ಇವತ್ತು ಇದೆ ನೆನ್ನೆನೂ ಇತ್ತು, ಅಷ್ಟ್ ಮಾತ್ರ ಮಾಡಕ್ ಸಾಧ್ಯ. ಕೊಡಿ.
My lord, being spoken to, my lord.
Fresh matter, right? Give it. Huh? Hey, no sir. Monday or Tuesday it will come. Give it. Yes. ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. Give it, sir. So what, sir? ಏನ್ ಹೇಳಿ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ ಏನು? ಏನೋ ಜಡ್ಮೆಂಟ್ಗೆ ಹೋಗಿದೆ. ಗಿವ್ ಇಟ್ ಟುಮಾರೋ. ಅದು 138 ನಾಳೆಗೆ ತಗೊಳ್ಳಿ.
My lord, being spoken to, my lord.
ಸ್ವಲ್ಪ ಇರ್ತೀರಾ ಮಾತಾಡಕ್ ಮುಂಚೆ? ಎಸ್. ವೈ? ಟುಮಾರೋ.
One matter for tomorrow, my lord. So Tuesday stay for the lordship has clarified that, my lord, only against the petitioner of proceedings is stayed. Trial court on the 5th day.
ಟುಮಾರೋ.
My lords, atrocities in a bailable offense, my lords, stringent condition of
Monday.
travel to the.
Monday. Yes.
This is a pending matter. There is
Give it.
30-year-old, 30 years of oncologist, my lord. He is a senior
That's
oncologist.
all right. Give it. Yes.
The only
ಇಂಟರ್ ಮಾಡ್ರಿ ಇದೆಯಾ?
intermodal.
ಮತ್ತೆ ಯಾಕೆ ಮೂವ್
The
ಮಾಡ್ತೀರಾ?
only problem is because I am being invited by other countries to come on research basis. Visa ಸಿಗ್ತಾ ಇಲ್ಲ, my lords, because of the pendency of a case.
ಮೇಡಮ್ ಅದನ್ನ ಟೇಕ್ ಇಟ್ ಆನ್
Anytime next week, my
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಹಾಕಿ.
All right. So
My
pleasure.
lords,
ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಯಾವ್ದಿದೆ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಸರ್. How long will I sit?
This is a matter, my lord.
You should also be considered. How long will I take memos? Give it. No problem, sir. Atrocities Act. Then stay ಆಗಿದೆಯಾ? ಪರವಾಗಿಲ್ಲ
Civil exams ಬರೀತಾ ಇದ್ದಾರೆ.
for cross examination, 138 proceeding.
ಕೊಡಿ. ಫ್ರೈಡೆ ಬರುತ್ತೆ ನಿಶ್ಚಯ ಕೊಡಿ.
My lord.
ಕೊಡಿ ಸರ್.
My lord, being spoken to, my lord.
ಕೊಡಿ ಸರ್. ಎಸ್.
My lords, this is, my lords, I'm not
Pending
seeking
or fresh?
quashing of FIR or
Pending
charge
or
sheet, my
fresh?
lord. Fresh, my lords. My lords, C report has been filed. I am a victim.
Monday.
My lords. Monday. Yes, my lord.
My lord,
There is
being
a-
spoken to, my lord.
another memo, my
No,
lords.
another memo. ಒಂದ್ ಸಾಕು.
My lords, ಇದರಲ್ಲಿ I have benefit of say, my lords.
Next
Your
Monday.
lordship-
Next Monday.
Your lords, two
Next Monday,
seconds to
yes.
demonstrate my case, my lords.
No, next Monday. Yes.
My lord, being spoken to, my lord.
My lords,
ಯಾಕೆ?
ಇದು ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬಿಟ್ಟು ಎಂಟೈರ್ ಓವರ್ ಆರ್ಡರ್ ತಪ್ಪಿದೆ 498A.
ಕೊಡಿ.
Pending matters, the connected matter.
Give it, sir.
Forgery offer.
Wait, madam. You come that side. Yes.
My lord, forgery of the general power of attorney when the.
ಈಗ ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್.
It's a pending matter, my
ಹಾ
lord.
ಕೊಡಿ.
He was not at all in the country. when
ಅಯ್ಯೋ
the-
ಪರವಾಗಿಲ್ಲ ಸರ್ ಕೊಡಿ ಸರ್. ಸ್ಟೇ ಇಲ್ವಾ?
My lord, I am for the respondent. Whereas my
Respondent.
properties are being sold, my lord, using.
Give
the
it. We'll see. Yes. Have you filed vacating stay?
Please, my lord. We have filed.
Vacating stay ಬರ್ಕೊಡಿ ಎಲ್ಲ it will come.
Please. That's pending. My lord, the connected matter is on tomorrow.
Mention it tomorrow morning. Yes. Not getting, where do you want to go? Thailand?
I'm retired, I'm trying to retire.
Oh, yes.
Junior is not getting married.
We'll see.
Predicate offense has been.
Give it, sir, give it.
As predicate.
Avinash, ಏನು?
I've got a benefit of stay, my lord. Your lord asked them to file a report. They are summoning me to the police station. I've called tomorrow, my lord. Today, end of the list or tomorrow?
Pending matter, ಹೆಂಗಪ್ಪ end of the list?
I have benefit of stay.
ಅಲ್ಲ, pending matter ಹೆಂಗ್ ನಾಳೆ ಕೊಡಿ.
Great.
The matter can be taken tomorrow. Why?
It can't be taken. You move it tomorrow. Yes.
Lord's predicate offense has been stayed, my lord. Even that when such is the case, charge sheet has been filed.
Give it, sir.
Lord's Monday, I pray, my lord. Obliged.
Fresh matter. ಕೊಡಿ ಅಲ್ಲ, ಜಗನ್ ಏನು?
138 proceeding class exam did sit down. Lords, the legal notice, excess amount is claimed. The complaint, least amount is claimed. It is against to the.
Next date ಏನಪ್ಪ?
Lords, next week it is there, Lords.
ಕೊಡಿ.
That's Monday.
Pending ಅಲ್ವಾ?
Pending. No, fresh matter.
Fresh.
My lord, pending matter. My lord, there is no interim order as such.
No interim order?
No interim.
No interim order. Give it. Yes.
The pending matter, my lord. Interim order.
Give it, yes.
Pending matter, my lord. The interim.
Friday.
Stay ಕೊಟ್ಟಿಲ್ಲ.
Petitioner is a student, my lord, he is working.
Latest judgment ನೋಡಿದೀರಾ?
In Canada, my lord, he is not able to.
Last week ಬಂದಿರೋದು.
4 months is already over.
Last week ಬಂದಿರೋದು ನೋಡಿ. ಅದಕ್ಕೆ ಮೂವ್ ಮಾಡಿ ಹಂಗಾರೆ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. Yes.
Petitioner is a student, my lord, applying for a working visa in Canada, my lord, he is not able to get it due to this case, my lord. That is reflecting.
Next week ಯಾವತ್ತರ ಡೇಟ್?
My lord, tomorrow, my lord, it's urgency, my lord, that is it.
ನಾಳೆನೇ PR ಬೇಕಾ ನಿಮಗೆ
Two
ಕೆನಡಾದಲ್ಲಿ?
petitioners,
Yes.
there are two petitioners, my lord, one is applying for a education purpose only for, he's got admission in Canada, my lord, he has to go. That is also the reason, my lord.
ಕೊಡಿ. Next week, not tomorrow, madam. Tomorrow it's already full.
On Monday, my lord.
Huh?
Monday, my lord.
No, Monday is fresh matters, madam. How much will I take? Monday is already 400.
Pending matter.
2027 post ಮಾಡಿ. Yes. ಏನಿದು ಮತ್ತೆ? ಸುಮ್ನೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದಲ್ಲ. Do your work properly and then complain. We'll take it in 2027. Don't project something that is not there. What you have complained? Yes.
Pending matter.
ಬರುತ್ತೆ ಬಿಡಿ. Yes.
Your Honor, pending matter.
Monday ಹಾಕಿ madam.
Pending matter. Student completely lost eyesight.
Student completely lost. Why?
Because of the negligence of the.
Again, fresh matter, pending matter.
Pending matter.
Then ತಗೊಳ್ಳಿ madam.
Interim order vacating.
Vacating interim order. Tuesday ಹಾಕಿ ಅದು. Tuesday next.
This matter pertaining to DRI, electronic seal was manipulated, escaping this thing. Lordship was quashed in respect of accused number 1 is concerned, rejected the petition. In respect of accused number 2, coordinate bench allowed without notice to DRI. I had filed a recalling application. Coordinate bench, Lordship.
ಈಗ ಇಲ್ವಲ್ಲ, ಕೊಡಿ, ಗೊತ್ತಾಯ್ತು ಯಾವುದು ಅಂತ ಕೊಡಿ.
Recalling.
RFID 2022. Yes.
Kind of any date it can.
All right. Yes. ಅದು ಹಾಕೋಣ.
Update.
Madam, senior citizen.
ಹೇಮಂತ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್.
Interim matter consider, my lord. Senior citizen. See, petition is age about 75 years, my lord.
So what?
The case on counter case, my lord. Can
So
you
what?
pending matter? Consider interim prayer, my lord.
No.
All appeals only 323 finance for finance disaster.
ಕೊಡಿ.
Date,
Next week.
Date.
Pending matter. ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ವಾ?
ಇಲ್ಲ sir. Can you Monday, my lord.
No problem. Give it. Yes. Next. Call the cases. The petitioners are accused 2 and 3 are alleged of the offence punishable under section 498 inter alia. A perusal at the summary of the charge sheet as obtaining in column number 17 would not indicate any ingredient of the offence that ingredients of the offence under section 498A of the IPC. Permitting further proceedings against these petitioners would run foul of the judgment of the apex court in the case of Kashkan Kaushar versus State of Bihar, 2022 SEC Online SC page 162. In that light, there shall be an interim order so and so. 1 HCGP 2 emergent notice. Next.
Number 2. It is connecting matter.
ನೆನ್ನೆ ಕೊಟ್ನಲ್ಲ ಕೊಡಿ ಅದು.
CP 85/24.
CP. Part CP. Yes.
85/24.
All right.
Given a
Yes.
6
Next.
months to complete the proceedings.
Number ಬರ್ಕೊಡಿ sir. Yes. Next.
The lordship B report is filed.
ಅವ್ರಿಗೆ ಯಾಕೆ ಕೇಳಿ?
Still number 3.
ಅವ್ರನ್ನ ಕೇಳ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ಅಷ್ಟೇ.
Represent the petitioner, my lord.
Yes, sir.
The proceedings under the Domestic Violence Act has
3
been challenged.
Serial number 2, B report is filed here.
B report format, serial number 2.
I'm sorry.
ಕರುಣಾಕರ್ ನೀವಾ?
ಅಲ್ಲ, I'm for serial number 3.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇರ್ಬೇಕು ಸರ್, ಒಂದ್ ನಿಮಿಷ.
List 1, serial number 2.
ಅಲ್ಲೇ ಕೂತಿದ್ದೀರಾ ಮತ್ತೆ ಸಿಟ್ಟಿಂಗ್
My lordship, I thought the next number have called. He started, my lordship.
B report format, closed, disposed. Yes. Next.
Number 3.
The petitioners are respondents in the DV Act proceedings initiated by the wife, finding no ingredient of the offense under the Domestic Violence Act. There shall be an interim order of stay equate these respondents till the next date of hearing. Emergent notice to the respondent. Next.
Please.
4.
In the meantime.
5.
In the meantime.
6.
The petitioners.
File, lordship.
5 ಆಯ್ತು, stay ಆಯ್ತು sir. Yes.
Petitioner attesting witness to the sale deed.
Sorry?
Attesting witness to the
Correct,
sale
sir. The petitioners, the subject matter of these proceedings is akin to what is pending before the civil court in OS 635 of 2023. Insofar as the petitioner is concerned, the only allegation is that he is an attesting witness. Being an attesting witness cannot be drawn into the web of crime is by now settled principle of law. In that light, there shall be an interim order of stay with this petitioner till the next date of hearing. Next.
7.
I prefer the petition in this case. Alleged transaction is on civil nature.
Page 13 and 14, I have marked a post. The complaint against the petitioner is as quoted herein above. If this is considered, the criminal law is set into motion for the purpose of recovery of money, which cannot be permitted. In that light, there shall be an interim order of stay of further proceedings with the petitioner till the next date of hearing. Vinayak, CC of 2010. What's the problem?
I understand where I stand, my lords. 2010 CC, 131 witnesses. As of now, ಒಬ್ರದೂನು ಇನ್ನು
Charges
complete
are framed in 2023.
That's understandable, but why it's not
31.
progressed?
No, my lords. He's 79 years old. He'll turn 80 now. Every day, every time for him to travel from Bangalore.
Correct, but where's the question of staying that now? We'll only direct the court to conclude the proceedings in time frame.
Yes, man. Apart from that personal appearance, whenever
That means-
required, he'll.
Yes, the petitioner is before the court seeking the following prayer. Though the entire proceedings are sought to be challenged and though entire proceedings are called in question, the charges have been framed long ago and the trial is in progress before the concerned court as the issue is 16 years old today. The learned counsel Vinayak Pandit would now submit that there is no progress in the proceedings as there are about 131 witnesses to be examined and the court is proceeding in a snail's pace. The learned counsel submits that the petitioner is now
79.
The petitioner is now an octogenarian and cannot be seen to be attending the court proceedings throughout for examination of 131 witnesses. In that light, I deem it appropriate to infuse finality into the proceedings by directing the concerned court to conclude the proceedings with an outer limit of 9 months from the date of receipt of the copy of the order. Insofar as the petitioner is concerned, unless situation warrants, the court specifically directs is exempted from appearance before the concerned court. Ordered accordingly. The aforesaid observations, petition stands disposed. Next.
Much obliged.
9.
Notice complainant. Yes, next.
10.
Come to page 29, sir.
Charge sheet has been filed.
Correct. ಅದನ್ನೇ ನೋಡಿ ಎಂದಿರೋದು. See page 29. We have to file discharge actually. No question of interference.
Charge, my lord, there is a warrant also, my lord.
Very good.
Summons are issued.
Very good, sir.
So direct might be given, my lord.
No, sir. No question of challenge in this.
My lord, the complaint version is totally fabricated, my lord.
That is a matter of evidence because allegations are grave.
Lord, there is no witness, my lord.
That is before the court, sir, where I can see here.
My lord.
File discharge.
The allegation of attempt of rape is also, my lord. It's
correct, sir. Allegations are horrible.
The court may be given direction, my lord.
For what, sir?
For appearance of the accused.
No, sir. You appear. You have been absconding as well. Yes.
It may be stayed, my lord.
No, sir. File discharge. Yes. Discharge format. Next.
11.
Emergent notice, ma'am.
Huh?
Notice may be given, my lord.
No notice, sir. Not a case for notice also. Yes. 67B, horrible. Yes.
Charge sheet is ready, Your Lordship. Will be filed.
Please file it. Yes. No representation by the petitioner. This is a matter where she should be tried. Yes. No representation. List on 8th. Fresh matters. Ashtal charge sheet haksiri. Yes.
12.
A 122. Notice.
13.
20%.
Please, my lord.
Yavak, when will you pay?
My lord, due to poor financial conditions, I'm not
IUN
able to.
can't tell. Financial statute will not, does not recognize financial conditions. When will you pay?
I'll seek instructions.
Secure instruction. Monday fresh matters. Otherwise, I'll dismiss it. Yes.
14.
Pass over.
Passport release application. Your Lordship, charge sheet is filed and CC is awaited, Your Lordship. CC.
That's all right. Seeking passport. That can't be. Wait. List on Monday fresh matters. Ask Jagdish to come. Yes.
Great.
Additional SPP B and Jagdish is directed to accept notice for the respondent. Next.
15.
Complainant notice.
16.
What sort of the order? TCR reject ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ, they have rejected the memo. I have sought for
ಗೊತ್ತಾಯ್ತು. TCR, yes.
stay maybe.
Notice, emergent notice to the respondent. There shall be an interim order of stay of further proceedings in the appeal number.
Appeal 1090 of 2023.
And so and so.
1090 of 2020.
Pending before so and so. Next, till the next date of hearing.
17.
Your Lordship, kindly appreciate again, there is a lacuna from the police where the complaint been registered. I mean to say complaint filed on 7/9/2023. If that is the case, she is in the hospital, that discloses discharge summary. That is one point, Your Lordship. Another point is this, Your Lordship, where there is no offences as if they found in the charge sheet, but they have made an investigation, Your Lordship. That is also, there is a lacuna in that, Your Lordship. And moreover, all the documents which says that
498 ಅಲ್ವಾ?
498 yes for me.
71 ನೋಡಿ. ಎಲ್ಲರ ಬಗ್ಗೆನೂ ಗುಣಗಾನ ಇದೆ.
ಅದರಲ್ಲಿ
Allegations against all. Husband, mother-in-law and father-in-law.
ಇದೆ ಇದರಲ್ಲಿ.
ಇದೆ ಅಲ್ವಾ?
ಇದೆ. ಇದರಲ್ಲಿ ಹೇಗಾಗಿದೆ 7/9/2023 ನಲ್ಲಿ
HCGP to emergent
occurred ಆಗಿದೆ ಅಂತ
No
ಅಂತಾರೆ.
problem.
But 8/9/2023 ನಲ್ಲಿ she was in the hospital. 7 discharge summary disclosed. Your Lordship, kindly peruse the page. Humble request, page kindly peruse the page number 102.
Notice, I have not dismissed it. Notice. No state. No.
It's a fit.
No, please, no, please. Yes.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ kindly peruse the page number 102.
Yes.
102.
You have tortured
Discharge summary is very clear.
tortured the daughter-in-law. No. Yes.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಕ್ಲೀನ್ ಆಗಿ ಹೇಳುತ್ತೆ.
ಪರವಾಗಿಲ್ಲ.
Discharge summary, discharge.
ಬರ್ಲಿ ಅವ್ರು.
So ಒಂದೇ ಒಂದು
One
discharge summary 102, 103 ನೋಡಿದ್ರೆ it is clear. She was in the hospital when the allegations made. She was in the hospital.
No
7.
problem. No problem.
ಅಲ್ಲ 7/9 ಅಲ್ಲಿ ನಾನು ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದೀನಿ ಅಂತ
Then it's a matter of evidence. You filed discharge, sir. You filed discharge. It's a matter of evidence. I will not interfere under 482 at all.
ಇದರಲ್ಲಿ
Yes. Dismissed. Yes, next.
ಲಿಬರ್ಟಿ ಮೇ ಬಿ ಗಿವನ್ ಅಟ್ ಲೀಸ್ಟ್.
For what, sir?
ಅಟ್ ಲೀಸ್ಟ್ ಒಂದು ಸ್ಟೇ ಕೊಟ್ರೆ ಏನಾದ್ರು.
At least one stay. No.
There is no fault, no any kind of
nothing.
blood injuries.
Notice ಮಾಡ್ತೀನಿ. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರಿತೀನಿ. ತೊಂದರೆನೇ ಇಲ್ಲ.
ಸ್ಟೇ
ಒಂದು ಸ್ಟೇ ಇಲ್ಲ, ಎರಡು ಸ್ಟೇ. Yes.
They are innocents actually.
Oh, who will say I'm guilty?
No. By perusing their records,
One
police records.
One HCGP to emergent notice. Next.
18.
Publish.
ನಾನು ಕಾಂಟ್ರಾಕ್ಟರ್ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಬಂದು
Correct,
ಅವ್ರಿಗೆ
sir.
ಮನೆ
In the
ಕಟ್ಕೊಟ್ಟಿದ್ದೀನಿ.
meantime, sir.
19.
States, sir. Yes. Same order.
For the petitioner.
Give it. Tag along with so and so, same order. Next.
20.
For petitioner, my lord.
Huh?
For petitioner, my lord.
ಆಮೇಲೆ.
Yes, my lord. Petitioners are the accused number 7 and 8 in the.
After that.
Yes, my lord. My
Loan
lord.
fraud bank.
We are for bank.
One HCGP to emergent notice. Next.
21.
One HCGP, there shall be an interim order of stay only insofar as the accused number 2 is concerned. Insofar as accused number 1, husband, the proceeding shall continue. Yes, next.
22.
A3.
Yes.
ಏನಿಲ್ವಾ?
A1 ಗೆ partly allowed ಆಗಿದೆ ಸ್ವಾಮಿ.
Very good, sir. Go to page 45. A3 ಬಗ್ಗೆ ಏನೇನಿದೆ ಎಲ್ಲ ಇದೆ ಅದರಲ್ಲಿ.
A3 ಅಂತ ಹೇಳಿದ್ರೆ 2 and 4 ಜೊತೆ ಹೋಗಿ ಅಮೌಂಟ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಮ್ಗೆ ಯಾವುದೇ ಅಮೌಂಟ್ ರಿಸೀವ್ ಆಗಿಲ್ಲ.
It's a matter of evidence. File discharge. I am not going to interfere. Yes, discharge. Next.
23.
Srinivas sir, husband gilla. 2 I'll grant. Let the wife come. The petitioner is before the court calling in question so and so. 1 no. 1 will be considered after the appearance of the wife. 2 interim order. Yes.
24.
Emergent notice to the respondent. There shall be an interim order of stay. Qua. Respondents 2, 3 and 4 before the concerned court initiated by the respondent wife under the Domestic Violence Act. It's made clear no stay is granted in favor of accused number of respondent number 1, the husband. Yes, next.
25.
Surface proceedings initiate madidara?
They initiated the proceedings as against the accused number 2 and 3.
In the meantime, next.
26.
Case and counter case.
Is accused number 3 a lot?
Notice, yes. Earlier, please. 1 HCGP 2 emergent notice. 27.
7.
In the meantime, next.
28.
420 offense.
Rent dispute.
ಅದು
Who's receiving the rent?
The petitioner is not receiving the rent. In fact, in the page 160 A3
In the
rental
meantime,
agreements.
next. State.
29.
Andar bar.
For petitioner, my lord. KPI.
There is a judgment. Andar bar.
ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ covered matter?
ಕವರ್ಡ್ ಮ್ಯಾಟರ್ ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ.
ಎಲ್ಲ ಪೇಜ್ ಹೇಳಿ.
ಪೇಜ್ annexure D 49.
ಅಂದರ್ ಬಾರ್ SJK. Yes, next.
ಸ್ವಾಮಿ ನಿಮ್ದೇ ಇದರಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಕೂಡ ಅಲೋ ಆಗಿದೆ ಸ್ವಾಮಿ ನೀವಿದ್ದಾಗ.
ನಾನು ಈಗ ಅಲೋ ಮಾಡಿದೆ ಸರ್. ಆಯ್ತು.
ಮಚ್ಚು.
ನಿಮ್ಮ ಹೆಸರೇನು?
ತ್ರಿಶೂಲ್ TMR.
TMR ಏನು TMR ಅಂದ್ರೆ? ಯಾವ್ದೋ ಪೊಲಿಟಿಕಲ್ ಪಾರ್ಟಿ ನೇಮ್ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? TMR ಅಂದ್ರೆ ಏನು?
ತ್ರಿಶೂಲ್ MR.
ಬರ್ಕೊಳ್ಳಿ. ಎಸ್.
ಮಚ್ಚು.
Sorry, my lord, my matter was 27th matter, my lord.
I have stayed it, madam.
Machu.
30.
85. Petitioner is accused number 2 in the meantime. Next.
31.
The bank is the complainant. Petitioner is accused number 4. A perusal at the summary of the charge sheet would not indicate any specific acts of the petitioner that could become the ingredients of the offences. All the allegations are against accused number 1 to 3. Petitioner is has only received the brokerage for introduction of the clients to the bank. A transaction having gone wrong later cannot lead the petitioner to into the web of proceedings. Therefore, there shall be an interim order stay. 1 HCGP 2 emergent notes. Next.
32.
Lordship, the petitioner here
Correct.
is
Page
accused
29
number.
ಅಲ್ಲಿ A3 ಗೆ ಏನ್ ಮಾಡಿದ್ದೀರಾ ಅಂತಿದೆ. ಅಡ್ವೊಕೇಟ್ ಆಗಿರ್ಬೇಕು ತಾನೆ ಸುಮ್ಮನೆ.
Lordship, so the Lordship is a clear case where the girl has fallen in love and she's eloped and she's married, your Lordships. Lordships, if I may, I apologize. I'm requesting you to look at page number 95 of the petition, your Lordships. The pictures are very clear that they were in love and then she has eloped with him and got married, your Lordships. When the father came to know about this, he filed the complaint, and to save the honor of their family, this proceedings been
In the
initiated.
meantime,
your
the
Lordship.
petitioner accused number 3.
Grateful.
Yes.
33.
Petitioner is.
Why did you go and destroy?
No, nothing of that sort we did, my lord.
Who is in possession?
They are in possession of the property.
then?
In fact, we are the ones who sold the property to them.
Correct.
They are constructing an apartment. My lord, we only ask them to, make sure that the debris all fall within their premises. And, my lord, in the complaint, they claim that there is CCTV footage. Nothing has been produced
No,
in the
that
evidence.
CCTV footage is not there.
It's not?
CCTV footage is not there at all.
No, they haven't
Is
produced.
what I'm telling, there is no CCTV footage of the incident. It is
In complaint, they have mentioned, in police complaint, they claim that we have CCTV camera photographs and.
In the meantime, next. Notice, one HCGP to emergent notice, husband.
Petitioner, my lords.
Hmm.
504 and 506, my lords.
504, 506.
Has been filed.
30?
35.
Hmm.
Because the dispute is between the family members. There is one.
You
party-
file a private complaint first.
First, I'll file a complaint, private complaint.
The petitioner is before the petitioners are before the court calling in questions so and so. The petitioners invoke section 200 of the CRPC and register a private complaint on 29/7/2025, 223 of the BNSS, and register a private complaint. On coming to know of the registration of the private complaint, the impugned crime is registered on 14/8/2025 as a counterblast to the proceeding to the complaint registered by the petitioner. Therefore, there shall be an interim order of stay of investigation.
Charge sheet.
Proceedings, yes.
36.
This case, my lord.
306. 108.
108, my lord. Insofar as, my lord, the allegation against me is concerned, that I have, my lord, given pressure to one Nagendra. Nagendra has given to them. And, my lord, kindly for a moment, turn ink page number 24 for a moment.
Investigation complete agilla line.
Investigation complete agilla. Adre,
get the papers. Get the investigation papers. List the matter on Tuesday in the fresh matters, 9th Tuesday in the fresh matters list. The HCGP shall secure the investigation papers and place it before the court on the next date. We'll see on that.
37.
Lord, kindly pass over, my lord.
Panchayat is the complainant. ಯಾಕೆ ಗಲಾಟೆ ಮಾಡಿದಿರ ಹೋಗಿ ಎನಿವೆ ಪಾಸ್ ಓವರ್ ಇಲ್ಲ ಟುಮಾರೋ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
38.
wound certificate ಇದೆಯಾ?
Wound certificate, it's part of the
charge sheet. Is there a wound certificate?
Samanya, sir.
Huh?
As per charge sheet, my lordship, simple injuries.
Simple injuries.
In the meantime, yes, next, please.
39.
In the meantime, next.
40.
40.
Twitter in the.
ಯಾಕೆ ಸುಮ್ಮನೆ ಇರಕ್ಕಾಗಲ್ವಾ?
My lordship, in this special PP will appear.
ಯಾರು special PP?
Anyone will.
Anyone? There are so many, is it?
4.
Ask 2 weeks bit appear ಕೇಳಿ. List the matter on 15th in the fresh matters list. Further proceedings shall remain state till the next date.
41.
85, 2 and 3. Yes, next.
42.
In the meantime.
43.
For petitioners, my lord.
376, sir.
Yes, my lord. 376 and 420, my lord.
Hmm.
The complaint is a married woman, my lord. She is having 2 children. During the subsisting of marriage, she is making an allegation of false promise of marriage, my lord. And
ಎಷ್ಟು ವರ್ಷ?
Sorry, my lord.
Relationship ಎಷ್ಟು ವರ್ಷ?
My lord, it is not a case of relationship, my lord. It is a case of business relationship, my lord.
Business relationship?
Yes, my lord. In this regard, she has transferred around.
Then business with benefits, sir.
No, my lord. There is no single material to show that I am in a.
To marry, amount also has been taken.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀರಾ?
Around 45 lakhs I have received.
ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
My lord, out of 45 lakhs, I have transferred around 25 lakhs.
Another 20 lakhs, when do you pay?
It has been frozen. She cannot prove the 1 crore what she stated in the complaint. That's the reason account has been frozen, my lord. In my account still there is a 25 lakh, my lord.
Will direct to be released in her favor.
If she proves, my lord, let her
no
get released, madam.
376 consciential acts you can have, but no assault, no financial transactions, all that I will not
Yes, my lord,
permit.
But I have returned the amount, my lord.
No, let the complainant come. One HCGP 2 emergent notice returnable by the 1st of July.
Lord,
List on 1st of July.
376 will not attract, my lord. 376 will not attract. Against the petitioner number 2 is the father, my lord. He is suffering from
There shall
tuberculosis.
be an interim order of stay only insofar as the second petitioner is concerned.
My lord, charge for it is posted for charge, my lord. 16th, my lord.
Don't worry. You are before the court, we will see. Yes. Next.
Any date may be fixed, my lord.
ಹೇಳದ್ನಲ್ಲ, 1st July.
Please, my lord.
44.
85, 2 and 3, 1 ಗಿಲ್ಲ. Yes.
ಅಲ್ಲ ಸರ್ ಇದು 5 ವರ್ಷ ಆದ್ಮೇಲೆ
ಪರವಾಗಿಲ್ಲ ಬರ್ಲಿ, ವೈಫ್ ಬರ್ಲಿ. ಎಸ್. Accused number 1 is the husband. No, stay.
45.
May please. After 10 years of the.
Seriously. Heard the learned senior counsel PP Hegde appearing for the petitioner. The incident struck the agreement between the parties is 2015, alleging certain, bringing up allegations on the basis of the agreement. The complaint is registered in the year 2025 without any speck of explanation for delay. Therefore, permitting further proceedings against these petitioners would run foul of the judgment of the apex court in the case of Chanchalapati Das versus State of West Bengal, 2023 SEC Online SC page 650. Therefore, there shall be sounds.
Great.
46.
231 application, my lords. Seeking cross examination.
List, ಗೊತ್ತಾಯ್ತು. Learned additional SPP B and Jagdish directed to accept notice. There shall be an interim order of stay of further proceedings before the concerned court. List the matter on 10th in the fresh matters list.
Obliged.
We'll dispose it on that day.
47.
NBW.
The proclamation has been issued, so I may be permitted to appear before the court.
Correct. Yavaga.
Fifth, nadide ide. Right.
Petition, what is called in question is an order of proclamation that hangs on the head of the petitioner. The learned counsel submits that there is procedural aberration in drawing up the proclamation against the petitioner, be that as it may. The learned counsel submits that the matter is listed before the concerned court day after tomorrow date. Therefore, the petitioner shall appear before the court on the next date of listing, i.e. date. Subject to the said condition, the proclamation stands suspended. In the event the petitioner would not appear before the court, the concerned court shall take further steps qua the proclamation. Therefore, said observation petition stands disposed. Next. Same. 48 OS 100 of 26.
Yes, madam. Stay.
ಇದೆಯಾ?
ಅದರಲ್ಲಿ 100 ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆ ಮೇಡಂ. OS ಅಲ್ಲಿ ಸ್ಟೇ is granted.
ಗೊತ್ತಾಯ್ತು. OS ಅಲ್ಲಿ ಸ್ಟೇ ಇದ್ರೆ ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಕೊಡ್ಬೇಕಾ?
After granting stay.
What after granting stay? The petitioner institutes OS 100 of 2026 in which an temporary injunction is granted answering the application of Order 39 Rule 1 of the CPC. Immediately thereafter springs the impugned complaint by the complainant. Therefore, there shall be an interim order of stay of further investigation qua these petitioners to the next date of hearing. 49 same.
49.
Same, yes. Gaurav 7A. Is the
additional charge sheet. In the additional charge sheet, he is implicated.
Okay, yes. The petitioner shall serve on BB Patil counsel appearing for the Lokayukta with requisite set of papers. List on 10th in the fresh matters list. So, complainant ilva? Idare? Nodu. Serve ಮಾಡಿ. Yes.
51.
Accused number 12.
He's the manager of the bank.
Correct. Page 83, 84 I have marked a portion. The allegation against the petitioner is as quoted herein above. He is the manager of the bank. Except the role of the petitioner being the manager of the bank, there is nothing that can be alleged against him that could become the ingredients of the offences. In that light, there shall be an interim order of stay of so and so till the next date of hearing. 1 HCGB to emergent notes. Next.
52.
B report reversed.
Similar complaint.
ಗೊತ್ತಾಯ್ತು. In the meantime, stayed. Next. 1 HCGB to emergent notice in the meantime. Yes.
53.
Pass over.
ನಾವು ಬರ್ತಾ ಇದೀವಿ, ನಮ್ಮ ಮಧ್ಯಾಹ್ನ ಹಾಕೊಂತೀರಾ
Next.
ಕೊಡ್ತೀರಾ?
53 in the meantime. Next.
54.
Petition 498. Tahirale. Husband accused number 1 igilla. Husband no. A2 and A3 stayed.
Any case is that sister, married sister and brother only made a.
Let the wife come. I'll grant.
Obvious.
Yes. Ottu 13% stayed. Yes.
55.
55 ಈಗ ಹೇಳಿದ್ ತಾಹಿರ್ದು 498. ಅದು ಮೇಡಮ್ 13% in the meantime. 55 ತಾಹಿರ್ದು 498. Yes. Next.
56.
simple in nature, page 60.
Case is simple in nature, then we will not grant interim order.
Leave to your lordship. Lord. There are some senior citizens, he has encroached the road.
The allegation against the petitioners are found, page 48 al mark madidi. So and so. There is, except making omnibus statements against these petitioners, there is nothing of specific overtax that are alleged. In that light, there shall be an interim order.
So great.
Stay. Yes.
57.
126 BNSS.
Yes. Preventive detention order, my lords, a quarrel between my lords in respect of a temple. My lords, so therefore, my lords, the proceedings are initiated, my lords, so let him execute to execute a bond, my lords, to
Yen beda.
maintain the peace, my lords.
Yen beda.
Please.
All right. Yes.
Please.
Learned HCGP is directed to accept notice for the respondent. We'll take it on Monday.
Please.
Rest on Monday, fresh matters. Next.
58.
Petition. Tashil.
Reference order really. Page.
My lords, annexure A, page number.
One nimisham kodi madam. Okay,
My lords, annexure for B, page number 42, my lords. 43 is the.
Non-application mind idರಲ್ಲಿ thesis ಬರಿಬೇಕಾ?
No, my lords,
ಮತ್ತೆ?
what happened is this, my lords. The Tashildar has granted, my lords, family tree first initially. Subsequent to that, my lord, same has been challenged before the AC. And
No,
AC
your
reminded
ground
that-
is that non-application mind. ಆ ground ಮೇಲೆ ಬನ್ನಿ. As a counter blast to arm twist ಮಾಡಿದ್ದಾರೆ. In the meantime. Next.
And C number 65 also same in the, much.
Petitioner in this case.
659 364A.
Okay. But our putiro idರಲ್ಲಿ the entire story, entirely it is imaginary only.
ಅಯ್ಯೋ
The
ತೊಂದರೆ
reason-
ಇಲ್ಲ ಸರ್.
No, the thing is.
One HCGP, 2 emergent notice. Yes.
It can be seen.
No, no.
The
Dismiss ಮಾಡಬೇಕಾಗಿರೋ ಕೇಸ್. Yes.
60.
For the petitioner, my lords, offense under 352.
In the meantime, 504. Yes.
51.
The complainant is, the learned heard the petitioners before this court calling in question so and so. The learned counsel for the complainant taking this court through the documents appended to the petition would seek to demonstrate that the complainant is in the habit of registering several cases against these petitioners. One such is OS 6768 of 2022. And on the same set of facts springs the impugned complaint against these petitioners. In that light, there shall be an interim order of stay for the proceedings so on till next date of hearing. One HCGP, 2 emergent notice. Next.
62.
Husband DNA rejected. Emergent notice to the respondent. Next.
63.
1 illa, 2, 3, 4, 5 stayed. Husband no stay. Yes, next.
64.
Similar to the matter yesterday, dispute between society and the very same developer. And my lords, we file a suit against.
If I don't permit you to argue, you will feel bad, is it?
But I don't know whether
You'll feel bad.
briefing council may feel bad, my lords.
Just to speed up the process ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ಹೇಳಿ.
My lords, the society, my lords, they had a developer who was to develop the land and then the allotment to take place. Developer does not develop it. Suit is filed against him for specific performance. He sets up the complainants who say that we have paid certain amount for allotment of land. That is a complaint. 3 FIRs that were registered, my lords. We registered the first FIR. They challenge it. There's an order of stay, my lords, in which vacating stay has been filed. They file another FIR, 3rd FIR, my lords. And matter is pending before the civil court. It has been
What happened
pending-
to the other 2 FIRs?
My lords, one is stayed by this honorable court. The one which we gave against them, my lords.
Oh, that is stayed, is it?
Stayed, my lords.
Yes, ಕೊಡಿ ಅದು.
ಅದೊಂದು ಕೊಡ್ತೀರಾ number? We'll just pass it on.
Heard the learned senior counsel Sandesh Chowta appearing for the petitioner. The learned senior counsel submits that in an issue that is purely civil in nature or breach of agreements, the crimes have been registered either by the petitioner, crimes have been registered against the petitioners. One such crime, one crime is also registered against the present complainant, which is stayed at the hands of this court in criminal petitions so and so. Even otherwise, the permitting further investigation proceedings.
Investigation.
Further investigation in the case at hand would become an abuse of the process of the law, albeit prima facie. Therefore, there shall be an interim order of stay of all investigation, pay these petitioners to the next date of hearing, tag along with so on.
It's one request could I do that DA cases, my lords, the judgment which is released by
Kodi,
the
I
court date
wanted,
with
yes,
dot.
yes.
I mean,
Then we'll post everything.
yes, my lords, once if it is posted, because my lord says certain matters reserved it for judgment, but if this is seen, my lords, a
I'll
lot of
see,
things
yes.
should.
ಆಮೇಲೆ ಯಾವುದು ಒಂದು ಲಿಸ್ಟ್ ಏನಾರು ಇದ್ರೆ ನಿಮ್ಮ ನೀವೆಲ್ಲ ಅಪೇರ್ ಆಗ್ತಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೌ ವಿ ಡಿಡ್ ಆತರ ಇಫ್ ಯು
Please,
ಡೂ ಅಂದ್ರೆ ವಿಲ್ ಫಿಕ್ಸ್ ಅ ಡೇಟ್ ಅಂಡ್ ಹಿಯರ್ ಇಟ್ ಅಂಡ್
Court date bench took the view, my lords, those two issues were open, whether, my lords, the desirability of having P. That has been, and application of mind so far as the order under 17. Both the issues are covered and all the judgments, my lords, are all quoted. All the ones.
Perfect. Then I'll post everything on one day.
Please, my lords, finish.
On the one day we'll make a DE day. A DA day.
I think this would make it easier now,
Yes,
my
yes,
lords.
yes.
Deeply obliged.
ಎಲ್ಲಾದ್ರಲ್ಲಿ ನೀವೇ ಅಪೇರ್ ಆಗ್ತಿರಲ್ವಾ?
Illa, my lords, various councils are there.
No, you ನಿಮ್ದು ಯಾವ್ದಿದೆ ಹೇಳಿ.
How?
You lead the bandwagon.
Please.
Then we'll do.
Please.
Yes.
Obliged.
Yes.
55.
This revenue inspector, my lords, in 58.
In the meantime, yes.
it
Same
connected
58 ಜೊತೆ ಕನೆಕ್ಟ್ ಮಾಡಿ.
Much.
56.
Meantime, next.
57.
85, 2, 3 and 4 stayed, husband, no, yes.
My lord, one submission, my lord.
Husband ga?
Insofar as the husband also.
Yes.
Page number 109 and 123 of the petition.
no.
My lord, the allegation is that we have administered tablet store forcibly to cause miscarriage. ಅಂತ.
Petition dismiss ಮಾಡಕ್ಕೆ ಅಷ್ಟು ಸಾಕು. Anything else?
ಅಲ್ಲ, my lord.
I'm issuing notice, fortunate.
My lord, for the husband, just one
No,
submission.
no, sir. Nothing. ಈ ಇದ್ರಲ್ಲಿ husband stay ಕೊಟ್ರೆ ಅಷ್ಟೇ. Yes.
Kindly, my lord.
Next.
58.
85, 2 and 3.
Please.
Yes, take a full person.
59.
Check. Offense under 75, 78 and 351. My lord, the only submission is the offense has not happened. It is only because
It has
of.
not happened,
It
definitely.
has not happened.
One HCGP heard the Grand Counsel Madhu and Rao appearing for the petitioner. A perusal at the complaint would clearly indicate that clearly indicate or generate a doubt of the happening of the offense itself, as the complaint is so worded, they albeit prima facie. Therefore, there shall be an interim order of stay of further investigation.
My lord, one submission.
Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
Investigation.
ಇಲ್ಲ, ಇಲ್ಲ,
Further investigation. Yeah.
One submission. I request the CCTV to be safeguarded.
Saved?
No, safeguarded. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ, in case eventuality.
Will direct. There shall be an interim order of stay of further investigation. In case the investigating officer has collected the CCTV footage or its transcript, the same shall be preserved to be placed before the court. Next.
70.
Additional charge sheet ಏನ್ ತೊಂದ್ರೆ?
Additional.
ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕಾ?
No additional.
ಮತ್ತೆ?
Only one charge sheet, sanction order.
Sanction ಇಲ್ವಾ?
Sanction ಇದೆ, but for different offenses, page 110. No additional charge sheet at all. 110, my lords, is the charge. For co-accused, my lords, the proceedings are terminated.
1 minute.
Yes.
Come to page 14, para 2.13.
Yes. Yes, ma'am. 2.1. Let's, so the investigating would amended sanction order before the learned and seek permission to file additional charge sheet. Yes, my lord.
ಇಲ್ಲ ಅಂದ್ರೆ?
ಅಲ್ಲ, additional charge sheet permission ಕೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, same day it is granted, additional charge sheet is filed, a copy is not available, made available to the petitioner.
Available.
Additional charge sheet ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ?
ಅಲ್ಲ, but for the original charge sheet.
Whatever, additional charge sheet ಹಾಕಿದಾರೋ ಇಲ್ವೋ?
Additional charge sheet ಹಾಕಿದ್ದಾರೆ, copy of which is not given to us.
Co-accused ಯಾವ್ದು? ಅದು ಕೊಡಿ.
Let's annexure H, page number 106.
ಸೂರತ್ ಸಾಹೇಬ್ರದಾ?
Yes.
ವಾಶ್ ಆಗಿದೆಯಾ?
ವಾಶ್ ಆಗಿದೆ.
ಯಾಕೆ?
Because would your lordships come to page number 110, 110.
Sanction is withdrawn?
Mallet?
Sanction order is withdrawn?
No, my lord, sanction order is not withdrawn. Well, it's page 110, can I
Sir,
just?
page 108, it is quashed on the ground that sanction order is withdrawn.
Well, it's the sanction order there, my lord, was given for different offences other than the charge sheet. Then they said we'll issue a fresh sanction order. Fresh sanction order is issued, which is also challenged. Annexure G, even
Page.
page 110, I've made a chart explaining 110. Offences for sanction was originally granted for 120, 201 and 34, my lord. Charge sheet was filed for 408, for which sanction was not taken. Therefore, cognizance order, my lords, at annexure F for 408 and 34 was bad. Then, my lords, 11, 12, 25, fresh order of sanction for offence under 34, but charge sheet is for 37.
Who has granted sanction? Government.
Government.
And additional SPP, B. N. Jagdish, is directed to accept notice for the respondents. First, second respondent.
Commission.
Second respondent, both the respondents, to explain the allegation of sanction being granted to one offence and the charge being of the other offence on the next date. List on Friday and Monday.
Monday.
Monday, fresh matters. Yes. Avat noduva.
71,
175(3) violation. Yes, in the meantime, next.
72,
Charge sheet has been filed, my lord.
Charge sheet format, next. Withdrawal, in terms of withdrawal, yes. Sachin,
73,
73. And for the petitioner, my lords. MMRD Act, my lords. The learned magistrate has taken cognizance, my lords. It has to be taken by the special court, my lords. I furnished the judgment of this high court, my lords, in 2 judgments, my lords.
Jagdish sir. Curable defect.
No, it's correct, man. Cognizance is correct.
Anything else, sir?
It is wrong.
Vivek judgment is, Vivek, you're relying on Vivek judgment.
Yes, my lords.
No, that is withdrawn, recalled by the judge himself.
No, my lords. High court judgment here, my lords.
Ayo, High Court has released.
Judgment which has been recalled.
Yes, that is recalled, sir.
My lords,
That is recalled by the very judge.
No, my lord, Justice Paninda and Justice.
ಅವರೇ ಸರ್ ರೀಕಾಲ್ ಮಾಡಿದ್ದಾರೆ ಒಂದು ತಿಂಗಳು ಬಿಟ್ಟು ಅದನ್ನ ನೋಡಿಲ್ವಾ ನೀವು ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ.
My lords, on merits also, my lords.
ಆನ್
Allegation-
ಮೆರಿಟ್ಸ್ ಏನು ಇಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಅಲಿಗೇಷನ್ ಏನಂದ್ರೆ 3 ತಿಂಗಳಾದ್ಮೇಲೆ CCTV ಫುಟೇಜ್ ನೋಡಿದಾಗ ಈ ಟ್ರಕ್ ಪಾಸ್ ಆಗಿದ್ ಗೊತ್ತಾಗಿದೆ ಅಂತ. ರಿಕವರಿ ಏನಿಲ್ಲ ಸರ್.
Let's see.
There is no recovery at all.
The learned additional SPP is directed to accept notice for the respondent. Secure instructions, make submission 17th. Next.
Both the respondents are.
Both the respondents, correct.
Appear for the petitioner. Lord's first complaint.
What's your name?
Aniket.
Heard the learned counsel Aniket appearing for the petitioner. The parties to the list are before the civil court in 2 proceedings, OS 182 of 2025 and 183 of 2025 on the same set of facts has sprung the impugned complaint. In that light, the issue being purely civil in nature is dressed with the color of crime, therefore. So it's both same. Please.
My lords may tag that.
Huh?
Tag matter.
ಎರಡು ಟ್ಯಾಗ್ ಮಾಡಿ ಒಂದೇ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡಿ.
75.
ಅಲ್ವಾ? Yes.
This number 2, being spoken to.
Rajat, ಯಾಕೆ being spoken to?
Instead of withdrawing, my lords, 9237 erroneously withdrew 7237. But both the parties are same in 7237, 9237.
ಈಗೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
Lords may kindly, my lords, recall the order and restore it on the file, please.
The petition was disposed as withdrawn on a memo being filed. The memo had a typographical error. The error was with mentioning the criminal petition number, which ought to have been
9237.
9237 of 2025, but 7237 is mentioned. In that light, the order dated so and so stands recalled. The petition is restored to file, lest the matter next Tuesday.
Please, the interim order.
Interim order subsisting at the time of disposal shall continue till the next date of hearing.
Okay.
Next. 21 ವರ್ಷ ಆಗಿದೆ, ಏನಿದೆ ಇನ್ನು ಏನ್ ಧರ್ಣೇಶ್? 21 ವರ್ಷ ಆಗಿದೆ. We will not permit further proceedings in this. One additional SPP.
ಅಲ್ಲ ನಾವಿಲ್ಲ.
ನೀವಿಲ್ವಾ? Sorry, emergent notice to the respondent, there shall be an interim order of stay of all for the proceedings before the concerned court till the next date of hearing. ಇದನ್ನ ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
Please, madam.
ಇನ್ನು 30 ವರ್ಷ ಆದ್ರೆ ಮುಗಿಯಲ್ಲ ಇದು.
Please, madam.
Yes.
Because the chief examination after 21 years, my lord. Further chief examination, even after 5 years, they are not.
1000 is the complaint.
Yes, yes. My lord, this punishment, your lordship has to pass some guidelines in this regard, my lord. Because, my lord, 25 years go to the court is more than the punishment what is prescribed in the law for the said offences.
21 ವರ್ಷ 2000 complaint.
26 years, my lord.
2020 is the complaint. 2025 cross examination in chief ಕರೀತು. What is this? 25 years. Yes, we'll see.
Please, please.
And ಏನು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇದು? ಯಾವುದು? ಐ ಬೆಂಗಳೂರೇ ಇಲ್ಲ.
And complainant is not there, my lord, and the accused number 1 is also not there. Both are.
ಕೋರ್ಟ್ ಮಾತ್ರ ಇದೆ, ಕೇಸ್ ಮಾತ್ರ ಇದೆ.
Yes.
Yes.
Please.
Number 3.
Charge sheet is filed in this case.
Charge sheet format.
4.
In the meantime.
5.
ಇಲ್ಲ 4 ಅಲ್ಲೂ charge sheet has been filed.
4 ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರ? 3 ಏನು?
Your lordship, I think this is a
After
case.
we filed the petition.
ಅಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡಿ. It's a matter to be stayed, but charge sheet ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ I will say stayed.
My lord, kindly stay any further proceedings, my lord. I will.
ಆಯ್ತು, you amend it if you want.
I'll amend it, my lord.
You amend it. You amendment ಬಂದಾಗ we will grant order. You should get to know what the court is saying. Challenge the charge sheet, move it immediately, we'll grant it. It is a matter to be stayed.
I think your lordship may lay down something in this case.
No, this is terrible.
Yes.
ಏನು misuse of criminal law, ನಿಮ್ದಲ್ಲ ಅವ್ರದ್ದು.
Thank you, my lord. My lord, in fact, she was dragged to the police station
All
early
right.
morning.
All that we will answer. You challenge the charge sheet, I will lay down something in this.
My lord, if it may be, if I may be heard tomorrow itself, I'll move the matter
ನೀವು
today
ಮಾಡಿ,
itself, my lord.
ನೀವು charge sheet challenge ಮಾಡಿ ಮೂವ್ ಮಾಡಿ ಮೇಡಮ್, 2:30 ಗೆ ತಗೊಂತೀನಿ.
Grateful, my lord.
Yes.
Great.
3 notice. One additional
ಅಲ್ಲ
SPP
3
to
charge sheet is filed.
3 ಅಲ್ಲಿ charge sheet ಆಗಿದೆಯಾ?
3 ಅಲ್ಲಿ charge sheet ಆಗಿದೆ. 4 ಅಲ್ಲೂ charge sheet ಆಗಿದೆ.
Serial number 3.
ಚಾಲೆಂಜ್ ಮಾಡಿ charge sheet.
Serial number 3 charge sheet ಆಗಿಲ್ಲ.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನಂಬರ್ ಬೇಕಾದ್ರೆ ಕೊಡ್ತಾರೆ. ಟೆಲಿಫೋನ್ ನಂಬರ್ ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ನಂಬರ್. ಎಸ್.
5 also charge sheet is filed.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
Yes, my lords. My lords, the entire premise.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಸರ್, ಮಾಡೋಣ.
My lords.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಲ್ವಾ? ಎಸ್.
6.
Speaker.
302.
Please, madam.
ಯಾರು acquit ಆಗಿದ್ದಾರೆ?
Petitioner is A8, my lord. Acquittal A1, 3, 5, 7 and 12 was came to be acquitted, my lord. Page number 33 is the acquittal, in which A6 also approached before this honorable court.
The petitioner is before, we'll close it, Jagdish. The petitioner is before the court, calling in question proceedings in continuance of proceedings in SC 98 of 2022, registered for offences punishable under so and so. The petitioner, accused number 8, gets embroiled in a crime number 31 of 2012 for several offences. Along the other accused who are available for trial are tried and are acquitted. The petitioner who was not available for trial at the relevant point in time is now sought to be proceeded against on the same set of facts. The other accused who are not available for trial were also before the court, and the coordinate bench has quashed the proceedings on the score that quashed the proceedings as it was a split case against the petitioner there in the court Marvudi. Yes, sir. Quashed.
Obliged.
7.
Lord, I appeal on behalf of the petitioner, Lord, a complete misuse of the provisions of the criminal law. Repeatedly, my lord, we have had these proceedings and we have had to come to court. And there is an order not passed by the single judge of this court, upholding the grant in my favor, confirmed by the division bench, and now not on the same basis, FIR is not, I am not named in the FIR, the charge sheet I am named.
Where are the orders of the learned single judge and division bench?
My lord, the order of the learned single judge, my lord, you also will find is at page 169. 156, my lord, it begins, and your lordship may kindly see, my lord, the para 3 at page 158. The same grant order of 26/12/1975, which was sought to be recalled, was questioned. And during the pendency of the writ petition, my lord, the grant was sought to be cancelled. And the learned single judge, my lord, after considering all that says, both the show cause notice and the order is quashed. And the division bench, the state prefers an appeal dismissed.
Heard the learned senior counsel KG Raghavan appearing for the petitioner. The complainant was one of the petitioners in writ petition 8972 of 2020, challenging the action of the respondent in initiating suo motu proceedings against the challenging the show cause notice so issued by the second respondent and suo motu proceedings instituted thereon by the deputy commissioner. The petition comes to be dismissed. An appeal preferred against the said.
The petition was filed by the petitioner before your lordship. It was allowed.
Sorry, in one nimsha. The present petitioner was one of the petitioners in writ petition 8972 of 2020. The challenge, the such petition is allowed by setting aside those orders of the deputy commissioner. The challenge to the said order of the learned single judge is negatived by the division bench by dismissing the same. After the loss in both the cases springs the impugned complaint. In that light, there shall be an interim order of stay of all proceedings. Investigation, la?
The proceeding charge sheet has been filed. We have challenged the charge sheet also.
All further proceedings in special CC 956 of 2026 till the next date of hearing. One, ಇದಿಲ್ಲಲ್ಲ ಯಾರಿದ್ದಾರೆ ಲೋಕಾಯುಕ್ತ he is not a public servant anyways. Counsel Baby Patil is directed to accept notice for the your counsel in Venkatesh Arbatti is directed to accept notice for the respondent. Emergent notice to the second respondent complaint. Next.
Great.
Yes, sir.
Lord offense 69, my lord. Close relationship. Offenses under 69, my lord.
2 years.
5 years, my lord.
5 years, sir. I thought 2 years.
ಡಿವೋರ್ಸ್ ಕೊಡಿಸಿ ಆಮೇಲೆ ಮದುವೆ ಮಾಡೋದು.
ಏನ್ ಮಾಡಕ
7 ಲಕ್ಷದ ದುಡ್ಡು ಇಸ್ಕಟ್ಟಿ.
That's only her assertion, my lord. That's only an allegation that I've taken money.
Heard the learned counsel Srimati Kirti Reddy appearing for the petitioner. The petitioner and the respondent complainant have had relationship. The relationship was physical as well. The allegation is that it was on the promise of marriage that, having been breached, has led the complainant to register the complaint for offence punishable under section 69 of the BNS. A perusal at the complaint would indicate all the acts between the petitioner and the complainant being consensual. 69 alva?
69 and 318.
69 and?
318 of the BNS.
Sorry, 318. That is cheating. 69 inter alia. In that, the perusal at the complaint would clearly indicate that the acts between the petitioner and the complainant were all consensual. For invoking section 318, so in that light, there shall be an interim order of stay of all investigation qua this petitioner till the next date of hearing. One additional SPP, 2 emergent notice.
ಫೋನ್ ಪೇಗಿಂತ ವಾಪಸ್ ಕೊಡಿ.
ತಗೊಂಡಿದ್ರೆ ವಾಪಸ್ ಕೊಡ್ಸೋಣ ಆಮೇಲೆ. ಎಸ್. ಮಧು ಸೇರಿದಾರ?
The order of the adjudicating authority before whom I appeared and submitted my reply records the fact that I have submitted my reply, but nowhere in the order does the discussion relating to that is done.
137.
My name comes on page 151. 151, last but one. respondent number 163,
ಇದು ಜಸ್ಟಿಸ್ MIR ಆರ್ಡರ್ ಕನೆಕ್ಟೆಡ್.
please. Where that out of 6 PCIRs,
ಅದೇ
5 have closed.
KC ವೀರೇಂದ್ರ.
Yes, yes, that group.
ಏನೀಗ ನಾನ್ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಅಂತನಾ?
No reasonings, nothing in the order.
Where do the reasons commence?
So my submission is recorded at page 196. Lordship will see the para number 3. On receipt of the show cause notice so and so, replies have been filed 138 and 163. He records the fact that I have filed.
138 and?
163. For my purposes, it is 163 only. Page 196, your lord.
190, I'm at 196.
Yeah.
Replies,
para 3.
submission and
Yeah.
rejoinders.
Second line, upon receipt of the show cause notice, respond number so and so have filed his reply. 163, my reply is noted. Then your lordship, the
you are
reason,
respondent 163 na? Quite a big group. Yes.
then your lordship, he refers to all these replies at page 218. Deals with each one of them.
218. Gist of the reply.
Yeah. He goes on referring to all of them.
163 reference ilva?
Illa. Nowhere.
ಯಾಕೆ ಬಿಟ್ಬಿಟ್ರಿ ಇವ್ರನ್ನ? ಕಮತ್ ಸರ್ ಇದೆಯಾ?
No, I didn't find at least.
They would not do like that.
If he wants the specific reference, I mean, I can.
Where is respondent 16? ಅಷ್ಟೇ ಅವ್ರ ಕೇಸು.
Page 251 is the last. Respondent number 138.
If this is the issue, lordship may call it 230, my lord.
All right, pass over. Let him secure it.
I hope this is the only argument. I'll deal with, I'll meet.
If this goes, there's nothing,
There's
it
nothing
has to be
else.
set aside and reconsidered at
No,
least.
if it is not there, I will send it back.
Please.
If
It's
there
not
is,
there.
if there is something 162 ಇದ್ರೆ ಒಂದು paragraph ಸಾಕು.
I'll guess.
It's not there.
ನಾಳೆನಾ? Tomorrow. ಬೇಡ, pass over. We'll take it in the
2:30
afternoon, 2:30. Yes.
Hearing on IA, 10,
Post before any other bench.
11,
Let go before any other court, yes. 11. Yes. Ade, not before.
Matter had come up yesterday, your
Yes,
lordship.
yes.
Lordship.
Petitioner's counsel. Not there? We'll vacate the interim order.
Please.
The subject petition was listed on 2/6/2026. An application seeking vacating the interim order is filed long ago and the matter is being adjourned on the request of the petitioner from time to time. Therefore, to give an opportunity, the petitioner, where the petitioner, the learned senior counsel Srimati Lakshmi Engar, appearing for the respondent complainant, would take this court through the summary of the charge sheet. Charge sheet ಆಗಿದೆಯಲ್ಲ? ಇಲ್ಲ. Take through the complaint registered against these petitioners.
Page 135 is the surgery.
A perusal at the complaint would indicate grave torture of the daughter-in-law and the wife of the first petition, accused number one. In that light, investigation in such cases is a must. Therefore, the interim order so granted stands vacated on the aforesaid reasons. Lest the matter after 4 weeks, the papers of investigation be placed before the court by the learned HCGP. Yes.
Sahil?
For the petitioners in this matter, my lord. The offences under section 498A, 323 and 504 and 34 IPC, my lord. The petition number 1 is the husband of the respondent number 2 and petition number 2 and 3 are the in-laws of the respondent 2, my lord.
ಏನ್ ಹಸ್ಬೆಂಡ್ ಇವರು?
Yes, petition number 1.
Wife has hit the husband, is it?
ಇಲ್ಲ.
ಮತ್ತೆ ಏನಿದು? Page 21.
Yes, page number 21, that is the
That is what
the
they
petition number 1
that is
was
what they
assaulted
contend.
by the respondent 2, my lord.
Complaint is otherwise.
Oh.
And page number 22, your lordship kindly.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಬರೀ ಇನ್ವೆಸ್ಟಿಗೇಷನ್?
Investigation, my lord. Yes, page number 22, for a moment kindly be seen, my lord, WhatsApp charge, which indicates that the complaint is premeditated. Just for your information, my lawyer told that there will be 2 cases since it
ಅದು
is,
ಪ್ಯಾಕೇಜ್ ಹೇಳಿರ್ತಾರೆ ಬಿಡಿ.
since it is domestic violence, one in civil and
Member
one criminal. So there will be a warrant issued. So you talk to your lawyer and prepare whatever is required from
ಅವ್ರ
your
ಲಾಯರ್
end.
ಏನೇನು ಹೇಳಿದಾರೆ ಅದು ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ, ಏನಕ್ಕೆ ಪರವಾಗಿಲ್ಲ.
Therefore, my submission before your lordship is with modified intention.
ಅದಕ್ಕೆ ಲಾಯರ್ ಹೇಳಿದ್ರು ಅಂತ ಮಲೆಫಿಡ್ ಇಂಟೆನ್ಷನ್.
It's a premeditated. And with modified intention, the complaint came to be filed by the respondent to against the petitioners.
ಎಸ್ ಇನ್ಲಾಸ್ ಮೇಲೆ ಏನಿದೆ?
ಇನ್ಲಾಸ್ ಮೇಲೂ ಇದೆ.
ಏನಿದೆ?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವರು
ಏನು?
ಅಲಾಂಗ್ ವಿತ್ ದೆಮ್ ಅವ್ರು ಏನೇನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲಾಂಗ್ ವಿತ್ ದಮ್ ಇಲ್ಲ, ಏನಿದೆ? ಯಾವ ಸ್ಪೆಸಿಫಿಕ್ ಓವರ್ ಟ್ಯಾಕ್ಸ್ ಹೇಳಿ.
ಈ ಎಲ್ಲಾ ವಿಚಾರಗಳು ನನ್ನ ಗಂಡನ ತಂದೆ ನಾರಾಯಣ್ ಶೆಟ್ಟಿ ಗಂಡನ ತಾಯಿ ಶಶಿಕಲಾ ಇವರ ಸಮ್ಮುಖದಲ್ಲೇ ನಡೆದರೂ ಕೂಡ
ಸೊ ಅದಕ್ಕೆ 498 ಏನಾ?
ದೇರ್ ಪ್ರೆಸೆನ್ಸ್ ಇಟ್ ಸೆಲ್ಫ್ ಮೆಲೋಡ್ಸ್ ಮಗನ ಜೊತೆ ಸೇರಿಕೊಂಡು ನನ್ನ ಗಂಡನಿಗೆ ಬೆಂಬಲವಾಗಿ ಮಾತನಾಡಿ ನನ್ನನ್ನು ತುಚ್ಛವಾಗಿ ಬೈಯಲಾರಂಭಿಸಿದರು.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್? ಹಸ್ಬೆಂಡ್ ವಿಲ್ ಡಿಸ್ಮಿಸ್, ಅದರ್ಸ್ ವಿಲ್ ಕ್ವಾಶ್. The petitioners accused petition stands quashed, accused number 1, sorry, accused number 2 and 3 stands dismissed, accused number 1 will release.
Liberty may be given to the petition number 1 to approach this court if they filed the charge.
That is always there on Barkoli. The accused number 1, husband is reserved liberty to approach, to reproach this court in the event the final report is filed and the final report would go against him.
Great.
Much obliged.
ಕರೆದು ಬಿಡಿ ಅವ್ರನ್ನ, ಜಾಸ್ತಿ ಆಗಿದೆ ಅಂತ. ಅಲ್ಲ, ಜೇವೈಗೆ ಬರಕ್ಕೆ ಹೇಳ್ಬಿಡಿ.
I am appearing for the petitioners in this case, my lordship, for the offences punishable under section.
ಆಯ್ತು.
My lordship, I am appearing for the petitioners in this case, my lordship, for the offences punishable under section 420, 506, 504 and read with section 34 of IPC, my lordship. My lordship.
ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
Criminal color ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. She has given, she has
2325 long ago. Yes sir.
My lordship, the
vacating stay ಯಾರು ಹಾಕಿರೋದು?
No vacating stay, my lordship. Dispensation.
There is no vacating stay in this. Yes. Less the matter. 2 weeks bit on date kodi. Interim order subsisting will continue to the next date of hearing. Yes, next.
One date may be specific, my lordship. Please.
Yes, next.
24. 14.
I pay for the second response in this case.
Vacating stay idea? Yes.
Of the 2 cases, I may be permitted to make submissions on the second case because that's of genuine urgency. My lord may kindly.
Has been filed by the respondent in criminal petition.
Whatever it is, petitioner name, we have taken stay.
I have taken.
Make your submissions.
Now, the offense that has been registered in that, my lord, that we have taken signatures of the co-accused who are named in the FIR, that the signatures have been obtained by fraud. So the offense has been registered under section 217, 197, 198, 200, 205, 149, 420, 471, 416 and 463. Now the allegation that the signatures have been obtained by fraud is not even made by the executants who are the co-accused.
Now,
with
who
me
is
in
making
DV
this?
At the instance of Srimati K.M. Shailaja, who is my wife, she has made the allegation that H.M. Kottreya, Ambuja, who are R2 and R3 in the DV proceedings, and H.M. Nagalingama, R4. What is alleged is H.M. Nagalingama, they have made her as a party as my alleged second wife, Milord. And H.M. Kottreya and Ambuja, who are R2 and R3, are the parents of the alleged Nagalingama. And Mahanta Swami, who is my father, and Virendra, who is my brother, have been made a party to the DV proceedings. Now, Mahanta Swami, who had expired on 6/5/2021, without even knowing that he has expired, the complaint has been made against him, who is none other than my father. Now, what is the allegation is the signatures of all these people have been taken by me by forgery. So these allegations
Taken
are
by
not-
you, forged.
has been forged. This is the allegation made against me, Milord, and not even made by the executants, Milord.
ಅಷ್ಟೇನಾ?
Milord, this honorable court, order copy is also produced by the petitioner. On the writ side was pleased to direct the police to register a FIR and go ahead with the investigation.
Against them.
Yes, Milord. Yes, against all those persons.
Where do I get that order?
Milord,
53, page 53.
WP 12137 of
Yeah, I'm there. 1 minute. Against whom was the complaint directed to be registered?
Against the petitioner.
According to signatures of so and so. Pursuant to that, crime is registered.
yes, Milord. Now that investigation is no challenge.
No, investigation is stayed here.
Stayed.
Stayed, Milord.
Let's go.
Order dated 7/1/2025.
Anything else, madam?
Milord, one more. In the writ petition, Milord, what?
Have you challenged that order?
No, Milord.
Has this order become final?
No, Milord.
The writ petition order has become final?
Become final.
Yes.
And Milord, one more point that I want to bring to the notice in WP number 9501 of
Which is that?
today.
Today?
Petition,
The next
Milord.
matter, Milord. The
The next-
protected
Next,
matter.
all right.
What has been challenged is the petition was filed under section 12 of the Domestic Violence Act by my wife. Now, there was no prayer to grant maintenance in the said petition. Even though there was no prayer, subsequently an affidavit has been filed by the brother of my wife, who is a practicing advocate. Now, on the basis of the said additional affidavit that was filed, the court has directed that interim order that which was granted without even holding an inquiry, it was made absolute. Now, because of which
What is the amount of maintenance?
7,000 million.
Anything else, madam?
So
Enhancement
that is-
ಹಾಕಿದ್ದೀರಾ?
Not yet, Milord.
Which
Because
is
that
at page
proceedings are stayed.
And
What judgment, madam?
now the DVA proceedings were challenged in appeal, which was again challenged in a criminal revision petition, which was disposed, Milord.
That's precisely what I wanted to produce.
In the said petition, Milord, my
Paragraphs-
wife who is residing in
Paragraphs
the
11 and 12.
You are the wife.
I am the wife.
You are directed to be evicted.
Yes,
Please.
Milord.
I have no objection about
This
that.
one,
I will
any
only inform the authorities. But the thing is, if I overstay, every day I have to pay 8,000 rupees without the husband making alternative accommodation, both in terms of the domestic violence court order, which is now confirmed by this, by a coordinate bench of this honorable court. I'm not seeking any relief at the hands of this honorable court insofar as vacating the quarters is concerned. That's not the
Of
issue.
course, this, that you can't also hear.
That's not the issue at all. Now that the writ petition is liable to be dismissed in view of this order.
Anything
Because
else,
the
madam?
same order is challenged in both the
While
cases.
getting from my property, my lord, I had built a hostel. They had not disclosed in the affidavit and they
In
have
the,
got
in the second petition, what is the challenge?
in writ petition,
Second companion petition, what is the challenge?
in the criminal petition, my lord.
Huh.
In the criminal FIR has been registered against me for taking signature on
That is pursuant to the order of this court, madam.
Yes, ma'am.
The second petition, yavudu?
9501. 9501.
9501. Adral challenge ಏನು?
The same order that was challenged in criminal revision petition. Two separate cases.
The advocate who is appearing
On
for
the
my
same
wife
cause of action.
has filed a affidavit, my lord, and they have taken post getting the post the disposal of the DV
If
proceedings.
the
my lord.
order passed by Justice Dinesh Kumar has become final, you have no say. Yes. First we'll take criminal petition 1336 of 2024. And how is the state?
State has failed. Not make any submission on that.
The petitioner is before this court seeking the following prayer. The petitioner is the husband. The respondent, the wife. Second respondent, the wife. Proceedings between the two, galore. They were before the court, the wife was before the coordinate bench in writ petition 12137 of 2021. The coordinate bench disposed the said writ petition by the following order, page 54 to 57. The coordinate bench unequivocally directed a crime to be registered against the petitioner for having allegedly secured the signatures of several persons, which were allegedly forged. Pursuant to the said registration, pursuant to the said direction by the coordinate bench, the impugned complaint comes to be registered, which becomes a crime in crime number 340 of 2023 for the following offences. Notwithstanding the direction of the said order of the coordinate bench has become final. In the light of the finality of in the light of the attaining of the finality of the order passed by the coordinate bench, interference in the crime so registered would not be an available remedy to the hands of the petitioner. Notwithstanding the same, there is an interim order of stay operating in the case at hand. Therefore, the petitioner will have to come out clean in the investigation as directed by the coordinate bench. Therefore, permitting further investigation, the subject petition stands disposed, reserving liberty to the petitioner to knock at the doors of this court in the event the final report is filed, and the final report would go against the petitioner. Companion petition. The companion petition is again between the same parties. What is under challenge in the subject petition is the order dated 22/6/2020 passed in criminal miscellaneous 1915 of 2009. It transpires that the very same order was called in question in criminal revision petition 248 of 2023, and the coordinate bench has now disposed the petition in terms of its order dated April the 30th, 2026 by the following order. Quote the order. In the light of the said order, the said order so passed and a direction being issued to the wife to vacate the premises, the other order I challenge le?
No, I am not challenging any
ಅಲ್ಲ
order.
ನೀವಲ್ಲ ಸರ್, ಇದರಲ್ಲಿ ಚಾಲೆಂಜ್ ಏನು?
Same order.
Same order
The
ಅಲ್ವಾ?
domestic court's order dated 19/6 and 22/6, which has become final. I mean, part of the
19/6 2010 and 22/6.
Yes.
Yes, same
What
order.
has been challenged is after the disposal, they have filed another affidavit that there was not a prayer of asking for
That's
a.
okay. Yes. In the light of the said challenge being already answered by the coordinate bench in the said order, no further answer to the said order need be done in the case at hand. It would suffice if the order that is paraphrased here and above would become applicable to the case at hand is made applicable to the case at hand as well. With the aforesaid observation, the petition stands disposed. Yes, next.
15.
Appearing for the second respondent in this matter, my lords.
Scores outside. One B is producing a document that is forced before the consent. List the matter on next Tuesday, next Wednesday, same stage. Yes.
Much obliged.
Interim order. Please continue. Yes, next.
16.
The respondent
For
in
the
this case.
petitioner, my lord. Alleged offences is section 420, reduced section 34 of IPC. The petitioners are the office bearers of one registered association by name Kelo Masters India, wherein the petition number 1 is serving as a treasurer, petition number 2 as secretary, and petition number 3 as a president. And petition.
What you glorify yourself so that we'll allow the petitioner. Para 36 cell.
Please.
Petitioners are God-fearing persons. They come from a decent family background. No black mark in their lifetime. So allowed quashed.
No,
Then
actually, the antecedent, what was suggesting at that para is with regard to the antecedent of the petitioner, my lord. Now, what has transpired is, my lord, initially I filed a PCR against this petitioner along with the other petitioners. 15 petitioners made as accused in a PCR. That PCR came to be registered on 6/1/2024. And as a counter blast on 7/2/2024, this crime has been registered against us. That too, according to them, this complaint has been filed after a span of 5.5 months. There is a delay of 5.5 months, my lord.
what is the allegation?
Allegation is that.
420.
Please, my lord.
My lord, on the pretext of organizing a tournament at Australia, my lord.
What tournament?
Hockey tournament, my lord.
Hockey.
Masters game hockey tournament at Australia, my lord. 3 lakh per player was collected.
Oh, by these people.
Yes, my lord. My lord, the amount was collected in the manner that
Ultimately, where did you play hockey?
we did not play.
Oh, you
My
did
lord,
not play at all.
but in fact, we were told that the tournament
That's
is
not
cancelled. But
that's
no, my
actually
lord,
not the correct
tournament was
version, my
not
lord. That's
cancelled.
not actually the correct version. My lord, initially, we were to take them to a tournament at Korea. Korea.
Korea.
Yes, that is the allegation in the complaint. But for the reason that the participant could not produce their documents in
What
time,
documents?
the document would pertain to take the visa for the same. No
Be-
documents.
Before all this, how much money did you collect?
My lord, 50,000.
50,000
Each.
per
50,000 each.
Wait, madam. 50,000 each.
50,000 each.
How many participants?
15 participants.
15.
15, 1-5.
All right, 50,000 into 15.
Yes, my lord.
First chunk.
Yes,
All
and
right.
according to them, it has been returned.
Whom?
We returned to the participants because that
Hello.
that event never
You have
took
returned
place.
you
Yes,
returned the money
according to the complaint.
according to the
Yes,
complaint.
my lord.
Amele.
The second one is with regard to an Australian tournament, my lord.
Oh, you took them to Australia also.
No, I was supposed.
Oh, sorry.
There was a tournament that was to be held in Australia. But once again, my lord, for the reason that some of the documents were not produced by some of the documents
Again, documents were not produced.
not produced. That was communicated to them.
How much money did you collect to Australia?
Please, my lord, 2,65,000
Each.
Please, my lord.
15.
15. No, not 15. In total, according to them, according to complainant, they have transferred 2,65,000 to the
How many people have transfers?
15 persons.
Each 2,65,000.
No, my lord.
Totally.
That is our allegations. That
No,
is
no.
the
How much I'm asking?
1,50,000 each.
Each.
Each 1,50,000.
So 1,50,000 into 15. Huh?
Please, my lord.
How can you repeatedly con them?
My lord.
Yes, sir.
Initially, that event never took place. And upon their request,
Hockey never took place.
Upon their request, my lord, the second event was to be conducted, but for the
First innings, okay. Second innings also?
my lord, next, there is also a third innings, my lord.
Oh, another country?
This never manifested.
In India, you have given them Lok Darshan.
No, my lord, see, the allegations, even according to the complaint, my lord, is that for the reason that some of the players, they were unable to procure certain of the documents for which they could not procure the visa. That is this, with regard to the second
So
event.
return the money.
Please, my lord. But since they requested that they want to play and
Another country.
want to play in hockey
ಈಗ
tournament,
ಯಾವುದು? New Zealand?
Sri Lanka,
Sri Lanka. Oh.
which took place.
Oh, they went to Sri Lanka.
Yeah, they went to Sri
So
Lanka.
you set off all the amount for Sri Lanka.
Not so, my lord, not so.
Then
Now, what has happened is, now the Sri Lanka tournament took place, and also there were some monies which was left with us. Now the allegation, yes, my lord. Now the allegation is in our PCR is that the accused number 1 in the PCR, also these accused who is the respondent number 2, they collected money in our name, and we don't know to what amount they have collected. And there repeatedly there were communications with the accused person since from November 2023. May I submit the document, my lord?
Copy, please, sir.
Please, please. Copy. Namdi.
documents,
These are the 81 documents that I produced.
If I have to see these documents
my
under 482, it's a matter of evidence.
My lord. Now the allegations against me. May I read out the complaint, madam? The allegation, there is no specific ingredients to attract section 420.
Seriously?
Please, my lord.
Oh.
May I read out the
Yes,
complaint, my lord? May I read out the complaint, madam?
Yes, sir.
Please, my lord.
Wait, we'll read the complaint. Yes, madam.
My lord, the complaint that was filed by them, my lord, ended up in B report. In B report, it is the categorical finding of the Nandini Layout police station that the amount that was collected by accused number 1 in my complaint as well as in their complaint, who is one and the same, was transferred to the personal account to the petitioners, my lord.
Totally how much, madam?
My lord, per participant, my lord, 1,30,000 in account transfer, 1,70,000 in cash, my lord.
So 3 lakhs.
Each, my lord. About 17 participants.
Oh,
And
they have collected,
apart from that, my
collected 51 lakhs.
yes, ma'am. Apart from that, sponsorships were raised in our name.
Oh.
They have raised sponsorship in our name, and that money is also utilized by them. I have produced the document to that effect.
Game hockey, kuch nahi baki.
My lord.
Yes.
My lord,
You have swindled everything.
My lord, the entire allegation is only against the petition number 1, saying that yes, some amount has been transferred in his name. But petition number 2, 3, 4, just because they happen to be the office bearers, my lord, there is no overtact allegation. Not even a
Not
single
just
word.
because, only because you are the office
My
bearer.
lord, there is not even a single overtact allegation against petition number 2 and 3.
Anything else, sir?
My lord, specific.
Anything else, sir?
The ingredients are not forthcoming.
I will write, sir. What are the ingredients? Idu stay ಆಗಿದೆಯಾ?
This has been stayed, my lord. Now, the PCR that I filed, that ended up in B report now, which has been challenged by a protest petition. My lord, if my lords look into what the B report says, that categorically states that there were some money.
Idu poor hockey players, you have conned them. Can you con cricketers like this?
No, it's
Impossible.
Not about my lord. My lord, my specific allegation or specific stand is that, my lord, once the accused number was never authorized to collect any monies.
No problems.
And even this respondent number 2 has received some money from the accused number 1.
All the investigation will reveal everything. It's a matter for investigation. You have lured them into the transaction. Straight away 415 ingredients met. Anything else?
My lord, even in first transactions or in second transactions, the amount has been returned back to them. That is their.
No worries. How many times can you hoodwink one set of people? Once okay. Korea ಆಯ್ತು, Australia ಆಯ್ತು, Sri Lanka ಆಯ್ತು. ಬಿಟ್ಟಿದ್ರೆ you would have taken them to some other land.
Those things happened for the reasons best known to them, because
known to them.
For the non-production of documents, my
Give
lord.
back the money.
It has been given.
All 51 lakhs you give back.
My lord, it's not about 51 lakhs, my lord. The contention is that the accused number 1, she has collected to the tune of 22 lakh 65,000, which is submitted by them, which is submitted in the B report.
you ask your friends also to give it back. Co-accused.
Court has got nothing to do
No,
with.
no, sir. Yes. Anything else? Dismissed.
I may permit with liberty to, if at all.
Discharge.
No, my lord, if at all end up with the charge sheet.
The learned counsel for the petition, after arguing the matter at length, would seek leave of this court to withdraw the petition and reproach this court in the event the final report would be filed, and the final report so filed would go against him. Reserving such liberty and keeping all the contentions open, the petition stands disposed. Yes.
70.
Lord, may I seek my Lord's indulgence in having it tomorrow, my Lord. And later, Mr. Sriram.
Pass over.
My Lord, my Lord. I seek
Pass
for
over,
an
pass over.
adjournment, my Lord.
Name time illa. Vacating stay application ಯಾರು ಹಾಕಿರೋದು?
We have filed.
No, you have filed.
We have filed.
Yes. You are not ready?
I have engaged the senior counsel.
Get the senior counsel. Yes.
But he is out of station, my Lord. I kindly have
Vacating
Monday,
stay,
my Lord.
I will not grant time. Pass over. Yes.
Monday, my lords.
No,
Please, my lords.
no, madam. Yes.
From yesterday, my lord, it is taken.
From yesterday,
Matter
we'll
was
send it to
posted
tomorrow.
Yesterday, no, my lord, the case pertains to, my lord, they want transgression of the checks which are wrongly produced. But the
This has to be, accused cannot get away with the typographical
Understand
error
it.
or the mistake of the counsel.
if it is, my lord, I can
See, there are two cases. In one case, check A, which had to be placed in the first case, is placed in the second case.
Yes.
Check B, which had to be in the second case, is placed in the first case.
Correct.
Evidence is let in. Everything is done. The court notices when the matter reaches the judgment
Yes.
and says you correct it.
Yes.
That's all. With this,
Court did
accused
not-
cannot get away like this, sir.
No, not like
Checks
that.
are there. See, if while issuing the demand notice or while in complaint, sworn statement is recorded properly on the checks.
Sworn statement is not proper. That is
Ah,
not
it
my
is.
case, my lord. Sworn statement is a different check. That is what, my lord. I can understand, my lord, if the wrong check number is mentioned, they can always amend
What
it.
is the amount?
They can correct it. The 20 lakh 14,000
Ah,
for
give
the
it back.
such check. But it is not like that, my lord. It is
41 lakhs.
not, it is total 40 lakhs. It is not like that, my lord. Complainant through his wife has also filed the several complaints. My lord, when it comes to
And when the
merit-
matter was posted for judgment, the court suo moto says you
Not
corrected.
court,
No,
sir.
sir.
Lordship,
Yes.
kindly see my written submission. Your lordship, yesterday your lordship wanted to see the written submission. It is not we who has, not we have highlighted this defect before the court at the time of
Written
argument.
submission is filed at the, just before the
While
judgment.
arguing, my lord, they did not. Your lordship may kindly see written submissions are filed. After 4 months, the court notified it. There were 3-4 dates were given.
We'll
Your
see.
lordship may kindly see.
We'll dictate it on Friday. List for dictating orders on Friday. Yes.
There are 4 decisions, my lord.
Kodi.
But incidentally, my lord, there are 2 cases. Otherwise, my lord, if it is to be one case and if a wrong check is produced, but cognizance itself is wrong.
Cognizance is wrong, yes, if it is right from the inception.
From the
Now,
inception.
no, sir.
My lord, cognizance, when the, my lord, sworn statement,
It is, checks are there. There are 2 complaints. Checks are exchanged in the 2 complaints.
Lord, checks may be
And
there, my lord.
accused on this ground cannot get away with it, sir.
No, I'm not. Checks may be there in the, my lord, in the same court, my lord.
no,
It is not on the same file, my lord. Incidentally, there are 2 cases.
A file ಅಲ್ಲಿ B check ಇದೆ, B file ಅಲ್ಲಿ A check ಇದೆ.
Two
ಅಷ್ಟೇ.
different
It's all
cases,
check
Lord.
had to be exchanged.
Your lordship may kindly see.
no, sir.
Your lordship may kindly consider the situation. Suppose.
Hanganta, now, if we say,
Yes,
the B case has a A check and A case has a B check, so quash the proceedings. What happens to the victim?
I did not seek for clashing, my lord. The complainant has come up with an application under section 91.
Why? Because
I
the
say-
court says,
No,
court
that
suo
is-
moto directed him.
No, that, no, the court has not directed, my lord. He filed an application under section 91. Not the such, my lord, the relief sought for in the application is unknown to law. Now, I am challenging, my lord, order on the application.
No
I'm
problem.
not seeking
We'll
clashing.
answer it as it is known to law. Yes, Friday.
Not only this, my lord.
Friday, sir. Yes. Next.
20.
ಇದು ನೀವೇ ಹಾಕಿರೋದಾ?
Cheating and forgery.
ಅಲ್ಲ,
yes, my
it's
lordship.
in fact covered by your lordship judgment.
ಯಾವ್ದಿದು?
Criminal petition 450 of 2024 ತಾವೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೀರಿ.
Not in respect of this particular cases, my lordship.
He's asking for quashing of.
ಯಾವ್ದಿದು?
HAL ದು ಪ್ರಾಪರ್ಟಿನ ಸೇಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ, ಲೀಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
ಎಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ?
They withdrew it. I'll place it. I'll give the copy. After arguing the matter, the matter was withdrawn.
Pass over. Yes.
Case number maybe.
Criminal petition 450 of 24.
Pass over. Yes.
450.
Thank you.
This is HAL land, my lord wanted to sell it to people.
HAL land ನ ಇವ್ರು ಮಾರ್ತಾ ಇದಾರಾ? ತೊಂದ್ರೆ ಇಲ್ಲ.
After full-fledged trial, we have been acquitted, my lordship, in a connected case.
All right. We'll
No,
see.
no,
Pass over.
corruption
Let's see. Let's see. Yes.
And there, my lord, your lordship, I think seems to have misled to this court by showing the charge sheet in that corruption case.
Right. We'll see. Yes.
21.
It's appear for the petitioners. Petitioners.
I post immediately after service of notice upon the respondent. Interim order, if any, shall continue to the next.
There is no interim order. my lord.
There is no interim order.
It was filed during the.
That
vacation.
also will continue.
No, no, my lords, it was filed during the vacations. Looking at the voluminous of the charge sheet, my lords, the honorable judge said, my lords, for the state to take instructions. Therefore, it is posted today because the matter before the trial court is tomorrow, my lords. Petitioners were not.
Appears to be a heavy matter.
ಅಲ್ಲ ಅವ್ರು ನಮಗೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ. I am only a tenant there. Dispute between the society and a member of the society. But they filed a complaint, my lords. Since 2020, the school is being run in the premises.
School?
School ನಡೀತಾ ಇದೆ. We are the trustees who are running that school. Petitioner, right?
What's the problem now?
Now the society says the person who was given the property on lease to us was not the member and he did not have the authorization. My lords, may kindly see one report of the RBI where they had filed a complaint before the RBI.
Well, let the respondent come.
Please, my lord. All that I request, my lords, may have it after 2 weeks, a date may be fixed.
No, that I will do.
Please, let.
Yes.
I understand because notice is already ordered.
Correct. ಅದಕ್ಕೆ ಇಲ್ಲ ಅಂದ್ರೆ we would have taken.
I understand.
Yes. List the matter on third week ಹಾಕಿ madam. 23rd June. Yes.
Fresh matters.
Fresh matters.
Great.
22.
Will please the court.
Yes, Raju sir is leading.
These are 3 writ petitions.
Yes, sir.
Questioning the legality of arrest.
Mr.
Under the
S.V. Raju, my senior colleague.
Yes, yes.
But we argued this extensively during the.
All of you are in this only? Oh, there are 3 cases. All right.
That's earlier your lordships had occasion to deal with it in a writ petition which is still pending before your lordships. Writ petition 1668 of 2026. This is the Gamescraft online gaming.
Oh, Chota sir had appeared. Yes, yes. Yes, yes.
So, begin, my lord.
Yes, sir.
So, well, this Deepak Singh, who's petitioner in 15337 of 2026.
Yes.
Is one of the founding directors of Gamescraft Technologies Private Limited. The company is incorporated on 6 June 2017. And in an earlier round, my lords, an FIR 722 of 2024 was registered at PS Central, Bangalore City under 318 of the BNS and 66 of the IT Act. And the complaint was that the complainant who had played Rummy Online, he had suffered a loss, according to him, of almost 3 crores of rupees.
There's
So the
poker
allegation
online,
was-
not rummy, poker.
Poker. I'm sorry. I'm correct. So the allegation was he had lost 3 crores of rupees. Well, there was a closure report filed in that FIR. After the filing of the closure report on 5th July 2025, 3 months later, they register an ECIR. And that's when, my lords, we came before your lordship.
The closure report became final?
That's right. That was not challenged. Yes. So, my lords, when the ECIR was registered on 11th November 2025, searches took place after the registration of the ECIR on 2 dates, 18th November and 22nd November. And these were under section 17 of the PMLA.
Yes.
This was at the residential premises of these very petitioners, because they are in Gurgaon. And we then came before your lordship with writ petition 1668 of 2026. And an interim order was passed in that writ petition, which we have placed at page 42.
Which is that?
Page 42 of the main writ petition 15537.
One moment. Page 42, yes.
If your lordship sees that order for a minute.
That is, there shall be an interim order of stay for the proceedings in the subject ECIR.
Correct. But
arising out of 722.
And your lordship notes the said closure of the B report is said to have become final.
Yes.
Mr. Kamath, learned ASG, submits that the ED is entitled to update its ECIR, which is the predicate offense is now closed has vanished. In that light, ECIR, insofar as it pertains to crime 722 of 2024, cannot be permitted to investigate it into. Learned ASG submits that there are several other FIRs which are pending prior to the registration of 722 of 2024. This is very important. Actually, there is no several FIRs pending prior to this at all. But the statement made before your lordship was there are several other FIRs which have been registered prior to 722 of 2024, and they also precede the registration of the ECIR against these petitioners. Therefore, he would file a statement of objections and also drive home the concept of updation of ECIR as and when FIRs come to be registered. Your lordship notes that this is 22nd January 2026. Now, what is important is 2 days after this order, on 24th January 2026, FIR number 97 of 2026 is registered in Telangana.
That is 27/1/26.
24/1/2026.
24/1/2026. Crime number?
FIR 97 of 2026
Telangana.
in Telangana.
Yes.
Again, under section 318, subsection 4 and 319, subsection 2 of the BNS. And there the complainant alleges that he lost 53,080 rupees. Now, nothing happens in that FIR. In quick succession, 2 other FIRs are registered in Telangana. Your lordships will note this also because these form the subject matter of the present ED proceedings. The second is FIR number 10 of 2026, dated 10th February 2026. Again, under the same provisions, alleging a loss of 1.85 crores. There is a third FIR 330 of 2026, registered on 12/2/2026, alleging a loss of 40 lakhs of rupees. So we have 3 FIRs registered in Telangana. Nothing happens in those FIRs for 4 months. No investigation, no summons, no inquiry, nothing. It's lying dormant. Well, what they do is on 23rd February 2026, they register a fresh ECIR.
Where?
In Bangalore. The same ED office in Bangalore, the regional office in Bangalore.
No, the ECIR is based upon what predicate offense?
These 3 FIRs. The 3
Of Telangana.
Yes. So I'm not arguing how come Bangalore ED has to take up when there is an ED in Telangana. That I'm not arguing at all. But the fact remains they picked up these 3 FIRs as predicate offenses and they registered this ECIR on 23rd February 2026. In the meanwhile, one very important fact is Gamescraft has stopped its operations in August 2025 itself. Your lordships are aware a legislation came about.
Correct, yes.
Everybody stopped. Gamescraft also stopped. Your lordships is aware. So after the stoppage of the Gamescraft operations, the first ECIR was registered, which your lordship stayed. Now these 3 FIRs on which a new ECIR. Now again for about 2 months and over, nothing happens. On the morning of 7th May 2026, they commenced their searches under section 17 PMLA in Gurgaon.
PMLA.
Yes.
Yes.
This search goes on for a whole day from the early hours of 7th May 2026 till the early hours of 8th May 2026. And from 2:30 a.m., one petitioner, Mr. Prithviraj, is arrested. 3:35 a.m., all this is in the morning of 8th May, Mr. Vikas Taneja is arrested. And the petitioner in the matter in which I am appearing, Mr. Deepak Singh, he is arrested at 4:50 a.m. All this happens on 8th May 2026. They get a transit remand and they are produced before the court here, which grants ED custody. Well, as those proceedings are pending, they were given 2 spells of ED custody. Now these 3 are in judicial custody. And that matter is coming up again on Monday.
What are these matters?
Well, as these are the same ED matters in which they've been remanded to first to ED custody and now judicial custody. Well, as there the court, although we point out the illegality of the arrest, well, as the lordships will say, which is the main ground on illegality of arrest? The main ground is this. There is no new tangible material spelled out in either the grounds of arrest or in the reasons to believe both of which are furnished to us. We've made part of the writ petition. Both the grounds of arrest and the reasons to believe refer to the material already seized in November.
In which, in Telangana?
No. In the first ECIR.
In 722.
That's right. That 722 left leading to the ECIR and leading to the search of November. Those are the very materials referred to in the present reasons to believe and grounds of arrest.
Where do I get that?
Well, your lordship will straight away come to the grounds of arrest and reasons to believe, which we've made part of the page 94 is the grounds of arrest. And your lordships will also refer to the reasons to believe. Well, as your lordships comes to page 102.
102. Yes.
If your lordships turns to page, after referring to the 3 FIRs, if your lordship refers to,
I'm at 102, sir.
yes.
But there are several other crimes mentioned here.
No, these are the
97, 10, 330.
Those 3 FIRs, Mullahs. What I've mentioned are the 3 Telangana FIRs.
Yes.
And the transactions your lordship see, which are referred to, all pertain to your lordship sees, for instance, page 116. And 3 outcome of PMLA investigations.
Outcome of PMLA. Yes.
Now, all of this, whatever they're referring to, rummy culture, rummy game, all this, if your lordship sees even the dates, they all pertain to the period 2017 to 2025 May.
Yes.
And even the shareholding pattern, all of that, everything ends at 31st March 2025. Now, your lordships will not find any reference to any material gathered during this search. All the facts set out here, all the allegations made, all pertain to material already searched, already recovered. If your lordship goes back just a few pages, page 108.
Yes.
107 onwards, correct. Thank you. 107 onwards.
Complaints filed by victims through
Correct,
email.
correct.
Yes.
And all of this, these data, first line of 108, these data was seized during the search conducted on 17 at the premises of Gamescraft in the month of November 2025.
That forms the part of 722?
Exactly. Which has been stated. So our first and major contention here is that the entire exercise is premised on no new tangible material, because this is one of the grounds on which your lordships have stated that an arrest can be held to be illegal if the exercise of the power is on the basis of material which has already been put to test and which is already seized off by a high court. Well, one would have imagined, after making that statement before your lordship, that they are going to amend the existing ACIR. Nobody thought they would actually go ahead and register a fresh ECIR on the basis of 3 FIRs which have not moved an inch. There is no basic investigation into those 3 FIRs, not even a summons, no proceedings commenced. And they pick up those 3 FIRs to register a fresh ECIR. What is interesting is, and I think we'll have to hand over to your lordships, the counter filed in that writ petition which is pending before your lordship.
In 722?
No, that 1668.
Which I stayed.
Yes, which your lordship stayed. If your lordship sees that counter affidavit, it's very interesting. And your lordship straightaway comes to para 8 of that counter affidavit, which is internal page 5. Your lordships will recall the sentence. According to them, there were several FIRs pending prior to 722.
That was a submission also, man. I've recorded that.
Yeah, there is no such FIR. What they refer to in para 8 is a subsequent FIR registered on 21st January 2026 in Gomti Nagar, Lucknow. on the basis of a complaint filed by Sri Pramod Tripathi, wherein the complainant alleged that he had created an account on the Rummy Culture online gaming application in the name of his wife and incurred losses of approximately 18 lakhs due to inducement into addictive gameplay, refusal to close the
A
account.
copy of his counter may be given to me. A copy may be given to me. A soft copy may be.
Mr. Raju, it's been handed over to Mr. Rao here.
Soft copy. Soft copy.
Very well. Very well. We'll send it. We'll send it. Not
But I was not there in that.
I know, sir. This is your own document. No difficulty.
And it's not produced. It is produced all of a sudden in the midst of an argument. It should have produced it earlier. Now I had to look at it.
I understand, Mr. Raju. Not to worry.
I'm not on technicalities, but I'll argue it. But this, if he relies on any document, he has to either file it. If he does it at the last minute,
Plus, we just wanted to
copy has to be given.
fact because everybody would want to know what actually happened further.
Give off a copy.
We've given a copy. Para 9, if your lordship sees, accordingly, FIR number 29 of 2026 was lawfully incorporated, the words your lordship see, into the existing ECIR by way of an addendum dated 18 February 2026. The allegations therein disclose commission of a schedule offence under so-and-so, thereby generating prima facie proceeds in view of the settled position of law laid down with Vijay Madan Lal Chaudhary. Proceedings under the PMLA are independent in nature. An attachment, search, seizure or investigation can continue so long as the proceeds of crime are traceable to any scheduled offence. The addendum thus sustains the ECIR and the very foundation of the present petition is rendered infructuous. Just pausing here for a minute. If this is what they were going to do in respect of a Lucknow FIR of 22nd January 2026, and this is consistent with what they submitted to your lordship, there was no need for them to resort to a fresh ECIR at all. And this FIR, interestingly, didn't result in any raid, in any search, in any arrest, whereas they picked up the 3 Telangana FIRs, and one fine day 2 months after, land up at Gurgaon. And my lords, because last time I argued and Mr. Raju was taking strong exception to the fact that I even alluded to the fact that under section 17, reasons to believe have to be formed even for initiating that search and seizure. And that reasons to believe are not known to us, although they have filed a counter here.
My learned friend argued that he has to be supplied the grounds of arrest. My learned friend may not digress.
My submission. Mr. Raju,
Supply is different.
Raju, I've already conveyed to his lordship your objection last time. So you're very much going to be heard, sir.
But you're changing. When you put words in my mouth, you must put the correct words, sir, with great respect. You must not say that I said that there's no necessity
You're always
to
there
supply.
to correct.
Under 17, I never said that there's no need to formulate. There's a difference between the two, sir. You know it. I would never have argued such a thing which is contrary to the statute. What is required, I'll argue. But don't put, you may argue on your own, but don't put words in my mouth, sir, with great respect. I'm telling you.
Anyway, so the point is this, Mellas, the reasons to believe for section 17 don't seem to be appearing on the records.
Correct.
And they've not been set out in the counter. That apart, the reasons to believe for section 19, according to me, are based on material already gathered. There was no application of mind. What is strange, my lords, they start the search on the morning of 7th, end it on 8th, by which time they're ready with both. Your lordships will see the length of both these documents, both the grounds of arrest and reasons to believe. Page.
Where do I get that?
Well, it's in the writ petition. Page 91, annexure F.
Reasons to believe.
Yes. No. Reasons. No. First, grounds of arrest, if your lordship sees, it
That's
begins.
it. Grounds of arrest 91.
94, actually 94. And goes on till 101. And then reasons to believe follows from 102 and goes on till. So if lordships should imagine there's a whole team there conducting search and seizure. You're supposed to, first of all, be satisfied that as a result of the material gathered during search and seizure, you should proceed with the arrest. And all of this is supposed to be happening during the search and seizure, which is impossible to believe. So the submission is this, Malas. This was all preset. It had already gone with typed documents, which is why these documents don't refer to the material seized during the search. They refer to material already gathered. So it was already predetermined. It's rendering the language of the statute completely redundant. I'm satisfying the letter of the law, but not the spirit of the law. I've already made up my mind. I've got all documents already ready. I'm going to tell a court, oh, I have satisfied. 19 is satisfied in letter, but not in spirit. And this is, my lords, when your lordship is seized of a matter. So even last time we argued, the least one would have expected is come back before the court and say that this is what we have found. And this leads us to believe that either we should amend the existing ECIR or initiate another proceeding, but the lordship should have to be explained, because otherwise you're only multiplying proceedings. What has happened is, because they bypassed your lordship, we are taken into custody. And it's almost a month.
You're in custody?
Yes, for a month now, my lords. For almost a month. Since the morning of 8th, I'm in custody till today. And I've been brought here overnight to Bangalore. The arrest was at morning 4:50. I think the time of production before the court was 6 o'clock in the morning. So, well, what was, I mean, are we some fugitives from justice? We are people who've been granted protection by your lordship. We are not going away anywhere. We have not left the country. We have not done anything. We have not diverted assets. That is not even the allegation. What was so urgent that could not wait even for a minute, that we had to be picked up from Gurgaon and brought here and lodged in jail here overnight. And there was no summons issued. Let's say, well, I'm assuming against myself, that during those searches, they found some material which they did not already have in the November searches. They could have issued a notice under Section 50. They could have asked me about it. I would have offered an explanation. Well, today, what is it? What happens is, because of its PMLA, and I don't need to argue PMLA at all before this bench, I'm put on the back foot. I have that onerous responsibility of proving that prima facie the ED's case is untrue. And how am I supposed to do it without all these materials? I'm given, of course, grounds of arrest and the reasons to believe. But the material on the basis of which they have now drawn this up, that is not available to me yet. And if it is the same material, my lords, it's a clear abuse of process. So, and my lords, what happens is this, and this also I pointed out last time. Your lordships of the Supreme Court and several high courts have explained to the district judiciary that prepare a checklist. Satisfy yourself, is this arrest a genuine arrest? Does it follow the letter and spirit of the law? But my lords, unfortunately, the courts are not prepared to do that. The granting of remand is almost mechanical. Even today, my lords, whenever we argue the bail application, the judge says the matter is pending before the High Court. We tried telling the judge that bail is separate, what we are arguing before the High Court is separate. There's a whole body of case law, your lordships are already aware, but I'll point it out. The legality of arrest can be urged in a writ petition before a High Court. And they've explained that this stands on a separate, different footing. Because of the power of this law, my lords, the power to pick up people across borders, bring them across borders, it's a very potent power. And if you're going to use it so casually and so routinely, then the courts are the only institution people can turn to protect their life and liberty. I've lost my liberty for a month. I'm cut off. I'm not a dreaded criminal. The greatest respect, my lords, I'm a person who engages with the law. At the first instance, I came before your lordship. I got an interim protection. So, my lords, there has to be a distinction made between when you will lose the law and how will you use it. Like, for instance, the same Lucknow case which we read out. There, they did not think of conducting a raid or a search. They did not think of arresting. Why do they routinely use this power? It's like brandishing this law in terror. And knowing that, I'll be on a weak wicket. I will not be able to get bail. Even now, my lords, the bail application is going to be argued. It will be argued at length. And by the time matters travel, several months are lost. So the power of the law, my lords, puts us on a greater alert. And I would urge, particularly the high courts, my lords, have to step in, because this is being abused. This power of the ED is being routinely abused, and which is a matter of great concern for the business community too. Here they've closed their business. Well, as these are people, I would submit, once they knew that they could not comply with the requirements of the statute, they closed down their operations. And now they're phasing the music after the closure of operations. Once a detailed investigation is done by the Bangalore police, the Bangalore police is satisfied with the closure report. That is ignored by the ED. A closure report is filed in August. 3 months later, in November, ECIR is registered, which is why your lordship granted us that interim protection. And here again, my lords, Telangana police is not chosen to pick up these 3 FIRs for further proceedings. No summons, no search, no arrest, nothing. Some 3 dormant FIRs are picked up, and the might of the ED is then unleashed. So, my lords, we have only the high courts to turn to, because I know this will be an argument, maintainability of the writ petition. Why are they coming to the high court? They can, of course, go to the trial court and seek bail. What happens to the loss of my liberty for a month? And probably it will be more than a month by the time the bail is decided. And there's no guarantee, my lords. The thing is this, although we have so many judgments, the trial courts are not examining the matters as they should at the stage of remand. At the stage of remand, the Constitution itself demands that even the magistrate is supposed to apply his mind to see on the lawful and legality of the arrest. But that is not happening, unfortunately. And we have to come to the high courts. And my lords, all the judgments I'm going to read out are all high court judgments. High courts have stepped up and said, we will not permit ED to misuse its powers. Some of those judgments have been upheld in the Supreme Court, which is also what I'm going to point out. So this is the broad spectrum of our case, that the present round of search and seizure, if it has yielded in any new material, we do not know what is that new material which has formed the basis of the reasons to believe. Well, it's one thing to say in the counter affidavit, oh, these are the new materials, A, B, C, and D. But that is not what the law requires. Your reasons to believe have to be based on that material. And you cannot now, well, it's old wine in new bottles, and you cannot now, by an affidavit, supplement what the law required you to do in the first place. If the law required you to form reasons to believe on the basis of material, it has to be on the basis of that material. You can't now supplement your reasons to believe with material which you do not mention in your order. That your lordship should not and will not permit. Counter affidavits cannot make up
No, that's that.
for what a reasons to believe or grounds do not contain.
That's now rudimentary.
That's
Yes,
right.
Yes.
So, well, this is the central point in the whole case. So we would maintain that, and what your lordships have done of the high courts and in the Supreme Court is, in a situation where your lordship is satisfied that the arrest is illegal, you've granted interim relief by way of an interim release, subject to conditions. So, well, let's see if I may straightaway take your lordships to the act
Have you
just for a
given the-
minute, because I don't need to read the act, but still. First, well, it's one of the arguments that's constantly made is this is a separate code in itself.
Yes, sir.
Money laundering is a separate offense. And they've gone to the extent of now arguing before the Supreme Court. And I hope Mr. Raju will not interdict now to say, don't misquote me. They've gone to the extent of saying there is no need for even a predicate offense. They've argued what if there's a closure report in a predicate offense, it does not stop the ED from proceeding under the PMLA, because the offense of money laundering, according to them, is a standalone offense and it can be pursued irrespective of the predicate offense. That was not the scheme of the act at all, Malas. This entire scheme, because you have a schedule to the PMLA, was interlinking it with the predicate offense. Anyway, if they now want to change it, it's...
But then my learned friend is referring to what is pending in the Supreme Court. The argument is this: if a predicate offense is closed, not because the predicate offense is not made out, but for a technical grounds that like a lack of sanction or that it is by way of settlement, then the PMLA offense subsists. That matter is live and kicking before the Supreme Court. So what I was arguing is that if it is not decided on merits, the predicate offense doesn't go. That was my submission. That's precisely what happened in this case, but that's a different argument.
But what paragraph 467 clause 5 of Vijay Madanal Chaudhary said was the predicate offense is, interpreting that I have myself held, that predicate offense is the foundation.
Yes.
And ED gets a superstructure on that. If the foundation falls, the superstructure would tumble down.
The predicate offense,
I've so
I'll
said that
make my
there is change in law.
I'll make my submission. But if the predicate offense falls, but if the predicate offense doesn't fall
No,
and the
but
FIR
these
is
three
closed,
circumstances which the apex
That's
court
already
says,
proving.
discharge, acquittal, quashment. On those 3 circumstances, the predicate would go. This would automatically go is what is the law. But if there's any change, then we will hear it. Yes.
there are several submissions which I'm going to make.
Yes,
One
yes.
submission is that there will be instances where the predicate goes, but the offense doesn't go. The FIR may go, but the offense doesn't go if it is not decided on merits. Like in the present case, it doesn't go.
Well,
If
it's
it is settled,
unfortunately-
No,
if the
the-
complaint is settled they're asked to settle, the predicate doesn't go.
ED springs into action not on predicate facts, but on predicate offences.
Yes.
If the predicate
On
offence
facts,
goes,
facts may be different. My
the
lords are
facts
right.
necessarily
On
would go.
facts, it may be different. Supposing
And
there are
also
1,000 home buyers.
contradicts
And
his
one
own
of them
grounds of
settled,
arrest.
that doesn't mean that the offence is gone. That is,
My-
you don't have to look at it from the individual
No,
case where there are large number
home
of
buyer's
people.
case stands on a different footing, as every home buyer has a grievance. In
Yes,
that
every
is
person
where
in a,
the addendum or addition to
I'm
the
so obliged,
ECIRs
so
was
obliged.
permitted by the Delhi
I'm
High
so
Court, I
obliged.
guess.
Every person in a gambling app who has been cheated stands on a different footing. Every person who has been cheated stands on a different footing.
We'll see.
Because there's a larger conspiracy
We'll
of
answer.
cheating so many
Actually,
persons. So whether it is home buyers or whether it's a Ponzi scheme or
All
whether
right.
it's a
We'll
gambling
see
scheme.
whether it is home buyer or a game buyer.
I make
Yes.
my submission when my turn comes. But the issue is live and
On a
kicking
lighter
before the
note,
Supreme Court that even if the predicate goes in technical
when
matters,
two lawyers were arguing,
FIR goes in
one
technical
told the
matters,
other, don't talk while I'm interrupting.
That notice has been issued and matters being heard.
That's what is happening here.
Yes, sir.
If Mr. Raju's interruptions are over, may I commence, Manoj?
Yes.
So
No,
I had to interrupt
Not,
him.
no,
He referred to me.
because
Otherwise,
he
I would
did
not
no,
have
I
referred.
interrupted,
I-
not
Very well,
Dolly.
very well.
Yes.
I would say only if
You
there's
tell
some
me,
wrong
if
statement.
my interruption is over, you can start.
Your interruption is most welcome. We should
It
know
is
what's
welcome
passing
also
through
because
your
it
mind.
makes
Yes.
the whole atmosphere lighter, my lords.
Yes, you can continue.
Well, it's actually, just to respond immediately, he's arguing against himself. Because he need not have referred to the three FIRs at all then in the reasons to believe. His reasons to believe should have simply begun by saying PMLA is a separate act. Money laundering is a separate offense. To conduct this search and raid, I don't need any other FIR.
No, that's an argument. This is caution. This is being cautious. That's an argument.
So having understood the PMLA in a certain way, at the time of arguments, you can't say, forget all those paragraphs you've written in the reasons to believe on other FIRs. I don't need those FIRs at all. You can't argue this, my lords, with the greatest respect. Your lordship should not permit it, in fact. You should not permit it. Lordship sees, just, this is carrying coals to Newcastle. 2(1)p is money laundering, which has the same meaning as section 3. Now, section 3, again, just for my own benefit, my lords.
Yes.
Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment. Just pausing here, man.
Yes.
Is actually involved in any process or activity connected with the proceeds of crime. This has to be read continuously. Any process or activity. So in Vijay Madanlal, my lords, they emphasized on this process and activity, saying you will have to demonstrate after that registration of that FIR, which is now forming the basis, what was the process or activity which you indulged in connection with that proceeds of crime. So it's not a presumption that every FIR means proceeds of crime. I'm grateful to Mr. Chowta for pointing this out to me. Section 107 of the BNSS now uses this very expression, proceeds of crime. So he's going to, I think, supplement by saying that what was the need to, even indulge in the PMLA for this round if you already had the BNSS from 1st July 2024. If you were confident there were proceeds of crime. Now, the Telangana police has not even done the first step to tell you there's any proceeds of crime at all. And, Malats, after having closed my activity since August 2025, how will this be satisfied that I was involved in any process or activity connected with the proceeds of crime? This proceeds of crime has to emanate, Malats, from these three FIRs. And unless this threshold is met, we can't even commence these proceedings. So the so-called independent standalone offense under section 3 will fall to the ground completely if you do not demonstrate dehorse these three FIRs. What is that proceeds of crime? And what was my process or activity connected with it? Well, very often they overlook this phrase process or activity. Yes. That is the trigger. So with greatest respect, in this case, if your lordship sees the reasons to believe, they do not tell us after the registration of these three FIRs, which is January 2026 and two dates, 10th and 12th February 2026, what was my process or activity connected with those proceeds of crime? Including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of the offense of money laundering. Now, Your Lordship comes to the explanation 2, because this is again important. The process or activity, why the legislature thought this phrase process or activity is important, and have an explanation for it. Process or activity connected with the process of crime is a continuing, present continuous, continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime. So, Malas, once it is clear, and they acknowledge in page 118, I think, that we have already closed our activity. If Your Lordship just notice that at page 118, I think, no? That we've already shut 116 or 118.
116 bottom, last activity shutdown is August 25. 116 bottom, above 7. So we just see from here.
Yes. Lordship sees page 116.
This is the last.
Shut down year and month. Lordship sees 2025 August. The bottom of 120. So that's the shutdown of activity. So this process and activity requirement, which is mandatory, is simply not satisfied even on a prima facie basis on their own showing. If this is the position, if Your Lordship now turns to section 19, if the director, deputy director, assistant director, or any other officer authorized in this behalf of the central government by general or special order has on the basis of material in his possession. So this is again very important. On the basis of material in his possession. In this case, well, that's why it is better footing than many of the other cases. They already had some material in their possession in November. They already registered an ECIR. Your Lordships prevented them going further with that ECIR. Now you can't pick up that very material. You can't say I'm again forming reasons to believe on that material. So when the law states has on the basis of material in his possession that he got possession of during this search. And today Mr. Raju can't file a counter affidavit saying, okay, the material in this search is this material. Please ignore what I've said in my reasons to believe. Transpose this, what I'm saying in my counter affidavit, into that reasons to believe. It cannot be permitted. Lordships have to hold them to account very strictly to the letter of the law. Penal statutes admit of only strict interpretation. So everything is procedure. 9 points is procedure in criminal law. If procedure is not satisfied, liberty cannot be sacrificed.
That's why procedure is the lifeblood of liberty.
Absolutely.
Yes.
I'm obliged. Has on the basis of material in his possession reason to believe, the reason such belief to be recorded in writing. So here the letter is satisfied. Oh, you wanted reasons to believe, record in writing. Why? I'm giving you typed itself. Neatly typed with subheadings, with tabulated charts. We know, government departments, even the super efficient ones, how long they may take to prepare this kind of a document. But that, in that hurry of preparing the document, they forgot the spirit of the law, which required this person who's authorizing the arrest to say, which is that new material he now has in his hand that justifies it. And reason for such belief to be recorded writing that any such person has been guilty of an offense punishable under this act, he may arrest such person and shall as soon as may be inform him of the grounds of such arrest. So, now I'll turn to the case law.
Before, if I may interrupt.
Please.
Now, one clarification
yes.
you may have to give by way of case law. Reasons found in the reasons to believe. Grounds found in the grounds of arrest. Whether I can, in exercise of my jurisdiction, enter upon that and say, these are the reasons.
No.
These are reasons that are not valid. These are reasons
not at all. In fact, Vijay Madhalal is very clear on that.
No. Can I interfere in that?
Mr. Raju, just a minute, Mr. Raju.
Merit-based evaluation is not.
Just a minute, Mr. Raju.
Well,
just a minute. I've heard the question very clearly.
Yes.
So, as Vijay Madhalal is very clear, this is not a merits review. This is not a merits review where you go into the adequacy of the material.
It's exactly grounds in the grounds of arrest, reasons in the reasons to believe. Am I not entering into the adequacy?
No. You're only asking, has the procedure been followed, my lords? If the procedure has not been followed, let's say he says in this grounds of arrest or reasons to believe, our search on 7th May gave us certain material on the basis of which I have now reasons to believe that this arrest is justified. I can't even argue. Please ask them to explain what was that material that persuaded them. No, I cannot argue that. The existence of materials has to be gone into, not the adequacy of the materials. There has to be some material.
That will answer.
Only that. My lords, I'm not asking your lordships to say, oh, this can't constitute reasons to believe. That cannot constitute reasons to believe.
It's what?
No, you should not also. With the greatest respect, I'm saying, my lords, but this time, as an officer of the court, your lordship should not enter into that exercise. This is a purely procedural argument. The procedure, the mandatory procedure under 19 requires you to form reasons to believe. That reasons to believe have to be formed on the basis of materials in his possession. There, your lordship.
According to the in terms of section 19, you say
yes.
it should form the reasons to believe on the material. According to you, the material should be that at the time of search and not that was earlier there.
Because you started the search.
Now the reasons and the grounds that are found are on the material that was already available and nothing sprang after the search.
Exactly. You started a process. Malas, if they had, for instance, let us say they had not undertaken the search or seizure at all. The same, it's like a review exercise. Right. In your lordship's knows section 147 Income Tax Act, that reopening of assessment on the basis of same material which was done in the scrutiny assessment. Your lordship has said you can't do that. You can't review, change of opinion, review your own order. You're not permitted to do that under the statute. So here you've started a certain process. Let's give them the benefit of what they could possibly argue. They could say, listen, we did conduct a search in November. We did come across certain materials. We did register an ECIR. The High Court has today stated that we have not challenged the order of the High Court. That High Court order subsists. Now I am a new ED officer. I say, let's not go down that route at all. Let us have another search. Maybe we left out some material. You therefore start a search proceeding. If you have started a search on 7th May.
No, there's no qualm about the search. They can.
No, they can. But the material now.
Material should
has
form
to be from
what is found in that search.
Exactly. Well, it can't be some other material which is already there, which some other ED officer has already seen.
That will answer. Yes.
Nothing can be found even in the search. Not as I said that anything can be found in the search. There can't be. Search is only on suspicion. You may not find any material.
Well, this instant response is very useful actually sometimes.
No, the ED is expected to search and then write, not research and then write. Yes.
Yeah.
Correct. That's what. That's what. Correct. That's what sir is telling.
Yes. So that incriminating material which leads you to form reasons to believe has to be the materials you now gathered. This is very important. Otherwise, my lords, it's all a misuse. I take a blind shot. I enter somebody's house. I'll try and rummage through the whole premises and try and find out something. Okay, did not find something. Oh, we already have material. Let's use that material only. This will be a total abuse of the process of law. My lords, if it does not result in somebody losing the liberty, we would not be here also. We would not be arguing so much. Right. We have no option. You are taking us on a transit remand at 5 a.m. in the morning. Look at the way this is done also, Manas. It's as if the most clandestine secret operation somehow, overnight it has to happen. Why go to this lens? This is something that one is forced to ask. What is it that is, driving them to do these kinds of things? And they are then running from pillar to post. So, Malas, this, therefore, section 19, I would submit, is not satisfied in its spirit. In letter, maybe, but I would say even in letter, when they write down, they cannot but refer to materials that they have now seized and they are now in possession of. And that does not get satisfied in the two documents I have enclosed, which is the grounds of arrest and the reasons to believe. Now, my lords, the lordship starts the earliest of the case law, which is Pankaj Bansal.
Do I have a compilation?
Yes.
Already given?
The compilation.
Madam. Compilation. This is the one? Starting with Vijay Madanlal.
Yeah, my lords,
No,
that's definitely there.
No, no, is this
But
the one
Pankaj
that
Bansal
starts
should
with
also-
Vijay Madanla?
Yes.
Yes.
If your lordship sees Pankaj Bansal first, because the facts would be close. Page 80 is where Pankaj Bansal is. Para 10, page 89.
Yes.
It was the specific case of the father and son in their writ petitions before the High Court that their arrest under the provisions of the PMLA was a wanton abuse of power authority and an abuse of process by the ED, apart from being blatantly illegal and unconstitutional. They also asserted that ED acted in violation of the safeguards provided at Section 19 PMLA. In this milieu, they made the following prayers. In view of the facts and circumstances mentioned above, it is prayed so-and-so. A, read down or read into, as well as expound, deliberate upon, and delineate the ambit and scope of Section 19 PMLA in consonance with the principles inter alia enunciated by the Honorable Supreme Court in Vijay Madanlal Chaudhary, and hold that the expression material in possession occurring therein must be confined, circumscribed, and limited to legally admissible evidence of sterling quality and unimpeachable character, on the basis of which reasons to believe could be recorded in writing, and the arrest is guilty of the offence under Section 4 PMLA. The word guilt occurring therein would qualify a higher yardstick than a mere suspicion, and the learned court at the stage of remand is required to apply its judicial mind to the grounds as well as necessity for arrest inter alia as held in Arnesh Kumar and as accorded imprimatur in Satyendra Kumar until the expression communicate occurring therein would definitely entail physical communication furnished in grounds. I'll skip that. Para 11, Malas. It is therefore clear that Pankaj Bansal and Basant Bansal did not assail the constitutional validity of Section 19 PMLA, but sought reading down and reading into the provisions thereof. Now, your lordships come to para 19. Okay. You want me to read 17? All right. Para 17, my lords, page 92 bottom. At this stage, it would be apposite to consider the case law that does have relevance in these appeals and the issues under consideration. All right. My lords, may I take your lordships to para 16? I'm so sorry, my lords.
Yes, yes.
Though much was stated and argued by both sides on the merits of the matter in terms of the involvement of the appellants in the alleged offence of money laundering, we make it clear that we are not concerned with that issue at this point. The only issue for consideration presently is whether the arrest of the appellants under Section 19 PMLA was valid and lawful, and whether the impugned orders of remand passed by the learned vacation judge, Additional Session Judge Panchkula, measure up. In that context, we may also make it clear that the mere passing of an order of remand would not be sufficient in itself to validate the appellant's arrests. Now, your lordships, the last letter D, if your lordship sees, the understanding of the ED and its misplaced reliance upon that case law begs the question as to whether there was a proper compliance with Section 19(1) of PMLA, and as to whether the learned vacation judge, Additional Session Judge Panchkula, correctly considered that issue while passing the remand orders. Therefore, as the very validity of the remand orders is under challenge on that ground, the issue as to whether the arrest of the appellants was lawful in its inception may also be open for consideration. So your lordships can ask whether that arrest which happened on 8th May in the morning was correctly done or not. Was it lawful? At this stage, it would be apposite to consider the case law that does have relevance to these appeals and the issues under consideration. In Vijay Madanlal Chaudhary, a 3-judge bench of this court observed that Section 65 PMLA predicates that the provisions of the CRPC shall apply insofar as they are not inconsistent with the provisions of PMLA in respect of the arrest, search and seizure, attachment, confiscation, investigation, prosecution, and all the proceedings thereunder. It was noted that Section 19 PMLA prescribes the manner in which the arrest of a person involved in money laundering can be effected. It was observed that such power was vested in high-ranking officials, and that apart, Section 19 PMLA provided inbuilt safeguards to be adhered to by the authorized officers, such as of recording reasons for the belief regarding involvement of the person in the offence of money laundering. And further, such reasons have to be recorded in writing, and while effecting arrest, the grounds of arrest are to be informed to that person. The last letter B and C, in between, it was concluded that the safeguards provided in the 2002 Act and the Lordship has that, page 93, the underlined portion, my lords, it was concluded that the safeguards provided in the 2002 Act and the preconditions to be fulfilled by the authorized officer before effecting arrest, as contained in Section 19 PMLA, are equally stringent and of higher standard when compared to the Customs Act, and such safeguards ensure that the authorized officer do not act arbitrarily by making them accountable for their judgment about the necessity to arrest any person involved in the commission of offense of money laundering, even before filing of the complaint before the special court. It was on this basis that the bench upheld the validity of Section 19 PMLA. Just pausing here for a minute. First register in ECIR, then go about gathering materials.
Fetching evidence.
Yes. So everything here is the other way around, my lords. Everything here. Then your lordship comes to para 19. Sendil Balaji.
Sendil Balaji?
That's referred to, my lord, Section 19, para 19.
Yes, that I've seen.
Yes. Now
You
lordship
can
comes
go
to
to Arvind Kejriwal.
para 24, my lords, just 24. In consequence, it would be necessary for us to examine how the appellants were arrested and verify whether it was in keeping with the safeguards under Section 19 PMLA.
26 as well.
Yes, I'm obliged. This chronology of events speaks volumes and reflects rather poorly, if not negatively, on ED's style of functioning. Being a premier investigating agency charged with the onerous responsibility of curbing the debilitating economic offense of money laundering in our country, every action of ED in the course of such exercise is expected to be transparent, above board, and conforming to the pristine standards of fair play in action. ED, mantled with far-reaching powers under the stringent Act of 2002, is not expected to be vindictive in its conduct and must be seen to be acting with utmost probity and with the highest degree of dispassion and fairness. In the case on hand, the facts demonstrate that the ED failed to discharge its functions and exercise its powers as per these parameters. Then, para 32, because it's very close to the facts of our case, when the second ECIR was recorded on 13th June 2023, after preliminary investigation, as stated in ED's replies, it is not clear as to when the ED's investigating officer had the time to properly inquire into the matter. Your lordship has already read it, I think.
Even 33.
Yes. Okay, I'll leave it at that. I wouldn't read
And
it.
they are directed to be released at para 47.
That's right. That's right.
So jurisdiction can be excised to release them.
Absolutely, my lords.
If they are
Absolutely.
incarcerate.
Correct.
Yes. You can go to Kejriwal.
Very well. In Kejriwal, again, para 1 is the issue for the
Yes.
legality of the arrest.
Yes.
And para 9 on preconditions of.
Para 32, reasons to believe goes into the root of the matter.
Absolutely, my lords.
So it should be
Correct.
founded upon documents and evidence.
Correct. The subjective opinion of the arresting officer must be
Yes.
founded and based on fair and objective considered
Yes.
material as available with them on the date of the arrest.
Exactly.
That is so important.
Yes.
Then 39,
Yes. Not otherwise.
yeah, reasons to believe should be, not a mere
Not,
grave suspicion.
not on grave suspicion, but on
Correct.
documents.
Correct. So 45, your lordships have seen more stringent in section 41 CRPC,
Yes.
and 47, guilt to be established on admissible evidence.
Correct.
So, my lords, again, this is very pertinent what your lordship asked. They're
No.
not asking you to look at adequacy of material or even, I would say, admissibility at this stage.
Para 44,
Yes.
if you see.
We now turn to the
In
scope and ambit.
fact, not to undertake judicial scrutiny when justified and necessary would be an abdication and failure of constitutional and statutory
Absolutely.
duty placed.
I'm obliged. I'm obliged. May I just read it, my lords?
Yes.
We now turn to the scope and ambit of judicial review to be exercised by the court. Judicial review does not amount to a mini trial or a merit review. The exercise is confined to ascertain whether the reasons to believe are based on material which establish that the arrestee is guilty of an offense under the PML Act. The exercise is to ensure that the Directorate of Enforcement has acted in accordance with law. The courts scrutinize the validity of the arrest in exercise of power of judicial review. If adequate and due care is taken by the Directorate of Enforcement to ensure that the reasons to believe justify the arrest in terms of Section 19(1) of the PML Act, the exercise of power of judicial review would not be a cause for concern. Doubts will only arise when the reasons recorded by the authority are not clear and lucid, and therefore a deeper and in-depth scrutiny is required. Arrest, after all, cannot be made arbitrarily and on the whims and fancies of the authorities. It is to be made on the basis of valid reasons to believe, meeting the parameters prescribed by the law. In fact, not to undertake judicial scrutiny when justified and necessary would be an abdication and failure of the constitutional and statutory duty placed on the court to ensure that the fundamental right to life and liberty is not violated. Then, my lords, para 48.
Yes.
The Director of Enforcement relies on the language of sections 227, 228 of the code pertaining to discharge and framing of charge, respectively. 227 uses the words sufficient grounds for proceeding against the accused. 228 uses grounds of presuming that the accused has committed an offense. Thus, the Directorate of Enforcement contends that grave suspicion is sufficient to frame a charge and put the accused to trial. This contention should not be accepted since we are not dealing with the trial, framing of charge, or recording of evidence. The issue before us, which has to be examined and answered, is whether the arrest of the person during the course of investigation complies with the law. The language of 19.1 is clear and should not be disregarded to defeat the legislative intent to provide stringent safeguards against pre-trial arrest during the pending investigations. Framing of the charge and putting the accused on trial cannot be equated with the power to arrest. A person may face the charge and trial even when he is on bail. Notably, section 439 of the code does not impose statutory restrictions except under 437(3) when applicable on the court's power to grant bail. However, section 45 of the PML Act prescribes specific fetters in addition to the stipulations under the code. Then, my lords, there's a distinction drawn between section 19 and section 45 and para 50. I'll skip that. If your lordship straightaway comes to para 82, when they refer it to the larger bench.
Yes.
And 93.
82 or 92?
93 is where they grant the relief of interim bail.
92 is where you grant.
Yes. So the
92 is
conditions
where
for
it is referred to the larger bench.
So this is as far as, well, then we have judgments of the Bombay High Court. Yeah. The first is Priyavarat Mandana, which is page 159.
Yes.
16 defense.
Mm.
The material is within the knowledge.
Sections para 16, again, when the lordship said no new tangible material, such information relating to the aforesaid three companies. No, it's okay. Such information relating to the aforesaid three companies from which funds were received was always within the knowledge of the respondents. However, till the conduction of the second search, they did not find it necessary to arrest the petitioner. This is important, Manoj. Very similar to
16, 17, 19, 20, 21.
Yes.
And even 22 to 25.
25, correct.
Where relief is granted.
Then we have Manoj, Anil Khande Rao Power. That's immediately following this. Page 169.
Yes.
Para 6, if your lordship turns to, at page 174.
Yes.
On the other hand, Mr. Anil Singh, learned ASG, extensively referred to the grounds of arrest and reasons to believe to support the arrest of the petitioner on 13th August 2025. The learned ASG would submit the powers of judicial review to interfere with the arrest order dated 13th August 2025 shall be very limited, and this is not such a case in which powers under 226 can be exercised. The learned Solicitor General relied on this decision in Radhika Agarwal versus Union of India and submitted that when the legality of arrest made under the special acts like PMLA, UPA, Foreign Exchange, Customs Act, GST Act is challenged, the court should be extremely loath in exercising powers of judicial review. The ASG has laid emphasis on paras 90 to 95, the reported judgment reaches under. May I just read it, Malats, because I'm sure this is going to be relied on. Para 91 of that quoted portion.
SLP
However,
against this is dismissed.
yes. And SLP against, yes, the Bombay High Court judgment has been dismissed.
ED cannot base its reasons to believe on hazy facts.
Exactly, Malats. Absolutely. And already material already available with you.
That's what.
So, Supreme Court orders at page 191.
Yes.
Then I'm not going to read the next two judgments. RKM Power Gen, which is the Madras High Court.
Yes.
So that, my lords, para 61 to 66. In that, para 62 is important. So if it does not trace the proceeds of crime, that's all. It's like a precondition to attract jurisdiction. Then you have Satyendra Singh Bhasin, which is at page 214.
On the same lines.
Yes. Well, it's a case law.
There must be predicate.
Well, it's the case law that
or the
yes.
Enforcement Directorate cannot metamorphose itself into a predicate agency.
The Madras High Court uses the word super cop.
Cannot
So-
become.
Correct.
Yes. So the prima facie, PML, yes, is a standalone offense.
Please, Manoj.
Standalone offense can spring if there is a predicate.
Yes.
Standalone is for the purpose of procedure prescribed for the ED to go on with it, is what let's see.
Well, it's not a Swayambhu.
Correct.
It's connected with an umbilical cord, with the predicate and the scheduled. Otherwise, the whole notion of scheduled goes. If this is the argument going to be advanced.
Oh, that's why Madras High Court says the umbilical cord is not cut.
Yes. Correct.
So
Correct.
it can continue is what is said in one of the judgments.
Correct. Para 61, if the limpet cannot work. Because I don't think I have to add anything more in rejoinder.
Yes.
I'm obliged. I'm really
Yes.
obliged.
No, it's all right. You can take your time.
So, my lord, after the, my lord, as usual,
Is
my
anything
lord,
to add?
a
Yes.
great erudite discourse.
Yes.
He leaves, my lord, nothing to chance. And, my lord, we all have been part of some evolution of this law, which are we very fortunate. He has been, my lord, on both sides. He's the only one who has been on both sides. So we remain.
Here.
He has been, like Mr. Raju, I think they have.
Even Lord Mr. Raju.
Can you speak in the mic? I can't hear you. Can you speak in the mic, please?
He wants you.
Nothing, Mr. Raju. I was saying some bad words of Mr. Chaudhary.
He was praising you, which you deserve richly, my brother. My lord, 2 or 3 quick things for a roundup. May I, my lord, just pass on a list of date note I prepared so that, my lord, for your lordship's facilitation of reference.
That's
questions
better.
also. Stop copying. The issues. Now, my lord, if your lordships would just have a quick glance. Now, my lord, what is happening here is twofold thing. One is, my lord, that the principal contention in the first case is that we are entitled to subsume or merge, that's the, my lord, language used, as many cases as we can. Even if one scheduled offense goes, my lord, we can add subsume others. Two, my lord, their argument is that even if the scheduled offense is confined, circumscribed or limited to, my lord, somebody's complaint of maybe a lakh of rupees loss in this case. Somebody has, my lord, even suffered maybe less or more. We can, my lord, go into the entire gamut of this gamescraft business right from 2017 till it ended. And we can, my lord, examine everything. That was their case in the first ECIR, and that would be their case in the second as. Today, my lord, there is a very, my lord, grave issue of, my lord, not only legal, constitutional, and public importance, but in the facts of the present case. And that, my lord, makes this case stand absolutely distinct and different from others. Your lordships, my lord, while entertaining the first ECIR, passed a, my lord, specific order granting a stay on the proceedings. Once that order is passed, my lord, I would say, apart from legality, would there be not an elementary courtesy? That's the word used by the Supreme Court in one of the cases, my lord, in preventive detention. Elementary courtesy to seek leave and liberty, even if you were to proceed by way of another case. That's one. Two, my lord, the legality of that very case, and as Mr. Chauta, my learned brother, pointed out, my lord, that we are not challenging the second ECIR, but that is inherent and embedded. Whether the second ECIR is an act of malice, both in law as well as in fact. My lord, just have a quick look at the list of dates in the manner that my learned brother pointed. I'll quickly make your lordships rush through it. So, my lord, in the list of dates which stands, my lord, first serial number 1 was, my lord, that FIR 722. The closure report, my lord, accepted, my lord, completely in 5th July 25, which is, my lord, on serial number 3.
Yes.
The ECIR, my lord, which is registered at serial number 5. And, my lord, it is a dead body, I say, because, my lord, if your lordship would see the contents on the next page, page 2 of my note. This is source is this, and then, my lord, serial number 8, details of the prima facie case. And then, my lord, they only refer to the allegations in that FIR.
722.
722. There was nothing. So I call it a dead body. And therefore, my lord, your lordships, when examined the matter, deeply. My lords granted, my lord, a stay prima facie. 17 January 26 was the petition filed with an interim prayer. 22nd January is your lordship's order. One quick date, my lord. My learned friend has already read the contents of their objections, but I must point out a date, my lord. So, my lord, please have a look at, just go a little down, my lord, and your lordships will find serial number 10. Now, see the date on serial number 10, my lord. It's 24th February. The objections filed in the first ECIR case.
722.
In 722. And my lord, they say that this Lucknow FIR was lawfully incorporated by way of addendum.
29 of 2026. Yes.
Absolutely, my lord.
26.
Now, 29 of 2026. And my
26.
lord, the addendum thus, my lord, if you also turn the next page, page 4 of my note.
26 and 24 to 2026 it is registered.
No, brother, we are talking about Lucknow FIR. Lucknow FIR. Chota sir, first.
FIR 29 of 2026.
No.
Correct. It's not 25, it's 26.
It's 26. My lord, please turn to the next page of that, the continued paragraph, page 4 of my note.
If it is 25, then their submission would be straight away correct. Yes.
My lord, see page 4 of my note, my lord.
Yes.
And that highlighted portion, my lord, of just before para 10.
Yes.
Ending para 9, I've, my lord, given emphasis.
Yes.
The addendum thus sustains the ECIR, and the very foundation of the present petition is rendered infructuous.
Correct. That's their objection.
That's their objection. Now see the next paragraph now, para 10. It is well settled that registration of additional FIRs during the pendency of the ECIR provides just jurisdiction to the Directorate of Enforcement to continue investigation by taking such FIRs on record. Then, my lord, the Delhi High Court in Rajinder Singh Chadda, first judgment relied, has held that ECI remains valid even if the initial FIR culminates in closure, so long as subsequent FIRs relate to the same project or criminal activity. The Punjab High Court in Irio, second judgment, Arvind Walia upheld the subsuming of multiple FIRs into single FIR. Then, my lord, the last 545 lines, similar views have been expressed by Allahabad High Court in Bhasin and Hamara India Credit, wherein it has been held that new FIRs can be added to an existing ECIR by way of addendum. Now, my lord, that was the understanding on 24th February. The second ECIR date is, my lord, interestingly, 23rd February. That's, my lord, 23rd February.
Yes.
And in the statement of objections,
that is
there is nothing
registered in Telangana.
That's, my lord, on the basis of FIRs which are registered in Telangana in, my lord, January and February 2026.
That is 23rd February.
23rd February is the ECIR.
ECIR.
Yes, my lord.
Yes.
So 24th objections filed. They do not mention this fact that they already have a second ECIR on the basis of some subsequent, my lord, FIRs which have been recorded during the pendency of the, my lord, present petition. They do not bring that fact to the notice of this honorable court. They do not seek any leave and liberty. The question, my lord, is of preemptory, my lord, a prime importance here. Apart from, my lord, I'll come to the material part, just want to substantiate on that. The first principally, my lord, I have formulated certain issues, my lord, if your lordship would allow me to read them. That may be, my lord, worth examining by your lordships only in the peculiar facts of the present case. Just give it to sir also. Now, my lord, I have divided my issues into 3 brackets. The first issue is, my lord, second ECIR itself, the sustainability, as I, my lord, just narrated. That if there, my lord, if they can subsume or merge whether prior FIRs or subsequent FIRs, where was, my lord, their embargo on treating these Telangana FIRs also into the first ECIR? There was no requirement of, my lord, having a second ECIR over the same subject matter. 2, my lord, why, my lord, they are claiming everything in the first ECIR to be part of the second ECIR? Because according to them, they can look at the entire business. These 3 Telangana FIRs, my lord, some are for very petty amount. Maximum one is, my lord, stretching over 1 crore of rupees. Out of the 3, 1.85, rest are in lakhs. So, my lord, there is a 50,000 also out of these 3 FIRs. So, if they can examine the entire, my lord, business of Gamescraft, then they could do it even in the first ECIR. What is this was so special in the second ECIR, which is confined to that ECIR alone, and they cannot touch the first ECIR.
That's because it is stayed.
Yes, my lord. And that, my lord, gives rise to a contumacious conduct, according to me. And that brings my case of arrest in section 62 of the PMLA, my lord, which, my lord, proscribes vexatious arrest and an action to be taken. That's what Vijay Madan Lal Chaudhary, 3 judges bench held, that these are stringent safeguards. Any violation or deviation would lead to such an action. This may be one of those cases, my lord, where this courtesy is even not shown. It's some, lord, I would say, a circuitous way to overreach the orders passed by this court. So first issues, my lord, A to D relate to that. Have the list of the second issues, my lord, the violation of 19(1). Your lordships asked, my lord, there was pertinent question. My lords read few paragraphs of Kejriwal. My lord, I must tell your lordships, my lord, how this law has evolved, my lord. It's a grave evolution forward. It remains a work in progress. More than 123 amendments. And I can tell your lordships, since 2016 onwards, we have been filing, my lord, petitions all over the country. And whenever, my lord, an issue arose, there was a corresponding amendment made by way of explanations or otherwise. 123 amendments in total, I believe, or maybe more, my lord, have been carried out in the act. My lord, the section 19, 1 and 2 have to be read together, my lord, and they use about 5 expressions, my lord. First is, my lord, material in possession, based on which already in possession, therefore, my lord, reasons to believe to be recorded in writing. That writing is, my lord, for the purpose of arriving. Third word is, my lord, third expression is guilt. And, my lord, after the guilt, they say inform him of the grounds of arrest. So 4 expressions used there, but section 19(2), my lord, uses another expression. It says the moment you carry out this arrest, you forward the order of arrest. Now, this is a new word, order. 19(2) uses the word order of arrest. Order of arrest along with material to the adjudicating authority. Now, my lord, order word is defined in the arrest rules. They were also, my lord, notified on 1st July 2005 itself. That order means, my lord, the order includes ground of arrest and there's a format given. So there are total 3 forms prescribed, my lord, and in the arrest rules. Form 1 to relate to, my lord, immediately sending the material in a sealed envelope to the adjudicating authority and taking its acknowledgement. And form 3 relates to, my lord, the arrest order. So they were following, my lord, all along, my lord, all along in the entire country. They never used to first give grounds of arrest. The judgment came, my lord, starting from
Pankaj Bansal.
No, my lord, it came earlier by Delhi High Court by none other than the person who was the author. Now he's, my lord, the speaker. So, my lord, so that judgment came, said grounds of arrest must be given. Because why would you record reasons to believe in writing if it was not to be communicated? And reliance was placed in a constitution bench by Delhi High Court, my lord, in CB Gautam's case, in income tax, my lord, enactments.
Yes.
My lord, that law is now followed. Then comes, my lord, grounds of arrest in Pankaj Bansal. That, my lord, you have to give all across. We argued that, my lord, they give it in Bombay. They give it, my lord, sometimes, my lord, they've given it in other states. But, my lord, in North India,
That
not
is by far, it's now settled.
Second-
Grounds of arrest. is
Second, my lord, came, I would say, my lord, skipping 2-3 lines straight and coming to, my lord, Arvind Kejriwal, where, my lord, they said reasons to believe.
Will continue at 2:30.
Yes.
That's one.
I'll be very quick, my lord. I'll try and wind up, my lord. Won't take much.
Lord, at 2:30, I have a matter, my lord. May I only mention? No, I have a matter.
Yes, sir.
I have a matter at 2:30 before the division bench of this court, my lord, Karnataka High Court. So
Yes,
my
sir.
turn. That's a longish matter, my lords.
Yes, sir.
So may I request
So,
for my turn
will-
tomorrow?
tomorrow?
Tomorrow.
No, since they are
Tomorrow
they are in
Tomorrow
custody.
at 2:30. They may complete tomorrow at 2:30, my lords.
Yes, yes, no problem. Yes.
Yes.
Lord, may I mention, my Lord,
Please.
You,
list number 2.
then all of you complete today. The learned will have it tomorrow. Yes.
Deeply.
Lord, may I seek indulgence, my Lord?
2:30 for respondent submission. Yes, Sriranga.
Lord, secondly, 17th matter, kindly grant me not accommodation till tomorrow. Lord, I am in some difficulty, my Lord. Even other side wanted time. Kindly tomorrow, my Lord, I am ready with the matter. I have some difficulty today. It's passed over.
All right.
Tomorrow. Right.
Second list 27.
Madam, admission matters, whoever want time, take it.
Serial number 27, Your Honor, second list, withdrawing the case.
I am Rajkumar Shanbhog, adopted son of P. Balakrishnan and Radhika Bhishane.
Ayo, what do I have to do with that? ಏನ್ ಹೇಳಿ?
Just ತಾವು ನಿನ್ನೆ ಎಲ್ಲ ರಿಲೆವೆಂಟ್ ಕ್ವಶನ್ಸ್ ಕೇಳಿದ್ರಿ.
ಯಾರಿಗೆ?
ಆಯ್ತಾ, ನಮ್ಮ advocate ಗೆ as well as I saw it in the
ನೀವು
YouTube.
ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರಾ?
ಇದ್ದಾರೆ.
ಇದ್ರೆ ಅವ್ರಿಗೆ ಬರಕ್ ಹೇಳಿ.
ಸರ್ ದಯವಿಟ್ಟು ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಏನಂದ್ರೆ ನಾನು ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ತೀನಿ ತಮ್ಗೆ.
ನೀವು ಅವೆಲ್ಲ ಮಾಡಂಗಿಲ್ಲ ಇಲ್ಲಿ. If your advocate is there, come through the advocate. Or you go before the committee and appear in person. This is not trial court. All right?
But
No, but you can't butt in like this.
no, on clarity ಕೊಟ್ರೆ.
Clarity, give it to your advocate.
But
Madam, serial number 36, list 2.
Please, I am not going to argue. Who can say that who registered? In February, May, there is no. You file a reply on the PDF. You don't need to disclose that you registered. The only activities that you carried out in the search के बाद आप इसने एकदम से क्या मटेरियल आ गया, right? Don't say that the same material was not found sufficient there. That's a wrong argument. Your argument is so. My Lord, since my learned friend Mr. Raju has given me a little more time, I'll, my Lord, like to read in about little time that I will take, my Lord.
Yes.
I was going to.
One second. You can.
Yes, my Lord.
Yes.
My Lord, please turn to my list of date note.
Yeah, I'll just get them one second.
The, my Lord, endeavor is to, my Lord, make the arguments that have already been made, my Lord, little more potent. That's all. Something, my Lord, on facts.
Yes.
My Lord, your lordships may just see it serial number 13 now.
Madam, ಅದು ಎಷ್ಟು ಕೊಡಿ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಎಷ್ಟು ಕೊಡಿ ಅದಿಲ್ಲ ಇದ್ರೊಳಗಿದೆ ಅನ್ಸುತ್ತೆ it's here. Yes.
List of date note, my Lord.
Yes.
If your lordship would turn to, my Lord, serial number 13.
Yes.
So, my Lord, at serial number 12, I had given a heading that registration of the second ECIR is an abuse of process of law.
Correct.
And my Lord, now see 13. So, my Lord, the ECIR is registered, as we now come to know, on 23rd February.
Yes.
24th February, they file an affidavit before this court in the first case. There is no disclosure. We don't even know about it. Now, my Lord, 8th May, after about, say, my Lord, 1.5 months or more, they, my Lord, 7th May, they come, my Lord, for searches. Now, see the dates at page 5, my Lord, date and timing.
Yes.
So, my Lord, they come at 7:35 a.m., 7 a.m. and 7 a.m., these three places. Two people are in Gurugram, my Lord, Prithvi Singh and Deepak Singh. The third one, my Lord, please note, Vikas Taneja is in Bangalore.
Yes.
So they come at, my Lord, 7:35, 7 a.m. These searches last till, my Lord, everywhere till 4:30 a.m. First one is 4:05, rest 4:30 a.m. So this search, my Lord, is continuous. Please note the timing for 22 hours. I'm reading, my Lord, on the next page. 22 hours search going on. Now, my Lord, the arrest is shown. I'll come, my Lord, to the arrest part, and your lordship will find serial number 14.
Yes.
Where, my Lord, the arrest is shown at 2:30 a.m. on 8th of May.
Yes.
In another, my Lord, 4:50 a.m. after search, Deepak Singh.
Yes.
The third, my Lord, Vikas Taneja at 3:30 a.m.
Yes.
So the whole process is, my Lord, up 24, almost, my Lord, 22 hours or 21, 22 to 23 hours. Continuously, person engages with you. During search, you are at his house. Then, my Lord, at mid of the night, you say that now I'm going to, my Lord, early wee hours, I'm going to arrest you. This is, my Lord, first. Your lordships, the issue arose before the Bombay High Court in Ram Kottu Malisrani. at serial number 13, my lord, just a page above, I've, my lord, given that Ram Kotumalis Rani, the Bombay High Court, my lord, a division bench, said that this is extremely unfair and uncalled for, that you call people, my lord, at wee hours, continue to record their statements. This is harassment, violation of fundamental rights. This judgment was, this is, my lord, right to sleep, they said, is a fundamental right. And right to blink is a fundamental right. So, my lord, they took this matter to the Supreme Court. The, my lord, SLP is dismissed. And, my lord, the ED itself, my lord, acquiesces into the order. And, my lord, issues a circular and guidelines that this should not be done. So this is,
Where do I get that?
yes, my lord. I will just pass on the circular, my lord. The judgment I've extracted.
Judgment is here. Where the
Yes, my lord.
circular?
I'll get that. I'll get that. There is a press release also of 29 January 24.
Both I
which,
want.
Which, my lord.
The press release and the circular.
And the circular.
Yes.
I'll just pass on.
Yes.
Now, my lord, your lordship would now see, my lord, the arrest is made. I'm going a further, my lord. Now, two people in Gurugram, the first and second, my lord, Prithvi and Deepak, they are now taken to a court, my lord, in Gurugram for transit to Bangalore.
Ah, correct.
Same
Transit,
very moment.
Transit warrant is. Yes.
So, my lord, that transit warrant is granted and they are produced eventually, my lord, before, my lord, the court at, my lord, Gurugram, my lord, if your lordships would see serial number 15.
Yes.
At page 7.
Yes.
Sorry, wait. Relax. At 6:15 a.m., my lord.
Yes.
Transit remand is early morning, 6:15 a.m.
Yes.
I'll read, my lord, come to the reasons later. Please have a look at now serial number 16, my lord.
Yes.
Mr. Taneja is produced at 6:10 a.m. before, my lord, the sessions judge at Bangalore only.
Yes.
My lord, the serial number 17. One day after, 9th May, they are now produced at 7:30 a.m. My lord, on it should be 9th, my lord, it's written 7th in my note. So 9th May they are produced. My lord, arrest made on, my lord, 7th May at 4 a.m. or 2:30 a.m. or whatever, my lord. Produced before the court at magistrate. This person has been for more than 48 hours. The search started at 7:30 a.m. in the morning in their custody. Now, having this timeline in mind, two questions will arise, my lord. Apart from, my lord, the reasons and material, my lord, two questions will arise. The first question is, was the arrest necessary? Because this was the first day of activity in the second ECIR. Now, this is the horse my argument, my lord, that second ECIR is completely bad in law. Where was the necessity? Necessity has been, my lord, incorporated as a doctrine in, my lord, Vijay Madan Lal Chaudhary itself. While dealing with it, para 322 and 325 of Vijay Madan Lal Chaudhary says, apart from, my lord, satisfying the safeguards under 19, the officer has to demonstrate that there is necessity to arrest. Okay? So that, my lord. Two, my lord. Second, that, my lord, your lordships will have seen, and I'm going to show it further, that, my lord, whatever materials they seek to rely upon for the purpose of arriving at satisfaction of guilt, reasons, recording reasons to believe, was the material actually in the first ECIR. Whether it was the search carried out in November 25, whether the data collected from there, and that has gone into the mind-making formation. I call it, my lord, fruit of a forbidden tree. Fruit of a forbidden tree. From 22nd January 26, when your lordships interdicted the proceedings and said that there will be stay of further proceedings. Where is the question of, my lord, with utmost respect, my lord, even on 24th February, your lordships granted, my lord, stay on 22nd January. The addendum has been made. Addendum, so-called, my lord, that Lucknow FIR, has also been made subsequent to the stay order.
Correct. Subsequent to the
Subsequent to the stay order, when the proceedings remain stayed. Whether they could do it or not, another question that your lordships will examine, my lord, in the first case. Second, my lord, the third aspect, and very critical, my lord, that, my lord, the same material at the earliest point in time, till January 26 that your lordship stayed, was never considered as potent enough for arrest. I'm not saying that they could have arrested or could not have arrested. I'm saying you did not think it necessary to arrest at that point of time, my lord, till 22nd January. How has it become relevant by registration of the second ECIR on the same basis, my lord, that you are relying upon the same material? Now, my lord, a quick glance at two documents that I want to show, and my lord, I have extracted some in my note. All right. My lord, serial number 14.
Reasons to believe.
Reasons to believe. Now, my lord, just have a look at a
They
glance.
are different from the other case?
Oh, no, my lord, they're same. They're same. My lord, I'm just reading those lines. Maybe, my lord, my learned brother had not read it.
Yes, yes.
My lord, that's why. So, my lord, 1.5, reason to believe 1.5, I'm
Yes.
expected. Complaints filed by victims through email to the accused company. Apart from the complaints received by the NCRB and FIR registered against the company, the accused company itself had received lakhs of grievances from its users who were victims of, Lord, in the next page, the fraudulent activities carried out by the company, and also notices under 91 CRPC from the law enforcement authorities of various states. These data was seized during the search conducted under 17 at the premises of Gamescraft in the month of November 2025.
That is pursuant to 722.
Yes, my lord. And now please have a look at the relevant part of their objection immediately from here. In the first ECIR, the document has been circulated, my lord, by Mr. Muralidharan to your lordship. Please have a look at that objection. Just one paragraph, my lord, paragraph 6.
Yes.
Of the earlier objections, my lord. Just have a look at, my lord, page 154, paragraph 6. My lords have it, my lord?
That's what you have quoted.
No, no, not quoted.
Oh, that's different.
That's different, my lord. I'm sorry. The objections filed by the ED in the first ECIR, in the 722 case.
No, it is given here.
It was given, my lord. My learned friend relied upon this paragraph, but my lord, I'm
Paragraph
not sure.
6, right?
Paragraph 6, my lord. I think it's the same. Because they are going to in the first ECIR also, they are relying on the same document. That's what I'm showing. At the time of recording of reasons to believe, on 11th November 25, and authorization of searches under section 17 during 1811 to 2211-25, the directorate had no knowledge of the closure of the FIR 722-24. It is submitted that reasons to believe were not solely made on the basis of FIR number 722, now mark this word, my lord, but various other complaints available on the open web source against the petitioners.
There was nothing on that day.
No, my
What
lord.
other FIR was there on that?
My lord, there was nothing.
Nothing.
There was nothing. But my lord, what they've said is that there were complaints made on the portal of the company. That's what they're showing me the present reasons to believe. I am, my lord, wanting your lordship to see it in juxtaposition with the present reasons to believe for my arrest today vis-a-vis their stand in the earlier case. It's the identical, my lord. It's a fruit of that same tree, and I call it a forbidden tree by virtue of your lordship's order of stay, because that has come on 22nd.
It's forbidden because of the interim order.
Correct.
If it were to be quashed, it would be poisonous.
It will be poisonous. Correct.
Fruit of a poisonous
Correct.
tree.
Absolutely, my lord. My lord, go back to my note now
Yes,
again.
yes.
Okay, my lord, your lordships would now see. My lord, in the note at, my lord, I was reading at page 6.
Yes.
No, my lord, see the, my lord, extract that I've said, my lord. Thus, from the above, it is clear
Yes.
that all, my lord, may skip this, my lord. Just have a look at the next one. This is at page, my lord, 115.
No, that is serial number 15, is it?
Yes, my lord. It is serial number 14.
14, yes.
14. And my lord, I have seen thus from the above, the second paragraph at page.
Yes, thus from
6.
the above. I'm
Then, my
there,
lord,
yes.
further, one
Correct.
down, my lord.
Yes.
Just correct that page, my lord. We have said page 190. It is actually page
Yes.
115.
Yes.
So, my lord, further during the search proceedings conducted on 7/5/26, statement of Prithvi was recorded under 17, with which he was asked to explain the above transactions. However, he has not given any plausible explanation, and therefore further investigation is needed. Which transactions? The same transactions, my lord. Then November.
722.
Yes, my lord.
Yes.
Further, there are reasons to believe that Prithvi Raj, director of so and so, is in possession of material evidence and information. I am giving, my lord, what are the reasons for arrest? First reason, he has not given explanation. Second reason, my lord, he is in possession of material evidence and information relating to the offense of money laundering. What material? What information? Nothing disclosed. Three, my lord, which is subject matter of investigation, and the custodial interrogation of Prithvi Raj is necessary to establish money trail proceeds of crime and to gather crucial evidence. Again, my lord, if I'm guilty, Lord, I must tell your lordships, just take a 1 second detour. This was the first provision of its kind in any legislation in India, which said, my lord, that prior to arrest, you would have material which would show guilt. Otherwise, my lord, suspicion. If you are suspected of committing an offense under 41 CRPC, my lord, anybody could be arrested, my lord, within those yardsticks. Today, my lord, this was the first legislation. He says, I have to identify the money trail of proceeds of crime, gather crucial evidence. What money trail? What evidence? Nothing mentioned. See, my lord. Further, for furtherance of investigation, custodial interrogation, mark the word investigation. Now, my lord, Kejriwal, I'm going to read with your lordships quickly, my lord. And I'll show three more things, my lord, for Kejriwal, my lord. I'll just quickly, my lord, take me to Kejriwal. Yes. Yes. My lord, may I have the liberty of circulating case extracts of the judgments, my lord? I've just culled out some paragraphs only.
Yes, give it.
My lord, the press release also we've got about that circular.
Yes. Yes, sir.
Now, tell me, Kejriwal. My lord, may straight away go to Kejriwal. It was a, my lord, huge leap forward when, my lord, reasons to believe came. But, my lord, now in Prabir Purkasta, before it, my lord Justice Mehta speaking for the bench, and my lord Kejriwal, my lord, Prabir Purkasta relied upon preventive detention law. That same, lord, when the arrest order is being passed, that means the officer has to arrive at the satisfaction of guilt. He has to have the materials before him.
It made it applicable to every offense.
Now, my lord, after Radhika, it is applicable to all. Applicable to all, because the word commit has been, my lord, equated with the word guilt. That also happened to be, my lord, I happened to be part of that. Radhika Agarwal, I argued, my lord. That, and my lord, the Supreme Court has actually now held, they were used to argue all along. My learned friend, Mr. Raju, and I have been, my lord, together, of course, as my lord, opponents in the courtroom in all these cases. And their argument was that Kejriwal is not a judgment, it's not a ratio, it's a reference order. But, my lord, I'll show from Radhika that it is a ratio. And the Supreme Court has said, we have laid down the ratio of Arvind Kejriwal will apply here. So, my lord, now please read Kejriwal in that light. In my note, my lord, this case extract note, could your lordships go to page 10? All right, please come back to it.
Yes.
Now, my lord, my endeavor is to show the law to your lordships, what has evolved here. So, my lord, the first paragraph, my lord, A, B, C, D, your lordships may skip because this was, my lord, about what is the duty of the court, etc. It's a bounden duty of the magistrate to apply his mind. 19 stringent safeguards. Vijay Madan Lal Chaudhary, my lord, ground I at page 11. Vijay Madan Lal Chaudhary, your lordships will find. Then, my lord, just come to, my lord, straight away to my lord, para K. That, my lord, it is a drastic power. It's in fact para 20.
Yes.
I have given, my lord, that alphabetic order in my own words, but, my lord, otherwise it is exactly the replica. It's extract from the judgment. It's a quote. Now, my lord, see L for a moment now, my lord. Given that the legislature has prescribed preconditions to prevent abuse and unauthorized use of statutory, the wielding of such power by an authorized person or authority cannot be conclusive. The exercise of the power and satisfaction of the conditions must and should be put to judicial scrutiny and examination if the arrestee specifically challenges their arrest. That's, my lord, the cause here. Now, my lord, please go to the next one. And your lordship will see paragraph N, my lord, page 12.
Challenge in the case at hand is to the arrest.
Arrest and remand orders, both. Lord, see page 12, paragraph N. My lord, please see paragraph M. Sorry, my lord, one line before.
Yes.
This is the argument made by Mr. Raju himself. It has been argued by DOE that power to arrest is neither an administrative nor a quasi-judicial power, as the arrest is made during investigation. Judicial scrutiny is not permissible, as it will interfere with investigation. This was the argument. And now, see, my lord, the next paragraph, it's para 22 and next paragraph is para 23. We do not agree and must reject this argument. We hold that the power of judicial review shall prevail and the court magistrate is required to examine that the exercise of the power to arrest meets the statutory conditions. Now, my lord, please see the, my lord, ground O at para 23. They also say, my lord, the power of judicial review will be before or after the filing of the complaint. Now, my lord, P is very important. From here, my lord, they built up the case for material. The, my lord, may please note that the expression material had never undergone the scanner of the Supreme Court in Vijay Madan Lal Chaudhary. And I take, my lord, one more second. Pankaj Bansal also happened to be, my lord, a case which I argued in Chandigarh and then to, my lord, Supreme Court. In Pankaj Bansal, my lord, when I, my lord, I settled those prayers, I said read down the expression material, etc. in section 50. The Mr. Raju only came. He said that, look, when Supreme Court has decided that section 50 is intra vires, you cannot have a challenge again made here. The Lord High Court rejected my argument and said this petition we cannot grant you these reliefs because the law is settled in Vijay Madan Lal Chaudhary. So in Pankaj Bansal, my lord, there is one more paragraph which your lordships may consider. And my lord, please go to Pankaj Bansal for a moment, my lord. In the same note, your lordships, yes, my lord, I think your lordships must have the judgment because we've not also extracted it.
No problem. That's clause 8.
My lord, paragraph.
No, note you have not extracted that?
No, not extracted. Lord. So your lordships would have a look at paragraph 10 and 11 of Pankaj. May I pass on?
I have the judgment.
Judgment your lordships have. See, my lord, if your lordships have that SCC online edition.
It was the specific case.
Yes, my lord.
Yes.
No, my lord, your lordship may just read the prayers extracted here.
Yes.
Read down. Your lordship, read
Expound
down section
yes.
91, expression so and so, expression material in possession. Now go to my lord, paragraph 11. It is therefore clear that Pankaj Bansal and Basant did not assail the constitutional validity of 19, but sought reading down and reading into the provision thereof. Now, my lord, further, they asserted that the remand orders were passed in a patently routine and mechanical manner by the learned vacation judge Panchkula without satisfying himself about due compliance with the mandate of 19, and more particularly, whether the threshold requirements of provision were duly satisfied. In consequence, they prayed for a direction to quash the remand orders as well as the underlying arrest orders and arrest memos. Now, my lord, see paragraph 12. And this is, my lord, I think a game changer, a paradigm shift. Though the appellants did not challenge the constitutional validity of section 19 in their writ petitions and had only sought reading down and reading into the provision thereof, in the light of the judgment of this court in Vijay Madan Lal Chaudhary, the division bench of the Punjab High Court failed to note this distinction and disallowed their prayer under the mistaken impression that they were challenging the constitutional validity of the provision. The finer connotations and nuances of the language used in 19, to the extent left uncharted by this court in Vijay Madan Lal Chaudhary, was still open to interpretation and resolution. And therefore, the High Court would have been well within its right to undertake that exercise, be that as it may. Now, my lord, from Pankaj, we go back to my lord now Kejriwal, back my lord to my note. And your lordship will see how this word material has given at least 4 different connotations, my lord, which had hitherto not, my lord, met the ambit of judicial review of the Supreme Court at least.
Correct, but that has become immaterial to the ED.
Yes, my lord, that's unfortunate. And they still interpret it, my lord, in a manner, but my lord, I leave it to that. The manner of interpretation of a judgment also, my lord, the judgment has to be read in a balanced. And my lord, it only applies to the given facts of a particular case. We don't read the judgments as arithmetical theorems, my lord. But the unfortunate aspect is that, my lord, when the DOE does not recognize the settled position of law and goes, my lord, in violation. And I can't see, my lord, more egregious case of, my lord, violation of the procedure as in the present case because of your lordship's stay order. And that, my lord, bothers me a lot. That what you couldn't do directly, you have sought it to, my lord, you have actually done it indirectly. My lord, please have a look at a few paragraphs, my lord, further in my lord, Kejriwal, page 12. Page 12, my lord.
I am there.
Please. So, my lord, please have a look at para P first, my lord, para 27. P. A higher threshold is required for making an arrest, necessitating a review of the material available to demonstrate the person's guilt. What is review, my lord? Your lordship's review. Judicial review vis-a-vis merits review. See, my lord, now suspicion and, my lord, reason to believe that, my lord, your lordship may skip. Just come to, my lord, paragraph R, my lord, it's para 31. And, my lord, the authorized officer's genuine belief and reasoning based on evidence that establishes the arrestee's guilt is also the legal necessity. You have to have genuine material. Then, my lord, as the reasons to believe are accorded by the officer, the onus to establish satisfaction of the said condition will be on the DOE and not on the arrestee, my lord. This is, I think, the most critical line that I hold it close to my heart. Your lordship said something about, my lord, procedure being the handmaiden, my lord, for any person's liberty, my lord. We read preventive detention law, and, my lord, the one line which, my lord, appeals to everyone is history of liberty. is history of procedural safeguards.
Correct. That's
Well,
why procedure is lifeblood of liberty.
Right, absolutely, my lord. Absolutely. Now, my lord, see, my lord, the next one, it's para 32. The subjective satisfaction of the arresting officer must be founded and based upon fair and objective consideration of the material as available with them on the date of arrest. On the reading of the reasons to believe, the court must form the secondary opinion on the validity of the exercise undertaken for compliance of 19(1) when the arrest was made. Reasons to believe that the person is guilty of offense under PMLA should be founded on material in the form of documents and oral statements. My lord, I pause here. This is the material. What is material? Documents and oral statements. That's my first understanding of the word material as expounded by the Supreme Court. My lord, please see, my lord, the next one. And this is, my lord, extremely important. I think para 39's quote in T, my lord. Clearly, reason to believe has to be distinguished, and it is not the same as grave suspicion. It refers to the reasons for formation of belief which must have a rational connection with an element bearing on the formation of belief. The reason should not be, my lord, please mark, extraneous or irrelevant for the purpose of the provision. My lord, they have used the word irrelevant and then relevant eschewed or irrelevant considered. Either which way, my lord, the rest will be bad. Now, my lord, I ask one question only, my lord. When this officer, my lord, registered the ECIR, or, my lord, he carried out search, or, my lord, he carried out arrest, did he even mention that this is the second ECIR and it is entirely different from the first case where your lordships have granted a stay order? If that material has also not gone into his mind-making formation, my lord, it is malice in law writ large, malice in fact writ large. He should have, my lord, dealt with it because it is his duty to satisfy, not mine, my lord. He has to say that, my lord, that I have considered that ECIR relates to X facts and I have a right to register another case. Despite that stay operating, I can continue with this. If he doesn't do that, my lord, I'm not saying question whether he can do it or not. No, I'm not on that, my lord. I'm saying this is eschewing of relevant material. And, my lord, then his reasons become irrelevant. So, my lord, this is one. My lord, if your lordships would have a look at, my lord, next paragraph U, para 41. Once we hold that accused is entitled to challenge his arrest under 19(1), the court to examine the validity of arrest must catechize both the existence and soundness of the reasons to believe based upon the material available with the officer. My lord, I'm harping on the word available because I'm going to argue something on 19(2). The material is, my lord, logged in time. It was that day, material in possession, he puts it in a sealed envelope and sends it to the authority. He cannot deliberate beyond those, my lord, materials when he comes to the courtroom, even in his remand application or in defense to the present date petition. So, my lord, the question which is your lordships are going to, my lord, going to examine this in my writ today is whether 19(2) is complied with. In form first and in substance. Did the magistrate or, my lord, the court, whether transit court or the main court, have an opportunity to examine that what materials are the basis for your reasons? Reasons are, my lord, merely narrative of the officer. It is factual inferences drawn on factual materials. Where are those materials? Nobody has seen them till date. They have not produced even here. So we don't know what was logged in time on that day. So, my lord, that non-compliance or non-application of the mind to the magistrate to form a secondary opinion, that's what the Supreme Court said, is equally fatal. Now, my lord, please go to the next one. W, my lord, straight away, your lordship. My lord, in W, my lord, they are saying that you can give reasons. If you think that something is sensitive, then, my lord, you can redact. Is a redaction. See, my lord, X, this para 42. Your lordships have, my lord, read it, probably, my lord.
Yes.
So, my lord said that judicial review, my lord, it is, my lord, I just want to read 3 lines, just at page 13, ending 3 lines, doubts will only arise. Doubts will only arise when the reasons recorded by the authority are not clear and lucid, and therefore a deeper and in-depth scrutiny is required. Arrest, after all, cannot be made arbitrarily and on the whims and fancies of the authorities. And then they talk about, my lord, your lordship may just come to straight away, my lord, to why. This is para 47. And, my lord, admissible, my learned friend read, and cannot be based on inadmissible. Now, what is admissible, my lord? What could be admissible evidence? To my mind, my lord, as a student of law, that admissible evidence is one which is collected during the course of investigation. Supposing, my lord, in the predicate offense, a full charge sheet is filed.
That would be the evidence.
My lord,
That can become the material.
that can become, my lord, material. But, my lord, that admissible evidence is that material has to be gone into by this agency. My lord, we have a celebrated case in, my lord, my lord, I'll just give the citation. Other material, my lord, where Income Tax Act proceedings gathered some material and the custom authorities relied upon that material. My lord, the Supreme Court said you cannot KM Abdullah, my lord, KTMS Muhammad. Thank you. KTMS Muhammad, my lord, I rely upon it consistently. That one agency collecting material, you can, that's a starting point for you to investigate. But you can't say, my lord, if supposing somebody's statements under 50 are recorded, can the police say, I will not record your statement under 161, those statements are my evidence for charge sheet? Cannot be. So, my lord, something like that. Second, my lord, whether this admissible test, so statement, my lord, which is not recognized in law, or, my lord, for which, my lord, there is some, my lord, forbidden, like, my lord, a statement recorded in custody. Whether, my lord, that could be relied on things like that. Your lordship may please go to, my lord, paragraph straight away, my lord, to, my lord, yes, paragraph double C, my lord. Arrest for Z. I'm sorry, my lord, paragraph Z, my lord. And I want to read one more line there. Though, my lord, my learned senior colleague had earlier read. This is para 47. Power to arrest is not for the purpose of investigation. Mark this, my lord. And I have shown reasons to believe it is only for the purpose of investigation. Arrest is made during investigation, of course. But, my lord, is not for the purpose of investigation. That's the word used by the Supreme Court of India. Arrest can and should wait. And the power in terms of 19 can be exercised only. Now, my lord, I feel that only word is the biggest, my lord, cog in the wheel here. Only when the material with the officer enables them to form an opinion by recording reasons in writing that the arrestee is guilty. Now, beyond that, there is nothing. You can't say, I have to discover from him. He is evasive. He is not cooperating. I wish, my lord, that the lordships have read those paragraphs in Pankaj Bansal. So, my lord, non-cooperation, evasive, you're not answering, I have to establish money trail, you might destroy it.
Oh, nothing that has ensued in this case.
My lord,
your non-cooperation, there is no recording that you have not cooperated.
They have said, my lord, in the remand application that when they came to my house during search, I was evasive. So there is, I could not explain. They wanted me to explain, look, this is an Excel sheet we recovered in, my lord, November 25. In November 25 in first ECIR, what is this Excel sheet about? And he refuses to explain it. Therefore, I'm going to arrest you. I must show, my lord, maybe one more provision. Either your lordships have seen it probably earlier. See section 63 for a moment, my lord. Since I have time, my lord, I'll utilize it only to, my lord, demonstrate. See section 63, PML. Please. Now, my lord, section 63 is divided into 4 parts. Just read 63(2) for a moment.
Yes.
First, my lord, the head note itself.
Failure to give information.
Yes, my lord. Just one minute. I go, my lord, off track, and the colleagues assisting me have a hard time. I harass them, my lord. That's the problem. Punishment for false information.
Yes.
Or failure to give
information.
No, my lord, this is covered. Now see 63(2), my lord.
Yes.
If any person, and then straight away come to C, my lord. C.
To whom a summon is issued under section
under 50, either who tend to give evidence or produce books of account or other documents at a certain place and time, omits to attend or produce books of accounts or documents at the place or time. And before that, my lord, refuses to sign statement made by him. And before that, legally bound to state the truth of any matter relating to, refuses to answer any question. What will happen, my lord? He shall, by way of penalty, pay, my lord, a sum of which is not less than 500, but which may extend to 10,000. But, my lord, 63(3) says even for that purpose, he will have to issue me a show cause. And see, my lord, 63(4), that I can be prosecuted under 174 IPC. It's a cognizable, bailable offense. And I can tell you, lordships, my lord, I have more than dozen cases with me right now, where, my lord, they have taken action under 63(2), as well as, my lord, under section 63(4). They have launched prosecutions under 174 IPC. So, my lord, a person who does not explain, that gives you a threshold to, my lord, reach that he is guilty. This is his satisfaction level, what is he demonstrating? And that's for judicial review, my lord. I'm not seeking merits review. Your lordships are not going to sit over the satisfaction of the officer. It is his realm. In this light, your lordships may see, lord. Please have a look at, my lord. Just go. See the remand application right now, my lord. In my note, list of date note, my lord. My note only. Your lordship may not go anywhere.
Yes.
Just see, my lord, serial number 15.
Oh, this is the remand.
This is
reason.
the remand application.
Yes.
No, my lord. It says, para number 6. It is submitted that Deepak Singh Alawat is evading the investigation, trying to derail the same by not providing complete and correct facts that are being asked of him during the investigation. So what do you expect? This is exactly contrary to my lord Pankaj Bansal. Then, my lord, the same necessitates the need for his interrogation and certain crucial aspects. My lord, para 9. Custodial interrogation, which is qualitatively more elicitation oriented of Deepak Singh, is absolutely necessary. And in this case, there are many aspects. Now, what are these many aspects? Not God knows. It is in his, in his whims and fancies, not disclosed. Many aspects that need to be investigated. And he has been totally non-cooperative, evasive, misleading. How, why, when, my lord? What is the question that you asked? What I did not answer? You don't want to specify, but whether this can even otherwise be a ground for my arrest. I, my lord, as a student of law, I would say reading, my lord, all these compendium of judgments, whether for or against. There would be many, my lord, where my arrest has been, my lord, held to be valid, despite raising all these contentions. Those are, my lord, as I said, my lord, the judgments have to be applied in a fact situation. We should be ad item on the position of law, and then we apply. So this, my lord, and my lord, in the first ECIR, I'm told, instructed to say that this gentleman was regularly appearing. He has appeared, if I'm correct with the number, he says 20 times, but I don't know. All right, about whatever 50 summons were sent, my lord, he appeared. So there was never a default on his part, but that's the first case. Now, my lord, come back to, for a moment, last 2-3 paragraphs of Pankaj, sorry, my lord, Kejriwal.
No, yes.
Last 2-3 paragraphs. My lord, we were on that para 47 that it should wait. It is not for the purpose of investigation.
Yes.
Arrest. Now, my lord, please have a look at. Straight away, my lord, your lordships may come to paragraph C, which, my lord, is extract of para 61. And I wish to read this, my lord. The legality of the reasons to believe have to be examined based on what is mentioned and recorded therein and the material on record. However, the officer acting under 19(1) PMLA cannot ignore or not consider the material which exonerates the arrestee. Any such non-consideration would lead to difficult and unacceptable results. First, it would negate the legislative intent which imposes stringent conditions. As a general rule of interpretation, penal provisions must be interpreted strictly. Secondly, any undue indulgence and latitude to the DOE will be deleterious to the constitutional values of rule of law and life and liberty of persons. An officer, now my lord, this is another one. An officer cannot be allowed to selectively pick and choose material implicating the person to be arrested. They have to equally apply their mind to other material which absolves and exculpates the arrestee. The power to arrest under 19 cannot be exercised as per the whims and fancies of the officer. Now, my lord, the next one also, para 62. Undoubtedly, the opinion of the officer is subjective, but formation of opinion should be in accordance with law. Subjectivity of the opinion is not a carte blanche to ignore relevant absolving material without an explanation. In such a situation, the officer commits an error in law, which goes to the root of the decision-making process and amounts to legal malice. We are of the opinion that it would be incongruous to argue that high-ranking officers should not objectively consider all material, including exculpatory material. My lord, I pause here. Your lordship's interference with the first ECIR, the fact of there being existence of the first ECIR, that too by the same office. Same office. ED may have separate offices, even then they are bound. Here it is the same very office and probably the same very officer. I'll check that fact, my lord. Who, my lord, registers another case and doesn't consider, doesn't even want to meet that argument. My lord. So we don't get the copy, but that's it. So we don't know. So para double G, my lord, para 66. Para double G of my note, my lord.
Yes.
The court should not inquire into correctness or otherwise the fact found, except where the facts found existing are not supported by any evidence at all, or the finding is so perverse that no reasonable man would say that the facts and circumstances exist. It is, huh? All right. Now, my lord, corresponding to, my lord, just one, my lord, paragraph which I want to read is, my lord, on preventive detention, how they, my lord, not akin to preventive detention. That, my lord, your lordships will find paragraph, my lord, double L. In my note, this is para 67. Error in decision-making process can vitiate a judgment or decision of a statutory authority. In terms of 19, a decision-making error can lead to arrest and deprivation of liberty, though not akin to preventive detention cases, but given the nature of the order entailing arrest, it requires careful scrutiny and consideration. And then, my lord, of course, they say that you have to supply, and then, my lord, for necessity of arrest, though there is a reference, but, my lord, I would just show 2 lines from Vijay Madan Lal Chaudhary, that necessity to arrest is a precondition. Have a quick glance, my lord, at Vijay Madan Lal Chaudhary's quote here only, in this very note, and your lordships may see, my lord, page 6 of my note, my lord. And see that that's, my lord, the quotes of Vijay Madan Lal Chaudhary.
Yes.
See, my lord, para 322, and just see ending lines of para 322, just above para 325, I've highlighted, my lord. The
Forming an opinion.
Opinion as recorded in writing regarding the necessity to arrest. Now see 325 also, my lord. And your lordships, my lord, would be seeing it, my lord. 325 necessity. My lord, again in the center, 5th, 6th line, my lord. 325. About the necessity, accountable for their judgment regarding necessity to arrest. Now, my lord, along with this, I must now take your lordship, my lord, through the reasons to believe, my lord. I showed, my lord, the remand application. Just have a look at, quick glance at, my lord, these reasons to believe quickly, which, my lord, in my, my lord, a comparative chart I've given at, my lord, my note, list of date note.
Yes.
Please turn to page 6, your lordships.
Hmm.
There is a comparative chart, my lord. Now, my lord, these 3 charts are 3 ground reasons to believe in these 3 petitioners. And just see, my lord, the last lines there. The underlined portion, my lord. The relevant portion, I'm reading the first top left, my lord. The
Yes,
left
yes,
one.
I'm there.
Relevant portion of such illegal payments is reproduced hereunder for ready reference. The data, and my lord, is extracted from the Excel sheet found in the seized mobile phone of Shri Deepak Singh. Your lordships have it, my lord?
Yes.
Same words, my lord, in the second. In the Deepak, my lord, in Deepak Singh's case also. Now the third case, my lord, Vikas Taneja. Your lordships will find the word mobile phone of Vikas Taneja.
Yes.
From the Excel sheet, same. Now where these Excel sheets were taken? Probably, my lord, during the course of, my lord, because here there was no time. You are continuing with the search for 48 hours, straight away you arrested me, brought to the court. So this is in that November 25 only. We don't know whose phone is it, from which phone is it taken. So, my lord, whether this would be even prima facie, secondary opinion the court has to form. Did the court ask, my lord? I am the court, I am the, my lord, court, remand court. So what is the obligation cast on me by virtue of all these judgments, my lord? 7, 8 of them.
Remand court asking.
My lord?
I have seldom come across a case where.
That's what, my lord, that's what your lordships have to see, my lord. That's eventually what is falling to. And therefore, my lord, those guidelines are necessary in such kind of statutes. It's not about, my lord, no guilty should go, my lord, and I'm not saying, my lord, that if these, there has to be procedural fairness, that's all, my lord. Otherwise, my lord, that checklist, my lord, Dr. Muralidharan, my lord, so elaborately, so beautifully, my lord, printed it that there has to be a checklist. So, my lord, it's that. My lord, now, my lords have read Premier Agency, para 26, have read Pankaj once. Now you take me to 19.2. My lord, quickly have a look at the other note, my issues note. And now arrest 2 is the my lord, I will quickly, my lord, just, my lord, introduce my issues. The first was about second ECIR.
Yes.
You lordships have that issues.
Yes.
The first was whether second ECIR, my lord, is a, my lord, a totally malicious exercise. I, my lord, try to, English is nobody's mother tongue, my lord, but I've tried to formulate them in that manner. The second one is, my lord, violation of section 19(1). How I feel it is violated, and my lord, I have imprinted it here. The third one is valid, my lord, very vital. Page 2, my lord, violation of 19(2). Now, before I show, my lord, I have to show to your lordships one judgment of Punjab High Court against which SLP is dismissed. I'm not saying, my lord, the dismissal of SLP would amount to merger. of, my lord,
So-
the Supreme Court, but now that's the law which is prevailing according to me. So, my lord, please have a look at, in my judgment note, my lord, the case extract note, case digest note, my lord, your lordship will find at page 19. Your lordships have, my lord, page 19. And, my lord, I'm reading that Dilbag Singh's case. From a perusal of the provisions of section 19 and law laid down in the above said judgments, it is apparent that legislature has purposely chosen to use the expression immediately section 19.2 and expression as soon as may be in 19.1. So, my lord, as soon as may be informed the grounds of arrest, and, my lord, in 19.2 it is immediately after arrest. As the order along with material which is required to be forwarded to the adjudicating authority would already be in the possession of the officer carrying out the arrest. As before arresting on the basis of the said material in his possession, he has formulated reason to believe to be recorded in writing that the said person was guilty, and thus the act of sending the said material should be done immediately, and the same would be required to be done prior to when the person so arrested is produced before the special court or magistrate or metropolitan magistrate, as the case may be, having jurisdiction. As it has been repeatedly held by the Honorable Supreme Court that it is incumbent upon the court concerned to satisfy itself of the compliance of the conditions contained in 19, which would also include compliance of 19.2 before passing the order of remand. In case the material on basis of which the officer arresting the person had reason to believe that accused persons were guilty is not forwarded before the accused is presented before the court concerned, then it would not be possible for the court concerned to carry out its duty to see the compliance of 19, more so section 19.2. Moreover,
even then the remand count will not do anything.
Lord,
Even if
so-
all the material is before it,
that's, my lord, where your lordship's
it is as if
jurisdiction.
their hands are tied.
My lord, I think it's time to, my lord, unlock them. And, my lord, either which way, my lord. So, my lord, we as lawyers, and I always say, my lord, most of us are in disguise employment, especially myself. Because, my lord, despite arguing this, my lord, umpteen times, we still get something whenever we read their grounds of arrest or, my lord, read the proceedings. So there should
No,
be
every rereading gives out something new.
Absolutely.
Always.
Every day, my lord. It's a new learning.
That's the joy of reading.
Absolutely. Absolutely. I'm so, my lord, yeah. So, my lord, in this case, two aspects held. That one, that you have to send the material not later than 24 hours, because the Supreme Court, after Pankaj Bansal, my lord, had held that it has to be 24 hours. So, my lord, but the court gives a second caveat, my lord. It says in any case it has to be before remand. So you have to satisfy 19.2 before remand. The reliance on 19.2 is, my lord, your lordships are having that book of professionals, my lord. The
Yes, yes.
arrest rules.
No, not that. But
Forms.
19.2 is here.
No, my lord. There are forms, my lord. I just wanted to show.
Forms is it?
Yes,
No, I have this.
Yeah, arrest rules. Okay. My lord, it's the rules which, can I pass on to your lordship?
Form number?
My lord, I think your lordships have the arrest rules. It says prevention of money laundering, the forms and manner of forwarding a copy of order of arrest.
Let me see.
Yes. You have it? You take it out. You should have been ready with this. Should have been part of it. जल्दी जल्दी निकाला भी था।
इधर ले आ तो नोटबुक करते
Lord, just these are the arrest rules. In short, it's a long name, so we call it arrest rules because it's forwarding a copy of order of arrest. And it talks about 19.2. There is section 2G and 2H. Oh, sorry, my lord, rule 2G and 2H, which, my lord, says
Material.
My lord, H means order.
Material and order.
Or material and order. I'm grateful, my lord. Now see, my lord, the next page. Rule 6, my lord. Rule 6.
Form of records.
My lord,
Forms of
the
records.
arresting officer, while exercising powers 19.1, shall sign the arrest order in form 3. And then, my lord, rule 6, this is the form 3. On the next page, on the next page, your lordship will find probably form 3. And then form 1 and 2 are, my lord, in terms of the other two rules. Acknowledgement by the my lord, adjudicating authority.
Yes.
No, my lord, I am saying three things had to be shown to the court. Number one, that this material has been forwarded. They may have done it, my lord, I don't know. My friend will demonstrate. It is him to satisfy. That they have sent it in these two forms to the adjudicating authority. That's the first compliance. Second compliance is, my lord, that the material which was forwarded had to be, my lord, I would say as a proposition of law, and I'm very careful in formulating it. And I, my lord, make it very good. I'm saying, my lord, when the Supreme Court said, you give me reasons to believe. Supreme Court did not say that you give me only the factual narrative, sense of the documents. You could have redacted, but you had to give me the material also. So what reasons to believe are, according to me, my lord, woefully inadequate. They are not complete. But my lord, be that as it may. The second argument, totally different, is that when the court had to ensure that, my lord, 19.2 material is available with it to see what is sent, so that it could cross-check secondary opinion that reasons to believe are in accord with that material. Supposing, my lord, the material I have seen in one of the cases, and I'm making a very responsible statement on, there was only FIR and charge sheet of the scheduled offense. Nothing else was in material.
Charge sheet in what?
In the scheduled offense.
722.
Lord, not in this case. I'm talking of some other case
Some other, in that,
where, my lord, material was shown.
because there was no charge sheet in this case.
No, no,
in
my lord.
None of these cases.
No, Lord, it was closed. They accepted. I'm saying, my lord, in one of the cases,
Illustration.
the material illustration, as an illustration, there was actually no material. It was, my lord, about a 10-page, 15-page document, and reasons to believe ran into almost, my lord, 40, 50 pages. So, my lord, this factual narrative can't take place. So this, my lord, with utmost respect, when I formulate those, my lord, issues, I said, my lord, 19.2 is violated. And the last one, of course, is, my lord, the
2122.
2122 violated. It will result in, my lord, my liberty forthwith. And, my lord, I hope and wish that your lordships have seen, my lord, those interim release orders also, my lord, which Mr. Mullaidharan pointed out. We'll do that, make it good. If my brothers
Yes,
want
who has-
to take anything, my lord. Deeply obliged, my lord, for a very, very patient hearing. It was a privilege.
I'm conscious.
ನಾಳೆ ತಾನೆ ನಾಳೆ 2:30. ಹೂವ ಹೆಸರು ಆದ್ಮೇಲೆ ಚೋಟ ಸರ್.
5 minutes by the clock, Malas. I'm conscious that.
ನೀವ ಅವರ
Nanu.
ಐ ಆನ್ ದ ಕ್ಲಾಕ್? ಎಸ್.
By the clock, 5 minutes.
Yes.
Malas, in fact, in all three
Yeah.
matters, Malas, I'm not appearing in any specific matter only. All three of us are in the three matters. Malas, I'll just specifically come to the facts, Malas. 3 arrests made. Malas, the law was placed before your lordships between Dr. Mullaidhar and Malas, Mr. Chaudhary extenso. Malas, your lordships have, Malas, in the previous round, James Craft, Puppy, Winzo, etc. All of it, Malas, repeatedly before your lordships. But please see the irony, my lords, in terms of the illegality. We are here before your lordships on illegality of arrest period. Nothing beyond that, my lords. Therefore, for a minute, my lords, please look at it as the bottom common denominator. Whether the arrest ex facie, my lords, is illegal. Section 19, my lords, indicates that the material available with them, they must, my lords, arrive at an opinion that I am guilty of the offense. Kindly see the language, my lords. Just 2 sentences in 19.
Material available with them at the time of arrest.
Yes, madam. That he has, on the basis of material in his possession, reason to believe that any person has been guilty of an offense punishable under the Act, he may arrest such person and shall, as soon as may be so. Necessity, my lords, has therefore been read into it. Necessity to arrest. 3 requirements on that, my lords. 1, material should be available with you. Based on prudent reading of that material, my lords, not some obnoxious reading of the material, you believe that I am guilty and therefore there is a necessity, my lords, to arrest me. My lords, the safeguard to it is, Supreme Court, my lords, in the series of decisions that was placed, indicates 1, that you cannot arrest me only for the purposes of investigation. Arvind Kejriwal, etc., etc., each line. Pankaj Bansal, Arvind Kejriwal, you can't arrest me only because it will facilitate your investigation. Second, Pankaj Bansal also indicates, my lords, and of course, series of High Court decisions, that if a 50 notice is issued or a question is asked, and I do not cooperate, mere non-cooperation also is no ground, my lords, to arrest. Therefore, my lords, please look at the contours in my case. There was, my lords, 2 FIRs earlier. Those 2 FIRs broadly, my lords, and I'll not trouble your lordships with the specific dates. Those were, my lords, in 2024, those FIRs.
121.
Based on those, one was FIR 21, other one FIR 722, 722 being the, my lords, base number. They were, of course, closed, etc. One closure is adopted, irrespective, my lords. An ECIR is drawn up on November of 2025. My lords, during that time, the various investigations that they had conducted, section 50 statements that they had taken were all available, my lords, with this authority. My lords, there was an order interdicting further investigation on that by your lordships court on 2/1/2026. My lords, that is 22/1/2026. The specific order, my lords, the language of that order is that your lordship says that there shall thus be an interim order of stay of further proceedings in the subject ECIR arising out of 722, etc. till the next date of hearing. My lord, therefore, the
Now,
material.
there is no further proceeding done.
There is no proceeding.
Material in that is taken and transposed to the next FIR.
My lord, that's exactly, my lord, my precise submission is that. If there is an interdiction saying that you will not do anything more, in other words, stay your hands on that issue. Now you know that you cannot add and make an addendum to it because you have found some FIR somewhere, etc. They have to come back to court and seek leave. They don't do that. All that they should have done is to come and seek leave, my lord. That would be the cleanest above board scenario, saying I'm seeking leave, I need to take this exercise. Whether your lordships will permit, not permit is a different matter. But what they do is take that basket of information, and that's why, my lords, this interdiction, fruit of a poisonous tree. My respective submission is that that basket of information today is not available for the authority, whether poisonous or not.
Forbidden tree.
That forbidden. That basket of information is then transposed to a new ECIR, which is drawn up based on FIRs, my lords, in January and February of 2026 is when, my lords, these FIRs in Telangana come up. And therefore, an ECIR, my lords, is drawn up on 23rd of February 2026. Well, in that light, could that information which was already available, could that be transposed is one submission, my lords? Respectfully not, because it interdicts. Therefore, illegality of arrest comes in. But the second submission is, again, bottom common denominator. Please for a minute assume, my lords, that extraposition of information that was available with them can be made. Well, that's for the purposes of argument. The investigation which went on, my lords, in the previous ECIR, my accounts were frozen. The investigation covered not just those FIRs. Obviously, they cannot investigate those FIRs, not being a super cop of RKM, Chennai, etc. They are investigating, my lords, the ECIR, which covered the entire gamut of my company's operations. And the information which they had with them at that point in time, prior to your lordship's interdiction, was not sufficient in their own opinion to arrest me, because they did not. If an information which is available with them gives them a hue that it is not sufficient to arrest me, does the hue of that information change subsequently to make it necessary to arrest me on the basis that that information is sufficient to hold me guilty?
So the cry. You and cry.
The cry, my lords, is from our end.
Yes, that's what I
Unfortunately, it
said.
does not reach them. Therefore, my lords, these three new FIR cumulatively is 2 crores. What is attached is some 600 crores in the company. Everything in the company is attached. The third juxtaposition to this is, as of the date, that is, my lords, when the central legislation came out, that legislation was August of 2025, there was a complete prohibition, my lords, on these activities. Therefore, if
That's why accounts are taken till August 2020.
August. Well, if that is the scenario, please now, my lords, come to see the reasons to believe, my lords, in the arrest. Kindly see the reason to believe, just two paragraphs.
Yes.
Could this be sufficient, my lords, for arrest? But
Yes.
there is an arrest memo, arrest order, and kindly see the reasons to believe. I'm using the same paper book, my lords. Although I appear,
Yes.
my lords.
No,
in
it is
22.
quoted here.
Yes,
Yes.
my lords. Although I appear, my lords, in I think 22.1 or 2, Prithviraj. My lords, please take Deepak Singh's matter, my lords, because that's what was shown to your lordship. Please, my lords, come to page number 124. I'm sorry, my lord, before 124, 108. Just two paragraphs. In 108, on top, your lordships, you'll see, my lords. This was shown to your lordships. I'm
Yes,
just showing
yes.
it for completeness because I'm juxtaposing to the next. Well, lords, these data were seized during, I'm sorry, 108 on the very top.
You carry on. Yes.
These data were seized during the search conducted under 17 at the premises of Gamescraft in the month of November 2025. There is one basket of information in the previous search. After the present ECIR, there is, my lord, search conducted. I'll come to that issue, my lords, whether that information was seen. Please come to, my lords, page number 124. At the bottom of that page, my lords. Please see, my lords, laundering proceedings, etc. Third line. However, Shri Ramesh Prabhu issued summons in section 50/2022, and in response of 18/11/2025, he responded. This becomes the basis. 18/11/2025, previous basket. My lords, now please juxtapose this to the last page of it, my lords, which is page number, my lords. Your lordships will find it at 133. 130, yes, my lords, 132. Paragraph number 6. My lord, 132 minutes.
Yes, I'm there.
Well, let's kindly see the last paragraph. Further, there is reason to believe that Deepak so-and-so is in possession of material evidence and information relating to the offense in the instant case, and custodial interrogation of so and so is necessary to establish money trail. In the teeth of my lords, what Arvind Kejriwal says, you will not arrest me because you want to investigate. Now, my lords, now kindly see that there was, of course, now an investigation being conducted because of the new ECIR. Could they have drawn up a new ECIR? My respective submission, no. The interdiction is that stay your hands. To get over it, you don't create a facade of a new ECIR, because right through the case of my friends who are in all the previous matters, we will issue addendums to existing ECIRs, not that we will drop new ECIRs. Our case was in the previous round of Windsor, saying if you find new offences, drop a new ECIR, I'll deal with it.
They've
They
done
said
it.
no.
They've done it.
In the previous case, the argument is no, I will do issue addendum. Your lordship
No,
interdicts them on
correct.
addendum.
They are now impressed by the argument. They've done it.
Excellent. Therefore, my lords, I'm grateful that at least they were convinced by my argument, if not your lordship. Now let's see, my lords, what they do. If there is a previous set of information which was not satisfactory enough for my arrest, the subsequent information was being garnered by a search in the premises on 7/5/2026 when the search began. The search ended, my lords, on 14/5/2026.
7 days.
My lords, 7 days. This is Gamescraft in the company, not my house, etc.
Oh, in the company.
Because, my lords, the previous material, my lords, was in fact, I am arrested now, my lords, in the subsequent second set of FIRs, etc., my lords, based on information that they have. I'm seeing what information. Previous information they can't touch. Even assuming they can touch, previous information did not satisfy them of the need to arrest earlier. That hue does not change. Now, my lord, 7/5 to 14/5, my lord, the search goes on. A seizure memo, search memo, etc., my lords, is drawn up on 14/5/2026, which is in that compilation at page 205. But when do they arrest me? They arrest me, my lords, on 8/5. Even before material is, my lords, collected in the seizure. On 8/5, what material did they have which satisfies section 19, my lords, to arrest me? Because they were going on for 7 days. At the least, if you wanted to cover your tracks, you wait till 18/5, have your seizure memo and say, based on this material, I now have sufficient material under 19 to think that you are guilty and therefore I will arrest you. To start the search on A7, arrest me on 8th, dehorse any material, goes to the teeth of section 19, my lord. That's my respective submission. Grateful. 5 minutes better. Grateful.
Proceeds of crime.
Doesn't matter.
So much said on the facts, and it's always told that don't make arguments to dilute the arguments of others. I wouldn't
No,
want
no,
to enter into
that you'll never do.
So I'll just put it in the form of.
I don't think you've done it at any time.
Just 3 points. I'll put
You'll
it
only
like this.
amplify it, not dilute. Yes.
My lords, I'm on the aspect of fairness of the ED, my lords, because I had appeared before this honorable court. Because I had appeared before this honorable court when we challenged the first ECIR.
722.
Yes, my lords. My lords was pleased to note that there was no predicate offense, and my lords was pleased to stay the proceedings, and an argument of updation of that was made. My lords, the matter thereafter came up before my lords.
That interim order was not challenged.
Never,
right?
my lords, never. And this matter came up on 9 occasions, my lords. After that order is passed, on 9 occasions. It is not that the matter never came up before the court. They could not
come up. Yes.
They did not. They were not in a position to point out that there are other FIRs registered. We intend having a second DCR. Nothing, my lords. Of the 9 occasions, on 5 occasions, my lords, the matter came up after they registered the second DCIR.
So that was not brought to the notice of
They were brought to the notice of this court. If this is not going to be a case of trying to overreach the order of this honorable court, my lords, a respectful submission is it only reflects on the conduct of the ED. And I want to use probably the mildest of words, my lords, just on the fairness. Now, this is one aspect of it. The second aspect of it, my lords, in the first ECR which we have challenged, they filed a statement of objections. They filed it on 24th, my lords. Paragraph 9 of that objection, where they said updation of the ECIR, they speak about one FIR that was registered in Lucknow. Can I just request, my lords, in the statement of objection, kindly notice paragraph 9, my lords? Whether they've been fair to this honorable court, even in their pleadings. It's at page 6. Accordingly, FIR 29 of 2026, this is in Lucknow, my lords, was fully incorporated into the existing ECR by way of an addendum dated 18/2. The allegations therein disclosed commission of a schedule offense under section 318(4) of the BNS. Now, please notice, may I just pass on the FIR, my lords. an offense which is an unscheduled offense under 66 of the IT Act, this is what they do in their pleadings. Please notice, my lords, the offense there, 66 in the first page.
ಅಲ್ಲ, in 29 of 2026.
ಹೌದು. Please notice the first page itself, 66D is the offense registered on 21/1/2026. And my lords may notice now the schedule under the PMLA.
6060 is not a scheduled offense.
And this is the pleading, my lords, we get before this honorable court to say we have updated it where there's another schedule offense. Now, this is the second aspect of it, my lords. Please also notice, my lords passed this order on 22nd. First FIR that gets registered in Telangana is 2 days later on 24th. Then, my lords, on 10/2 and 12/2. In all these three FIRs, my lords, the informants say, look, we have been playing online rummy since 2017 onwards. And as we were playing the game, we have lost X amount of money.
From then?
Yes, my lords. And they try to say that because we lost this money, it could be a case of cheating. Now, if that is the FIR, my lords, these are offenses which are punishable with less than 7 years. Mandatorily, my lords, it would be noticed under 41A of CRPC, which is 35(3) of BNSS. Nothing is issued, my lords. Based on these.
That is in the predicate offense.
In the predicate offense. Based on this, my lords, they registered this second FIR on ECIR on 23/2. A day before they filed the statement of objection in it, they registered this ECIR. Now, my lords, if their apprehension was, look, there may be some proceeds of the crime and we may immediately have to attach it, that apprehension cannot be there now with BNSS, my lords, with section 107. Can I just point out section 107, my lords? This was not there in the CRPC, my lords. In the CRPC, the investigating officer did not have the power to attach or for it to be forfeited.
Now attachment of proceeds of crime.
Yes, my lords, attachment of proceeds of crime in the predicate offense itself, the power is there.
Correct.
Now, if that power is there and the investigating officer who is investigating the predicate offense can attach it, ED can't even now say, look, at least we had to prevent any proceeds of crime from changing hands and we needed to attach. They can't even say that because now under 107 that power is available.
I'm afraid that can be pressed into service.
My lords,
For the reason that PMLA is it's a complete code by itself.
Probably, my lords, in my respectful submission,
Complete code by itself. They need not invoke this or get into what has happened there. They can do it in
my lords,
under the
this is
PMLA.
one aspect, my lords, where the law will have to evolve. If an investigating officer of the predicate offense has the power to attach and then proceed thereafter, then how do we look into PMLA? Because, my lords, my understanding, subject to what has been explained, my lords, my understanding is a schedule offense should be there, proceeds of crime should be there. That merely existence of proceeds of crime will not give them the cause of action for an ECIR. The proceeds of crime, there should be a process or activity of laundering to start PMLA. So, my lords, now if we stop at the point of proceeds of crime, there can be an attachment made in the predicate offense. Anyway, my lords, it's a developing aspect of it. I've done a small note, my lords, comparison of 107 with that of the PMLA Act. May just pass that on, my lords. And if that is so, my lords, the point comes is, can you have this parallel investigation? Now, what is it that the ED is doing is nothing but investigating a predicate offense. My lords, 3 FIRs in Telangana saying they have cheated. This is exactly what they want to investigate now. That, in my respectful submission, my lords, is not the scope of PMLA at all. So there are 2 points, my lords, which I put in writing. One is on the aspect of 107 being covered. And the second aspect is, can you even investigate when in the predicate offense, nothing has moved. There's no notice issued. And, my lords, lastly, my lords, now when they register this ECIR, minimum requirement, my lords, in any ECIR, first you would issue a notice under 50. You cause a search and seizure thereafter. You get convinced, yes, there's a necessity of an arrest, and I believe you're guilty of the offense. That none of it has been followed. It has only been done to overreach the order of this honorable court, my lords. Because of this conduct, this entire arrest which has been done in our respectful submission would be illegal. That's all.
All of it done. Nade 2:30, sir. Raju sir ಮಾಡ್ತಾರಲ್ಲ. Yes, sir. So you are here tomorrow? Then we'll finish it off tomorrow. Purvala, they will stay. Bangalore is good weather-wise and otherwise.
No, my lords, today I don't think they'll be in a position to go anywhere, my lords.
That is
They are
correct. They are
stuck
stranded
today,
here.
my lords. The roads are in a bad shape.
They are stranded here.
We,
Oh, see this.
we may not be able to leave the court.
No problem. You can. It's in the lighter way.
SV Raju ಮತ್ತೆ Zoeb.
I'll try to navigate my way.
Appearance.
ಎಲ್ಲ ಎಸ್ ಎಸ್ ಎಲ್ಲರದು ಅವರು ಸರ್ ಮಧು
SV Raju and Zoeb Hussain.
ಅಂಡ್ ಯಾರ್ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಎಲ್ಲ ಎಸ್ ಸರ್
Deeply obliged.
ಎಸ್ lot of questions to be answered, we'll see.
Lot of issues. And I can only say, my lord, that whenever we all appear, we feel, my lord, that this is the first time, because whatever your lordships are going to follow, either which way, my lord, it is evolution of law. Okay?
We'll see.
Yes.
ಮೇಡಮ್ ಯಾರ್ಯಾರ್ದು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ, ಯಾರ್ಯಾರ್ದು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ಇದು ಒಂದು ಕೆಲಸ ಮಾಡಿ ಮೇಡಮ್.
Let's continue. Orders 23. Police.
ಇದಾ 7A 23
Please, Abhishek.
post immediately after service of notice upon
It's covered.
respondent ಬರ್ಬೇಕಲ್ಲ.
KP Act.
KP Act, Police Act.
Please.
I'll take notice of.
Land additional SPP ಅದು covered ಅಂತ close ಮಾಡಿ. Additional SPP accepts notice for the respondent. Next. ಅಲ್ಲ ಯಾರಿಗೆ ಮತ್ತೆ ನೋಟಿಸ್ ಆಗಿರೋದು R2?
Complainant ಗೆ notice ಮಾಡಿ. Complainant is also police officer.
Yes. Learned additional Learned additional SPP accepts notice for the second respondent as well. Thus, the service of notice stands complete. The issue in the list ಅದು covered ಅಂತ close ಮಾಡಿ. Next.
24.
Police report received unserved. ಇದು ಮಾಡಿದ್ಯಾ? In the light of the police report, the respondent dead ಅಂತಿದೆ? Sorry. In the light of the police report that the complainant is no more, the state will have to defend the action. List the matter for admission on the 17th. Yes.
25.
But in this, there is.
Vacating stay.
Not here.
Arguments.
Kindly will not list the matter next week along with main.
ಏನ್ matter?
Housing society. When he was.
Orders ಅಲ್ಲಿ ಬಂದಿದೆ admission ಗೆ ಹಾಕ್ತೀನಿ.
Incurred for the reason that.
ಅಲ್ಲ vacating stay under the caption vacating stay I will post it on next Wednesday.
Public money is involved to the tune of 13 crores, my lord.
When society?
ಹೌದು ಸ್ವಾಮಿ. For last 1 year there is a stay.
No, last 1 week it will be there.
No.
Sir. Last 1 week ಇರುತ್ತೆ.
ಇಲ್ಲ ಸರ್ ನೋಡ್ತೀನಿ ಈಗ.
Orders ಅಲ್ಲಿ.
was.
Next Wednesday in the same, under the caption, hearing on interlocutory application. Heard sounds on party next Wednesday under the caption, hearing on interlocutory applications. Huh?
Camera direct on ಆಗ್ತಿದೆ.
Next
Interim order to continue.
That will continue. Yes.
ಯಾಕಂದ್ರೆ 23,
Status quo
24
ಇದ್ದಂಗಿದೆ. Criminal matter status quo ಏನ್ ಬಂತು?
There was an application brought seeking interim custody by the complainant as well as the accused. That application came to be rejected.
Right, next week ಮುಗಿಸ್ಕೊಂಡು.
Please.
Under the caption, interlocutory applications. Yes. All objections overruled. ಮಾಡಿ ಅಲ್ಲಿಗೆ ಹಾಕಿ. Yes. There is objection label. 26 withdrawal, 27 withdrawal.
28.
Vacating stay ಉಂಟಾ? ಹಾ, yes.
Stay is
ಇದು
vacated,
ನಿಮ್ದಾ?
it's not extended. Stay is not extended.
As good as vacated.
To be taken up for disposal.
91 application, my lord.
91 application ಇಂಟರ್ ಮಾಡಿದ್ಯಾ ಇಲ್ವಲ್ಲ?
ಇತ್ತು ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ
Not extended.
I was not appeared.
Since not appeared, it was not extended.
ಪರವಾಗಿಲ್ಲ. He has appeared, we will not continue. 91 application ಏನಿದೆ? What is the matter ಹೇಳಿ?
My lords, the petitioner is accused for the offence under section 138 of NI Act.
Correct.
So after completion of the cross examination, my lords, when the matter was posted for evidence of the complainant, he has filed an application earlier under section 91 of CRPC seeking to call for the account extract of the complainant hearing. That application came to
ಕೊಟ್ಟಿದ್ದೀರಾ?
That application came to be dismissed.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ? Signature ಒಪ್ಕೊಂಡಿದ್ದೀರಾ? Anything else?
Notice duly, sir.
Because disputing the financial capacity.
ಪರವಾಗಿಲ್ಲ. ಅದೆಲ್ಲ ಎವಿಡೆನ್ಸ್. Yes. ಏನಿಲ್ಲಲ್ಲ? Dismissed.
Great.
Awaiting police report. Post immediately after service of notice upon the respondent.
30.
Immediately after receipt of notice. Huh?
Filed in February, month of February.
ನೀವು ಯಾರಿಗೆ? 30 ಬರ್ಲಿ.
Filed in month of February.
ಏನ್ ಮಾಡೋದು? ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Notice ಆಗಿದೆ.
ಬರ್ಲಿ.
Date ಕೊಟ್ರೆ ಅದು ಮತ್ತೆ ಇಲ್ಲ ಅಂತ ಬರಲ್ಲ.
ಅಲ್ಲ ಡೇಟ್ ಹೆಂಗ್ ಕೊಡ್ಲಿ ಇದಕ್ಕೆ? ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರೋದಲ್ವಾ? ಫೆಬ್ರವರಿ. ಜೂನಲ್ಲಿ ಮುಗಿಸುವ ಬರ್ಲಿ. ಡೇಟ್ ಹೆಂಗ್ ಕೊಡ್ಲಿ? ಪೋಸ್ಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ನಾನೇ ಇಂಟರ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಅಷ್ಟೇ. ಎಸ್, ಅದಕ್ಕೆ ಬರ್ಲಿ. ನೆಕ್ಸ್ಟ್. Post immediately after service of notice upon the respondent.
Undertake to appear for
Learned counsel so and so undertakes to enter appearance for the second respondent, registry to print the name of so and so as appearing for the second respondent. Post for admission on 17th. Yes. Enter ಮಾಡಿದ್ಯಾ? Post for admission. Vacating stay ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ.
24th. Yes. Next. Enter order continues. Next.
31.
The office
People for ethical treatment.
is.
What is PETA doing here?
My lords, the respondent number 2 is an unregistered dog breeder.
Dog breeder.
Unregistered dog breeder, the respondent number 2.
All right.
At my instance, an FIR has been registered against respondent number 2.
Why?
For cruelty.
Cruelty.
Cruelty towards the dogs. We have videos.
Because
my lords,
he has
they
no
show-
license.
Not only that, as in that videos of him thrashing the dogs with pipes.
ಹೌದಾ?
ಎಲ್ಲ ಇದೆ ಅದಕ್ಕೆ.
How did you capture all that?
ಎಲ್ಲ from the
Or
from their
hearsay?
neighbor or ಕೊಟ್ಟಿದ್ದು.
Hearsay.
From their neighbor. In any event, after the FIR was filed, my lords, the dogs have been rescued. Subsequently, in terms of the case property animal rules, the dogs have also been relinquished in my favor. Adadmele 2 weeks later, he approaches the magistrate and files a 57
Regarding relinquishment.
Why do you torture the dogs also?
No, my lords, I have not tortured the dogs.
Then?
Based on, my lords, I maintain 3 dogs, my lords.
You maintain 3 dogs?
3 dogs, my lords. For the disciplinary purpose, I have.
Discipline? You beat them and teach, is it?
No, my lords, not beating.
Dogs need not be beaten to teach, sir.
No, my lords, it's not regarding that.
Then?
And also, my lords, during the pendency of this case, my lords, without reporting the seizure of the dogs, the complainant have, based on the relinquishment deed, they have given to the adoption, my lords. Regarding that, I have
No, if you want to beat the dogs and teach the dogs something which they may learn, may not learn, that's a different thing. You need not have the dogs. Let it
No,
go
my
with
lords,
them.
I am filing a detailed objection, my lords, regarding the,
Dogs.
please.
I will not return the dogs to you. I will not direct returning of the dogs to you at all.
My lords,
How can you beat the dogs?
no, it's not beaten,
Disciplinary purposes.
please, my lords. So,
All right.
I'm filing a detailed
Correct
objection.
ಆಗಿದೆ. Unethical treatment to animals.
There are totally 9 dogs that have been rescued.
No, my lords, only I was in possession with 3 dogs. There were 2 mother proceedings, my lords. First 3 ನಾಯಿ ಏನಿದ್ವು ಅವನ್ ಫಸ್ಟ್ ಸೀಸ್ ಮಾಡ್ತಾರೆ 18th.
ಆಯ್ತು.
There after 25th, my lords.
ಹ್ಮ್.
6 more dogs were seized, my lords.
ಹಾ.
ಅದು ನನ್ನ ಫ್ರೆಂಡಿಗೆ ಕೊಟ್ಟಾಗ ಅದನ್ನ ತಗೊಂಡ್ಬಂದು ಮತ್ತೆ ಸೀಸ್ ಅಂತ ಅದನ್ನ ಸೀಜರ್ ಮಾಡ್ತಾರೆ.
ನಿಮ್ಮ ಹತ್ರ 9 ನಾಯಿ ಇತ್ತ 3?
My lords, total I had 9 dogs, my lords. 9 ಅಲ್ಲಿ 3 ಮಾತ್ರ ನನ್ನ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇತ್ತು.
ಆಯ್ತು.
Regarding that, these 3 after seizure, my lords, they have not reported the seizure to the court, my lords.
You are a dog breeder.
No, my lords, I am the resident, my lords. Yeah.
Why do you want 9 dogs if you're not a breeder?
My lords, so what can I do, my lords?
CCTV ತರ ಒಂದೊಂದ್ ಕಡೆ ಒಂದೊಂದ್ ಇಟ್ಟಿದ್ದೀರಾ?
No, my lords, what can I do if dog gives birth to more puppies, my lords, out of emotion. Also, I am a divorcee, my lords.
If you are a divorcee, what?
For emotional support, my lords.
Like because of the name of the breed.
You are a divorcee, dog has given more birth to
Probably because of the name of the breed.
Huh?
Because of the name of the breed.
ಯಾವುದು?
Golden retriever and Shih Tzu, my lords.
Shih Tzu. Oh.
My lords.
Okay. Hybrid.
Not sure, not seen the dog, actually.
Not seen. Yes.
There are also unneutered, my instructions are unneutered dogs and purebred.
No, whatever it is, but no right to beat the dogs.
Please, my lords, the statement of objection may be taken on record, my lords. I'm also, my lords, during the pendency of this investigation, they have coerced me to execute a relinquishment letter, my lords, during the pendency.
ಅದು 9
9 my lords.
9 relinquish ಮಾಡಿದ್ರಾ?
No, my lords, by way of coercion in the with the hands in hand with the investigating officer.
Hands in, hand in hand. All right. Hand in glove.
Hand in glove, my lords. Investigating officer ಜೊತೆ ಸೇರಿ ಇದು
ಸೇರಿ ಎಲ್ಲ
ಮಾಡ್ತಾರೆ. My lords, when I have filed application for releasing of the dogs, then they file normal formal objection from the investigating officer. And when I went to police station for enforcement of release order, I was stopped by the investigating officer and allowing the complainant to approach this court, my lords.
All right.
Anyways, I never had any problem.
Why are you before the court? He has registered a crime, is it?
No, my lord, I am the complainant in this case.
Oh, you are the
I am the
complainant.
complainant in this case.
ಈಗ ನಿಮ್ಗೆ ಯಾವ ನಾಯಿ ಬೇಕು?
My lords,
Which dog do you want?
it's all dogs I do want.
Shih Tzu you want or golden retriever?
Actually, I want all dogs, actually.
All dogs?
Yes, my lords.
Yes. You are not disciplined.
So filing objection.
Yes.
And also, my lords, in the main petition, they are relying on notarized deed, my lords. And in that notarized deed also, it does not bear signature on every page.
Right.
And also, based on the letter na in notarized deed age or convert ಮಾಡಿ, based on that they have secured the stay, my lords. Therefore, my lords, I may be
Objection, learned counsel appearing for the. ಅವ್ರು ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ. ಸ್ಟೇಟ್ಗೊಂದು ಕಾಪಿ ಕೊಡಿ, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. We'll clear this dog problem next week. 10th.
The office objection may be overruled. Now.
Office objections overruled. Yes.
The interim order may be extended.
Interim order extended. What else you want? Sorry. Yes. List on 10th. Hey, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. Petition copy ಕೊಟ್ಟಿಲ್ವಾ? Give a petition copy.
They will just give a
Ah, ಕೊಡಿ. Yes.
32.
Petition in this case. Copies are being served personally.
Post immediately after service of notice upon the respondent. Yes, next.
Personally served the copies to the bank.
ಯಾರು ಹೇಳಿದ್ರು ಪರ್ಸನಲಿ ಕೊಡಿ ಅಂತ?
Emergent notice ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೆ.
Emergent notice ಇಲ್ಲ. Yes, ಬರ್ಲಿ ಬಿಡಿ. Next.
33 adjourned. Admission 34.
ಪಾಸ್ ಓವರ್ ಇತ್ತಲ್ಲ 34 ನಿಮ್ದಾ?
34 Millards.
Playing bad part as against Sunil.
That's similar allegations, Millards. One
34.
allegation, one incident, Millards, the two FIRs.
ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್, ಬೆಳಗ್ಗೆ ಒಂದು 306 ಅಬೆಟ್ಮೆಂಟ್ ಸೂಸೈಡ್ ಇತ್ತು, ಬಂದಿಲ್ವಾ? ಯಾರು ಇರ್ಲಿಲ್ಲ ನೀವು?
I'm sorry, my lord. I was on my legs.
ಯಾವ್ದೋ ಇಲ್ಲಿತ್ತಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್.
This one, yes, yes.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
Yes.
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೇನೆ.
Given, my lord, the series of judgments, my lord, delivered by your lordships, my lord, I wouldn't trust it. We have been relying upon, my lord, every case on the judgments of your lordships, especially when it comes to abatement.
ಈಗ ಇದ್ರಲ್ಲಿ ಏನು ಏನ್ ಸುನಿಲ್ ಇದೆ?
Plus one incident, this is the dispute in the Alliance University, Millard.
ಎಲ್ಲಿ?
Alliance University, Millards,
Oh.
Anekal.
ಹಾ.
This Millards, this petitioner is a registrar at the time of the incident, Millards. The one incident, Millards, took place on 13/11/2017. Two FIRs came to be registered, Millards. One FIR by the police officer, another FIR by the one of the member of the
ಯಾವ್ದು
university.
ಬೇಕು ನಿಮ್ಗೆ?
Both, Millards, it has to go.
Why?
Because, Millards,
ಯಾವ್ದಾದ್ರು ಒಂದು ಇಟ್ಕೊಳ್ಳೋಣ.
on the day of incident, Millards, I was not there, Millards.
If Sunil is limiting his prayers for himself, not attacking the FIRs, my lord, I may concessionalize. If he says entire FIR is bad, my lord.
No, one of the FIR let it go, one remain.
No, Millards, my submission.
That incident ಎರಡು FIR ಯಾಕೆ?
One, it's not the same incident. One, the policeman says he was assaulted personally. And my lord, the other FIR filed by us is about, my lord, the barging into the university. My lord, let me not, my lord, get into the merits of it. There are two concessions, my lord, which Mr. Sunil makes. He strenuously claims that he was the registrar, which has been, my lord, turned down by this honorable court.
ಯಾವ್ದೋ ಬರ್ದಂಗಿದೆ ನಾನು.
Series of Alliance University cases.
Series
My lord,
of
what
cases.
happened? We were the legal management, and Madhukar Angur, my lord, with his team came and
ಆಯ್ತು. What is this man?
This man, my lord, he claims to be appointed as a registrar by Mr. Madhukar Angur, who himself, my lord, is a rich outsider to the university, as has been held by this honorable court.
No,
And
my
my
lord,
lord,
some of-
attained finally to the honorable Supreme Court. Therefore, my lord, this claim that I am the registrar, all these things being aside,
No, Millards,
he
I am
says
not.
about the role. If he says about, let him, my lord, limit his submissions to the role, if any. My lord, that we will see. Let him not, my lord, say that I am.
Next
That's
week
my
ತಗೊಂಡು.
submission. Millards, he is a senior citizen, Millards, he is more than age about
Stay
60
ಇಲ್ವಾ?
years. There is a stay, Millards, stays there, Millards. Allegation against me is that, Millards, on the day, Millards, some of the students and some of the persons from the side of the Madhukar Angur, they started the agitation against, in the university, Millards. It is a specific case of the prosecution that, Millards, on the day I have instigated the other accused person for this agitation. As against me, Millards, there is section 107 of the IPC they have invoked, Millards. And Millards, with this
107%.
107, not 10, Millards, 107 in the IPC abatement instigation.
Suicide ga?
No, Millards, instigation for commission
what?
of crime.
Yes,
This-
it should have been 114. Yes.
And
It
so
should,
far as
it
it
should have
is-
been 114, Millards, they invoked section 107.
Hmm.
The main offense is section 153 against the police officer. In the second FIR, Millards, there is no such allegation. With respect to similar incident on the similar day, they have narrated the two set of facts.
Right, Shamsundar sir, we'll take it next week.
Akbar. Lack of material is only what Sunil has to show. If he shows only lack of material,
will
as
accept
against
it.
his petitioner, my lord, I will
ನೀವು
concede.
ಲ್ಯಾಕ್ ಆಫ್ ಮೆಟೀರಿಯಲ್ ತೋರಿಸಿ ಅವರು ಏನು ಹೇಳದೆ.
Aste, I will concede.
ಹಾ.
If Sunil starts arguing about, my lord, the quality of FIR and all those things, my lord,
Millards,
let him
I am
not
not,
answer.
Millards, I made the two, my submission is twofold, Millards. One is a legal issue and the similar set of facts, your lordship judgment, Bairegoda covered by judgment of your
That is multiple FIRs.
multiple FIRs. Second one.
That he would accept. That
That I will not-
Shamsundar sir will not argue on that
That I
at
will
all.
not.
Then if senior
Now,
Shamsundar sir-
one FIR, if you want its squashment, as he said, you will have to show that there was no material to register a crime against you.
Yes.
Finish.
Yes,
To include him in the crime.
Correct. That's
the
what.
second FIR, Millards, none of the witnesses says that, Millards, my presence
We'll
for
see.
instigation.
ಈಗ ಒಂದ್ FIR ಹೋಗುತ್ತೆ.
Yes.
ಇನ್ನೊಂದು FIR ಏನು ಹೋಗುತ್ತೆ ನೋಡೋಣ.
Yes.
Yes. That will do it on 10th.
Greatly obliged.
Same stage 10th.
Greatly obliged.
Interim order stands seconded, appearance source.
Greatly okay.
ಎಸ್ ಅದನ್ನ ಯಾವತ್ತಿಗೆ ಹಾಕಿದ್ದೀನಿ ಮೇಡಮ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್
Apologize, my lord, the first case I was not here.
ಯಾವತ್ತಿಗೆ ಹಾಕಿದ್ದೀನಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೀನ ಪಾಸ್ ಓವರ್ ಮಾಡ್ದಂಗಿದೆ
ಏನಾಗಿದೆ? I'm so grateful. I'm so grateful. But this we see in appeals, my lord, when we don't appear in the appeal, your lordship should still, my lord,
ಪಾಸ್ ಆರ್ಡರ್ಸ್
pass orders.
that is the mandate of the statute.
Mandate of the statute.
ಇಲ್ಲೇನಿಲ್ಲ ಆದ್ರೂ ವಿಲ್ ಪಾಸ್
Adru, my lord, I'm so honored.
mandate of the
I'm so
court.
grateful. I'm so grateful.
35.
For the petition, my lord.
Yes, sir.
With respect to 138 of the NI Act, wherein initially the complainant presents two checks, that is totally 1 lakh. The accused pays that amount. Subsequently, again, he presents along with the other two checks and files a criminal complaint.
Yes.
Here, what is the main thing is, the complaint is not accommodated by any affidavit, verifying affidavit. It's covered by judgment also.
We'll see, wait. Petitioner to serve on the counsel who represents the respondent in the trial proceeding 17th admission. Yes, next.
Interim order may be granted.
No, sir. 2 years ಇಂದ ಇಲ್ಲ ಇವಾಗೇನಿತ್ತು. Next.
ಇಲ್ಲ ಅವ್ರು ಡಿಲೇ ಮಾಡಿದ್ದಾರೆ ಎವಿಡೆನ್ಸ್ ರೀಡ್ ಮಾಡಕ್ಕೆ.
ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ 24 ಮ್ಯಾಟರ್ ಅದು. Yes.
36 adjourn, 37.
Section 4512 of the Manslaughter Act and 379 of IPC law. There is no any complaint from anybody in respect of 379. So only to bring it to his power, the PSI has invoked section 379. And then, my lord, there is one point is there is no any complaint from anybody in respect.
House lot.
And then the seizure has to be reported to subdivisional magistrate.
Interim order ಇದೆ next week ತಗೊಂಡು.
154 section is not compliant.
Interim order ಇದೆ.
ಇದೇ
List on 17th, same stage. Interim order continues.
I have to go abroad, so.
Abroad?
ಇಬ್ಬರಿಗೆ ಹೋಗ್ಬೇಕಾಗಿದೆ ಅದಕ್ಕೆ I have moved. Next, okay, next date.
ನೀವು ಅಬ್ರಾಡ್ ಹೋದ್ರೆ ಕೌಸ್ ಎಲ್ಲ?
ಅದಕ್ಕೆ ಕ್ವಾಶಿಗೆ ಹಾಕಿರೋದು ನೀವು.
ಓ. ಆಯ್ತು.
17.
17.
Oblige.
38.
For petitioners in this case, sir. The offense are under section 490. Offenses are under section 494, 498A, 114 and read with 34 of IPC, my lord.
Yes, sir. Sorry.
Offense are under section 494, 498A, 114 read with 34 of IPC, my lord. Based on the private complaint, the honorable trial court.
Respondent ಯಾರು sir?
Respondent is the wife, my lord.
ಅದು ಗೊತ್ತು, ಇಲ್ಲಿ ಯಾರು ಒಂದು? Not appeared. ರುದ್ರೇಶ್ ಅವರೇನಾ?
ಅಲ್ಲ.
ಯಾವ್ದು ಮೇಡಮ್? serial number?
38.
Is the counsel for respondent number 2, my lord.
So where is the counsel? Heard the learned counsel appearing for the petitioner as there is no representation by of the respondent. Rest the matter on 24th as a last chance. Interim order subsisting will continue to the next date of hearing.
39.
Yes, Salima madam, ಇದೇನು?
Abatement to suicide, my lord. There is no any material. In ಹೋಗಿ ಸಾಯಿ ನನಗೆ ನಾಕ್ ಬೇಕಾಗಿಡ.
Interim order ಉಂಟಾ?
ಉಂಟು. ಮೂವ್ ಮಾಡಿರೋದು.
ಓ ನಂದೆ.
ಹೌದು ತಮ್ಮದು. Connected matter is under 212. ತಲೆಮರೆಸಿಕೊಳ್ಳಲು ಸಹಾಯ ಮಾಡಿರ್ತಾರೆ ಅಷ್ಟೇ.
ಅದು ಸ್ಟೇ ಮಾಡಿದೀವಿ.
ಹೌದು ಸ್ಟೇ ಇದೆ, ಎರಡು ಸ್ಟೇ.
Heard same order, heard so and so, no representation by the respondent. 24th last chance. Interim order continues.
37 ಅಲ್ಲಿ ಕೂಡ interim order.
ಅದು ಕಂಟಿನ್ಯೂ, ಅದು ಡೋಂಟ್ ವರಿ. Interim order ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ. Yes.
40 adjourn, 41.
And 352 and 354. Lord, the civil suit, my lord, was filed by me.
ಆಯ್ತು, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು ಇಲ್ವೇ? ಒಂದು ಚಾನ್ಸ್ ಕೊಡುವ ಅಷ್ಟೇ. ಸೇಮ್ ಆರ್ಡರ್ ಸೇಮ್ ಡೇ. Interim order continues.
Order may kindly.
ಅದು ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಎಲ್ಲ. ಅವತ್ತು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ತೀರ್ಮಾನ ಮಾಡು.
Grateful.
42.
I appear for the petitioner, my lords. Whereas this is a case, my lords, the chief accounts officer of BMTC, who is a whistleblower and he has been now hauled up in the.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ ಗೊತ್ತು ಮೇಡಮ್ ಬರಲಿ. ಯಾರು ನೀವು ಹಾಕಿರೋದ? ಸೇಮ್ ಡೇ 24th. Continue, continuous.
43.
I appeal for the petitioners council, my lord.
Yes, sir.
Yes, my lord. This is a matter where the petition number 1 for helping his brother's son's family while he was in distress, he is entangled into a case wherein false allegations have been made in the complaint, which my lord gets it at page number 12. The complaint is dated 23/3/2022. In respect of an event which happens on 21/2/2022. After 1 month, which is a late realization.
That's all right. Yes.
That is one aspect of the matter. And now the urgency is that the bank account is frozen, where 20 lakhs money is lying, and the investigating officer has frozen the account.
Yes, madam. Complainant is served unrepresented. ನೋಡಿಲ್ವಾ?
ನೋಡಿದೀನಿ. 60 lakhs my lordship.
60 ಲಕ್ಷನಾ?
ಹೌದು.
60 ಲಕ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ?
ಇಲ್ಲ ಅದು ತೆಗೆದುಕೊಂಡಿದ್ದು that insurance amount which came, and it is not the complainant's case.
15 lakhs that also they have not given.
It is not the complainant's case before the police that I have misappropriated the money. She acknowledges the fact that I cleared the debts.
No, may not be misappropriated, but you have appropriated.
No, I have spent it for the purposes for which I was authorized in terms of clearing the loan, which was
loan clear ಮಾಡಿದಿರಾ?
ಮಾಡಿ ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡಿ ಆಮೇಲೆ ಅವ್ರ ಇನ್ಶೂರೆನ್ಸ್ ಅಮೌಂಟ್ ಬಂದಿದ್ರಲ್ಲಿ ಕ್ಲಿಯರ್ ಮಾಡಿ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಇದ್ದಿದ್ದು ನಮ್ಮ ಕಡೆಯಿಂದ ಎಕ್ಸ್ಟ್ರಾ ಪೇಮೆಂಟ್ ಮಾಡಿ ನಾವು ಅದನ್ನ ಅದು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳುವಾಗ ಡಿಸ್ಪ್ಯೂಟ್ ಬಂದು ಫೆಬ್ರವರಿನಲ್ಲಿ 21/2/2022 ನಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಬಂದ ಮೇಲೆ 1 ತಿಂಗಳಾದ್ಮೇಲೆ being instigated by her brother, the complainant goes to the police station and they register a case against me. The various sections have been invoked. Now the only submission of the petition number 1 is about for having rescued them, for having treated the complainant as because the complainant is related to, she is none other than the wife of the accused number 1's brother's son. She is the wife. She is the daughter-in-law of the accused number 1.
Complicated.
Yes.
If he ಬರಬೇಕಾಗಿದ್ದು
now
after his death, my lord.
What is stated in the FIR, I will read it out if my lord gives 5 minutes. If it is read as a whole, will not.
When is it served, madam?
Long, of 2 hearings have taken place.
2/25. Heli.
So the page number 12 FIR, if it makes out a case, if that version is taken as it is, then I may have to further explain what is my what could
charge sheet ಆಗಿದೆಯಾ?
ಆಗಿದೆ. Charge sheet ಆಗಿದೆ, ಎಲ್ಲ hearsay. There is no the entire all the statements which have been recorded, they are hearsay. We have seen them, we know the family.
138 proceedings initiate ಮಾಡಿದಾರಾ?
ಯಾವುದು? No proceedings, and
it has been clearly mentioned.
ಏನಂತ madam?
60 ಲಕ್ಷ ಹಣವನ್ನು ತನ್ನ ಹೆಸರಿನಲ್ಲಿ ಅಕೌಂಟ್ ಓಪನ್ ಮಾಡಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಸುವುದಾಗಿ ಹೇಳಿ ಬಂದ್ರಿಂದ ಅವ್ರ ಅಕೌಂಟಿಗೆ ಹೋಗಿದೆ. ಅದರಿಂದ 15 lakhs ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬಂದು ಅಲ್ಲೂ ಕೊಡಲ್ಲ ಮತ್ತೆ.
ಅದಕ್ಕೆ ಕ್ರಿಮಿನಲ್ ಕೇಸಾ?
No, it has no, in fact,
ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ತಗೊಂಡ್ರದಲ್ಲ.
ಅಲ್ಲ ಅವ್ರ ಲೋನ್ಸ್ ನೆಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದ್ದೇವೆ ನಾವು. ಅವ್ರು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ, ಅವ್ರು ಅದನ್ನು ಹೇಳ್ತಾರೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಇಷ್ಟೇನಾ?
ಅಷ್ಟೇ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು ಮೆಟೀರಿಯಲ್ ಎಕ್ಸೆಪ್ಟ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ವಿಚ್ ಸಾಕ್ಷಿದಾರ ಹೇಳಿಕೆ. When charge sheet is read, the particular ಸಾರಾಂಶ, charge sheet ಸಾರಾಂಶ, if my lord were to kindly see, it doesn't indicate commission of column number 17, which my lord gets it at page number 39.
The petitioners accused 1, 2, 4 are at the doors of this court calling in question proceedings in CC 220 of 2023 registered for the following offences. Heard the learned senior counsel Bhavi Shankar Narayan Rao appearing for the petitioner and the learned HCGP representing the state. The complainant, though served on 2/2/2025, remains unrepresented even as on date. Therefore, the parties who are, therefore the aforesaid senior counsel of the petitioner and the learned HCGP are heard. Facts in brief germane are as follows. The petitioner and the family members are.
Family members.
Yaru, complainant. The complainant and the
Is the daughter-in-law of
petitioners are members of the same family. They allegedly have a transaction between the two, between them to the tune of rupees 60 lakhs, which is said to have been transferred from the account of the complainant to the petitioners. The petitioners claim or aver in the petition that the said amount was transferred for the purpose of the clearance of the loan or clearance of the loan, clearance of the loan, which they have in fact executed the said
Payment of
loan
medical
clearance process.
medical bills.
The medical bill.
Yes, his medical bills were paid by the uncle, who is the petitioner.
And the documents to that effect are appended to the petition. Long thereafter, a complaint comes to be registered by the second respondent contending that her checks were stolen and forcibly signatures were taken on certain documents and the amount was transferred from her account to the account of the petitioners. Therefore, there has been cheating, assault, intimidation, and assault and intimidation. The crime comes based on the said complaint. The crime comes to be registered in crime number 39 of 2022. The police conduct investigation and file a charge sheet. The filing of the charge sheet is what has driven these petitioners to this court in the subject petition. The learned senior counsel appearing for the petitioner would vehemently contend that the complainant, who is a member of the same family, has sought to develop an axe to grind against the petitioners for the reason of certain dispute within the family. The learned senior counsel further submits that the amount that was received from the hands of the complainant have all been dispersed towards the clearance of the loan that was taken for the purpose of clearance of the medical bills, and therefore submits that the crime is registered for the purpose of recovery of money should not be permitted to be continued as a proceeding before the concerned court. Per contra, the learned HCGP would vehemently refute the submission to contend that the amount is transferred from the hands of the complainant to the petitioners. Though they are members of the same family and there is a transaction between the members of the family, that would not mean that petitioners could escape trial. It is for the petitioners to come out clean in a full-blown trial is the submission of the learned HCGP. As observed here and above, the complainant, though served on 2/2/2025, remains unrepresented even as on date. Therefore, I have given my anxious consideration to submissions made by the respective learned counsel. The aforementioned narrated facts are a matter of record. The dates, the link in the chain of events are all what are narrated in the petition or the complaint. Since the entire issue is now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 12 and 13. The complaint becomes a crime in crime number 39 of 2022. The police conduct investigations and file a charge sheet. The summary of the charge sheet is obtaining in column number 17 reads as follows, page 39. If the complaint and the summary of the charge sheet are read in tandem, what would unmistakably emerge is the criminal law is set into motion for the purpose of recovery of money. Notwithstanding the fact that the money is said to have been utilized by the petitioners for the purpose of the payment of medical bills for which loan had been raised by the complainant herself. In that light, permitting further proceedings against these petitioners, which has been instituted for the purpose of recovery of money, would become an abuse of the process of the law. It becomes apposite to refer to the judgment of the apex court in the case of Lalit Chaturvedi versus State of Uttar Pradesh in reported in 2024, 12 SEC, page 483, court para 6 to 12. The apex court holds that setting the criminal law into motion for the purpose of recovery of money should not be permitted to be continued which have to be interdicted or obliterated by the court's exercising jurisdiction under section 48 of the CRPC. In that light, permitting further proceedings against the petitioners, which is ostensibly instituted for the purpose of recovery of money, would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reason, allowed quashed. The consequences of quashment of the order shall follow.
Second respondent.
Okay, for the petitioner in this matter, my lord. The offences are 498A and 306.
306.
Please, my lord. The husband's not before your lordships, my lord. It's the accused number 2 who's the mother-in-law. Straightaway take your lordships, my lord, to the column number 17 of the charge sheet.
Page
23.
30.
23, my lord. There's nothing against the accused number 2, my lord, if your lordships will see. There is a voice recording, my lord, right before the act of suicide was committed by the deceased. There was a WhatsApp message that was sent to her sister. That, my lord, your lordships will find at page 26, my lord, where it's a voice note which is now they've extracted in 3 different messages. In page 20.
What does that indicate?
That also indicates nothing against the accused number 2 here.
To the mother-in-law.
Please, my lord. I'm covered by a lordship's order, my lord, in the case of Kanya Kumari. I'll just pass.
Page? Sorry, where is that?
Well, my lord, now the rigor of 306 has to be read with 107, my lord, which is the abatement of a thing also. So the scrutiny goes much higher, my lord.
The
So
306, 108.
108, my lord, and 85.
BNS.
Please.
BNS.
Therefore, my lord, when there are no allegations against me at all, therefore, my lord, my respectful submission is that if your lordships will see page 23 also, there's only one line that says that
You are demanded dowry.
demanded dowry. That is only in the complaint where she says that once when she visited the house during a Varma Lakshmi festival, there was some talk about that. But the marriage takes place, my lord, in the year 2012, and this act is only committed in the year 2024. Also, my lord, one other thing that is to be observed is that the mother-in-law never lived with the.
That's what I wanted to ask.
Please, my lord. The
He
mother-in-law
did not reside with
no,
the.
my lord.
ಏನಿದೆ?
The husband's not before this court.
Husband ಚಿತ್ರಹಿಂಸೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಇದೆ.
But it's matter of my colleagues, it may be taken up day after
No,
tomorrow.
no, no.
Day after tomorrow.
ಏನಿದೆ ಇಲ್ಲಿ ಹೇಳಿ?
Charge sheet ಅಲ್ಲಿ she has demanded the dowry,
ಅದೇ,
my lord. So 10
ಯಾವಾಗ?
lakhs rupees.
12 ವರ್ಷದ ಕೆಳಗೆ ಮತ್ತೆ ಅಬೆಟ್ಮೆಂಟ್ ವಾಟ್ ಇಸ್ ದಿಸ್? Husband has tortured. Husband has tortured. No doubt about it. Horrendous offences
Yes, my lord,
against the
at page
husband.
26, at page 26 in point number 3, it's clearly mentioned against the husband. Yes, my lord.
Husband unpardonable. No doubt about it. He has to be tried because
Please, sir.
allegations are grave.
Please.
Day after tomorrow.
ನಿಮ್ದಲ್ವಾ? ಮತ್ತೆ
My colleagues matter it was.
ಏನಿದೆ? ನೀವು
Day
ಡೇ
after
ಆಫ್ಟರ್ ಟುಮಾರೋ ಆದ್ರೂ ಅಷ್ಟೇನೆ. It's completely covered by what I've written. Yes. Husband will not permit. The petitioner, accused number 2, is before the court calling in question proceeding in SC 349 of 2025 registered for offences punishable under section 108, 85 and 85 of the BNS. Heard Srimati Kirti Reddy appearing for the petitioner, the learned counsel of your name?
Satish.
So and so representing the respondent and the learned HCGP. Facts in brief germane are as follows. The accused number 1 and the daughter of the complainant, daughter,
No, my lord, sister, brother,
Sister.
brother's the one.
sister of the complainant get married on 4/5/2012 and reside separately. Relationship reside separately, and from the wedlock 2 children are said to have been born. the relationship between the husband and the wife was floundering. And on the floundering of relationship or the allegations of grave torture by the husband on demand of dowry or otherwise, the wife dies by committing suicide. The acts of AXC, the acts of abetment of suicide has now fallen upon the husband accused number 1 and the petitioner mother-in-law accused number 2. The police conduct investigation and file a charge sheet. The matter is then committed to the Court of Session and is registered as SC 349 of 2025. Registration of the SC is what has driven the petitioner, the mother-in-law, to the doors of this court, calling in question the said proceeding. The learned counsel, Srimati Kirti Reddy, appearing for the petitioner, would vehemently contend that the allegations against the petitioner would not touch upon any of the ingredients that would become necessary to be proved for an offense of abetment to suicide. It is a submission that the definition of abetment is not even met in the case at hand. The learned counsel would take this court through the voice note either.
Please, ma'am.
Yes, ma'am.
Through the transcript of the voice note, which also is indicative of the fact that all the allegations are against the husband, and the mother-in-law did not even reside with the husband or the wife, as the marriage had taken place 12 years prior to the date of death of the sister of the complainant. The learned counsel appearing for the complainant would vehemently refute the submission to contend that there is clear demand of dowry by the mother-in-law at certain intermittent intervals. All that put together has led for the commission of suicide. Therefore, the petitioner accused number 2 also should come out clean in a full-blown trial. The learned counsel seeks dismissal of the petition. The learned HCGP would also toe the lines of the counsel for the complainant in seeking dismissal of the petition on the score that the allegations of demand of dowry is present in the summary of the charge sheet, and therefore it is for the petitioner to come out clean in a full-blown trial. I have given my anxious consideration to the submissions made by the respective learned counsel. The relationship between the sister of the complainant, who is now no more, and the accused number 1 are that they are husband and wife. They get married on 4/5/2012. 12 years pass by and the wife on a fateful day commits suicide. The commission of suicide leads the brother of the complainant, brother of the deceased, to register a complaint before the jurisdictional police, which becomes a crime. What crime is that? Which becomes a crime in crime number 334 of 2024 for offense punishable under section 85 and 108 of the BNS. The police BNS. Since the entire issue is triggered from the complaint, I deem it appropriate to notice the complaint. It reads as follows, page 12 and 13. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 23. If the complaint and the summary of the charge sheet are juxtaposed and perused, what would unmistakably emerge is that all the allegations are against the husband accused number 1. In fact, the allegations against the accused number 1 are all horrendous, as the narration is that the husband has tortured the wife for over certain years, which became unbearable, and the wife has committed suicide. Insofar as the accused number 2, the mother-in-law, is concerned, there is not even a titter of overt act by the mother-in-law, except an omnibus statement that the mother-in-law petitioner had demanded dowry from the hands of the sister of the complainant way back when they got married in the year 2012 or 15, or at intermittent intervals, not immediately before immediately before the death of the sister of the complainant. Therefore, permitting further for an offence to become punishable under section 108, which deals with abetment to suicide, what is necessary to be proved is the ingredients of section 107 of the IPC, which is now section 45 of the BNS, which defines abetment to suicide. The abetment to suicide, the interpretation of section 45 need not detain section 45 or section 107 of the earlier regime. The IPC need not detain this court for long or delve deep into the matter. The apex court in Yadvinder Yadav, 2025 SSC online SC page 2332, so and so, has held as follows. In the if the elucidation, if the facts obtaining in the case at hand is considered on the elucidation of the law by the apex court permitting further proceedings against the mother-in-law, in particular on the aforesaid facts, would become an abuse of the process of the law and result in miscarriage of justice, as the entire allegations are goaded against the husband accused number 1 and none against the petitioner, the mother-in-law. For the aforesaid reasons, so and so, allowed quashed. The petitioner accused number 2.
Deeply obliged.
Is your judgment?
Lordship's order, my lord. Grateful.
45.
Offense is 112 of BNS section 112 of BNS and section 79 and 80, my lord. Police Act, Karnataka Police Act.
Serial number?
Serial number 45.
Ispita. Andar bahar.
Private property ಒಳಗಡೆ ಆಡಿರುವಂತದ್ದು.
Private property ಅಲ್ಲಿ?
Within the residence of their
room
property.
ಮಾಡಿ ಅಲ್ಲಿ ಹೋಟ್ಲಲ್ಲಿ ರೂಮ್ ಮಾಡಿ
ನೀವ್ ಯಾಕೆ ಹೋದ್ರಿ ಅಲ್ಲಿ?
ಗಾರಿ
ಹೋಟ್ಲ್ ಅಲ್ಲ ಮನೆಲ್ಲ?
ಹೋಟೆಲ್
ಹೋಟೆಲ್ ಅಲ್ಲ.
7 ಜನ.
ಅಲ್ಲ ಹೋಟೆಲ್ ಅವ್ರು ಆರಾಮಾಗಿ ಒಳಗಡೆ ಆಡ್ಕೊಂತ ಅಲ್ಲೂ ಬಿಡಲ್ಲ ಅಂದ್ರೆ.
Yesterday, my lord, Supreme Court has confirmed the legality of the online gaming and taxations. Said that even game of skills, it's an offense if you.
ಆಯ್ತು, ಅದು ಕೊಟ್ಬಿಡಿ, ಎಲ್ಲ ಸ್ಕಿಲ್ ಮುಗಿಸ್ಕೊಂಡ.
Several judgments by all your
ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸೆವೆರಲ್ ಹೋಯ್ತು.
That is on
ಒಂದೇ ಒಂದ್ ಸಾಕು.
ಅಲ್ಲ, that is on taxation and things, my lord, on online games ಮತ್ತೆ ಇದ್ರ ಮೇಲ್ಗಡೆ, and that has nothing to do with this BNS offenses.
So that's correct, but the Supreme Court recognized the fact that the game of skill, it's not a chance, but in fact, game of chance is an offense. Game of skill, your lordship said held. It's not an offense. Even
ನಾನೇ ಬರ್ದಿದ್ದೆ.
there also Supreme Court now says.
ರೇಸಿಂಗ್ ಅಲ್ಲಿ ನಾನೇ ಬರ್ದೆ. Yes.
And it's not just a taxation, but that act prohibits online gaming as well. So that has been confirmed by the Supreme Court.
Organized petty crimes and various.
ಇದು ಏನ್ ಆಡ್ತಾ ಇದ್ರಿ ನೀವು?
ಅಂದರ್ ಬಾರ್ ಅಂತ ಇದರಲ್ಲಿ ಇದೆ, my lord.
ಹೋಟೆಲ್ ಅಂದರ್ ಬಾರ್.
8 ಜನ ಹೋಗಿದ್ದಾರೆ.
Moreover, the description in the complaint itself, they say 500 ರೂಪಾಯಿ ನೋಟ್ ಹಾಕ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Moreover, the entire amount what they says is not more than 13,000 out of 9 accused.
Oh. Stay ಇದೆಯಾ?
Stay ಇಲ್ಲ. This is first time it's been heard.
ಏನು ಆ ಕೋರ್ಟಲ್ಲಿ ಸ್ಟೇ ಸಿಕ್ಕಿಲ್ಲ ಇವ್ರಿಗೆ?
ಅಲ್ಲ, because it was not, it was end of the list ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು
112 ಇದೆ.
Not reached.
It's been this.
79, 80, 112.
Coastal melody, it's off late, it's becoming a nuisance, especially on this.
No, we'll decide this.
Yes.
Take notice. First time ಬರ್ತಾರೆ.
ಇಲ್ಲ ಬಂದಿದೆ ಹಿಂದೆ.
ಇಲ್ಲ, ಫಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಆಗಿಲ್ಲ. And additional SPP is directed to accept notice for the respondent. List the matter on 18th ಹಾಕ್ತೀನಿ. List the matter on 18th. Further proceedings shall remain state till the next date. ಅವತ್ತು ಮುಗಿಸ್ಕೊಂಡು ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ.
Offenses 354C and 300 and for the 23 504. Between the parties, the matter has been settled in a civil suit. A compromise was drawn, a decree was drawn.
ಎಲ್ಲಿದೆ?
The compromise decree, my lord, is at page number 117. My lord, the petitioners, my lord, are the plaintiffs.
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
And
Deepak
there
sir.
a clause may kindly look at Millard. Only
Deepak
one
ಅವ್ರೆ,
clause.
settle ಆಗಿದ್ಯಾ?
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ settlement was between the husband of the second respondent and the petitioners. Here it's a case where they were the owners, then sold the property, that was challenged, and ultimately they agreed that they are going out of the property. So that, as far as that part is concerned, that is settled. But what had happened is, in between, they entered the premises and then harassed, abused her, hit her, and physically abused her. So that was caught in the CCTV. Based on that, the police have charge
118
sheeted.
may kindly look at Millard. 118 page number, last clause number 9, compromise petition.
ನೀವು ಪೆಟಿಷನರ್ ಯಾವತ್ತಿದು ಟೈಮ್ ಆಗಿರೋದು?
Millard, the crime on 1/6/2025.
ಸೆಟಲ್ಮೆಂಟ್ ಯಾವತ್ತು?
The compromise, Millard, was happened on 17/1/2025.
Second respondent is not a party.
Kindly look at page 118, Millard, clause 9. Clearly case number mentioned, Millard. Specifically, I may be permitted to read.
ನಾನು ಸೆಟಲ್ಮೆಂಟ್ ಇಸ್ ಬಿಫೋರ್ ದಿ ಇನ್ಸಿಡೆಂಟ್ ಅನ್ಕೊಂಡೆ.
After only, Millard. Specific case number mentioned, Millard. The defendants and their family members shall withdraw the complaint and file a.
ಯಾವ ಪೇಜ್ ಅದು?
Page 118, clause, last clause, clause.
ಒಂದ್
number
ನಿಮಿಷ.
9. Clause 9, Millard.
ಒಂದ್ ನಿಮಿಷ.
Yes.
ಸಿವಿಲ್ ಸೂಟ್ ಇದೆ,
kindly
ಸ್ಪೆಷಲ್
look at-
ಕೇಸು ಇದೆ.
That is, this is the special case.
Hmm.
Withdraw the and case, and in the counter case assaulting against each other, it is agreed by both the parties. In default of withdrawing the above mentioned case by any of the parties, shall
Aye.
produce the
Close.
compromise petition.
The petitioners are before this court seeking the following prayer. The parties to the list were also before the civil court in OS 2053 of 2023. The 2053 of 2023. The first petitioner was the second plaintiff, was plaintiff number 2 in the said case. The parties enter into a settlement. The decree is drawn based upon the said settlement. The terms of settlement, insofar as the present list is concerned, is as follows. Page 118, 119. The parties agree to withdraw the suit, the special case, i.e. the subject case, and subject case that is filed, which was a case and a counter case. The parties that in default of withdrawing the above mentioned cases shall produce a compromise petition in the respective courts, is what is said. The special case is specifically mentioned as a condition of settlement upon which the decree is drawn by the civil court. In that light, it would not be, the complainant now cannot contend that the present criminal proceedings should continue notwithstanding the fact of the settlement and the benefits of the settlement being taken by the parties. In that light, I deem it appropriate to obliterate these proceedings, recording the recording the settlement that is arrived at as quoted herein above. For the aforesaid reasons, disposed, quashed.
Petition by accused number 4, please, my lord, accused. Split up charge sheet. Accused number 3, my lord, was
Preparation to commit dacoity, my lords.
Huh?
Preparation to commit dacoity. That's a
Preparation,
petitioner-
preparation.
ಕೊಡಿ ಅಂದ್ರೆ ಹೋಯ್ತು.
And for-
Orders of your lordship.
ಅದೇ ಗೊತ್ತಾಯ್ತು.
ಅದೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಇದು ಸೇಮ್ ಕ್ರೈಮಾ?
ಇಲ್ಲ, different.
Chetan. The petitioner is before the court calling in question the continuance of proceedings in CC 26975 of 2017 registered for offence punishable under section 399 and 402 of the IPC. The petitioner is accused number 4 gets embroiled in a crime on a suo motu case registered by the jurisdictional police in crime number 228 of 2013 against 5 persons on the score that the police had noticed that those persons were preparing for commission of dacoity, which would become an offence under section 399 and 402 of the IPC. The suo motu case is tried before the court of session, and the court of session acquits the were persons available for trial, i.e. the other accused 1 to 4,
A3.
huh?
Accused
Accused, the ಬೇರೆ ಇನ್ನಿಬ್ರು?
ಅವ್ರಿಲ್ಲ, ಸಿಕ್ಕಿಲ್ಲ.
The third accused,
Page number 53.
the page?
53, judgment.
The reasons rendered by the concerned court to acquit the other acquit accused number 3
Para 13 and 14.
is page ಏನು ಚಂದ್ರಶೇಖರ್?
62. 62, para 13 and 14.
Page 62. 62?
Page 62,
Ah.
para 13 and 14, madam.
60,
Reasoning.
65. Para 13, 14, page 66, 67. The petitioner admittedly was not available for trial at the relevant point in time, though indulgence should not be shown to those persons who escape trial to bring them on par with the persons who have been acquitted after a full-blown trial. What needs to be considered is the precious judicial time that would be wasted for an eventual acquittal in the light of the offense being the one punishable under section 399 and 402 of the IPC, which would be preparation for commission of dacoity. If preparation of commission of dacoity is done by 5 persons together, it cannot be said that one person would get acquitted on the evidence that is led and the other person would get convicted for the petitioner to be permitted to be tried. Since the precious judicial time is what is required to be noticed today, I deem it appropriate to exercise my jurisdiction under section 482 of the CRPC, 482 CRPC, and obliterate the crime against the petitioner. The view of mine in this regard. Allowed cost. Next.
48.
Offense under section 118, 109, 107, 54.
Attempt to murder.
Attempt to murder. I am accused number 2
Poxo
and
also.
3. There is no allegation.
Poxo.
Yes.
Poxo. I am no allegation against 2 and 3, my lord. 26, kindly see the charge sheet. Allegation is that A1 hit on the head of the one Swami. After that, I have reached the spot and instigated him. After that, the alleged crime, I have reached the spot and instigated him. Subsequently, I am not present.
Poxo yake?
Poxo very next day that A1 reached the house in front of the minor house girl, shouted that I am in love with you, I will marry you, and he was also present, the allegation. But in the complaint, kindly see the 11, the complaint, there is no reference of A2 and A3. And also 183 statement also, there is no reference of A2 and A3 in that report.
Yes, Nageshrap.
And also wound certificate also, it's a minor injury.
Page 25, that's A2 ಗೋಪಾಲ ಹಾಗೂ A3 ಮಣಿಸ್ವಾಮಿ ಇಬ್ಬರು ಕಲ್ಪನಾಳ ಮಾನ ಮರ್ಯಾದೆ ತೆಗೆದು ಆವಾಗ ಅವಳನ್ನು ಯಾರು ಮದುವೆ ಮಾಡಿಕೊಳ್ಳಲು ಮುಂದೆ ಬರುವುದಿಲ್ಲ ಎಂದು ಕುಮ್ಮಕ್ಕು ನೀಡುತ್ತಿದ್ದರು.
Instigation, that is instigation.
So what, sir?
My lord, I am not present at the time. As per the complaint also and the statement 183, kindly see, my lord, statement of the complaint. There is no reference of A2, A3 present. In the complaint also, there is no reference of A2, A3 present. And also, as far as 307 is concerned, subsequently in that commotion, after I read that spot, ಕೂಗುತ್ತಿದ್ದು
Yes, sir.
ಕೇಳಿ ಸದ್ದು ಕೇಳಿ ಆ ಸ್ಥಳಕ್ಕೆ ಬಂದ A2 and A3.
File discharge ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ. ಏನ್ ಈ ತರ ಹೊಡೆದಿದ್ದೀರಾ?
My lord, I am not present that there is no, in charge sheet also I am not there. Subsequently, after ಕೇಳುತ್ತಿದ್ದು ಬಂದು
Nothing. File discharge ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ. Yes. Intermode ಹೆಂಗೂ ಇಲ್ಲ.
ಇಲ್ಲ, first time.
Then it will not come next time. Yes. Discharge format. Yes, next.
49.
Accused number 4 is before his court, my lord. Accused number 1 and 3 have already been, the proceedings has been passed by the board bench of this court. My lords will find it annexed Annexure E, page 139.
130.
139. 139. And even in that proceedings, the complaint was absent, those years, sir.
ಅವ್ರು ಬರಲ್ಲ ಬಿಡಿ. Yes. Petitioner, accused number 4 is at the doors of this court calling in question proceedings in so and so. The learned counsel for the petitioner takes this court through the orders passed by the coordinate bench which has quashed the proceedings against accused number
1 to 3.
1 to 3. Who remains in the fray is only accused number 4. The complainant, though served, remains unrepresented even today. He had remained unrepresented even before the coordinate bench, which had quashed the proceedings, accused number 1 to 3. In that light, I deem it appropriate to paraphrase what is observed by the coordinate bench. The coordinate bench has held as follows: full order court madi, allowed quashed. Next.
50,
24th. ಎಲ್ಲಿ ಮತ್ತೆ?
I'm sorry. Please. My lord, fresh matter, my lord, that's.
Fresh matter?
ಹೌದು. Notice not issued.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ. My lord, the civil dispute, my lord.
ಯಾಕೆ 4 ಸರಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದೀರಾ?
I was on my legs on the previous days of my land council.
ನಿಮ್ದು ಇಲ್ಲಿ ನನ್ ಮುಂದಲ್ಲ ಸರ್.
ಅಲ್ಲಲ್ಲ.
Previous bench ಅಲ್ಲಿ.
ಹೌದು, ಅಲ್ಲಿ I was on my legs in another court ಮೇಲೆ. Page 23, my lord, complaint is lodged on 25.
Own certificate ಎಲ್ಲಿದೆ?
Assault with hands.
After 10 days, complaint is lodged.
Assault with hands ಸುಮ್ನೆ ಹಿಂಗೆ.
After civil case is pending, my lord. Now after 10 days, the complaint is lodged. 15/12/24 is the incident, alleged incident. 25/12/2024
ಅಲ್ಲ
is
ಅದು
the
ಪರವಾಗಿಲ್ಲ.
10 days, my lord.
ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ವಾ?
Own certificate taken.
Because 118 is with a weapon.
ಹೌದು. ಕೈ ಲೋಡ್.
Thereafter, my lord, he was assaulted.
Case and counter case.
ಅಲ್ಲ, earlier one more complaint we have filed, my lord, that's pending. ಅವತ್ತು ಅದಕ್ಕೆ
Heard the learned senior counsel P.P. Hegde appearing for the petitioner. The parties to the list are before the civil court in OS 81 of 2022. After the registration institution, then OSO.
ಹೌದು.
After the institution of the OS springs the impugned complaint glorifying the incident, a particular incident, to become an offence under section 1181 of the BNS. For an offence under section 1181, the ingredients as necessary, the offence voluntarily causing hurt with using a weapon is necessary. The wound certificate in the case at hand depicts that it is simple injury.
Simple injury.
The simple injury. Therefore, it is a case which we could be only under 115 and not 118. In that light, there shall be an interim order of stay of further proceedings quay the petitioner till the next date of hearing. 1 HCGP 2 emergent notice.
Great.
Next. Senior counsel ಹಾಕಿದ್ರಾ?
51,
Please.
Appear on the petitioner. My lord.
First time ಬರ್ತಾ ಇರೋದು.
First time ಅಂದ್ರೆ ರೀಚ್ ಆಗಿಲ್ಲ ಲಾಸ್ಟ್.
ಆಯ್ತು ಸರಿ. ಓ ಪ್ರೀವಿಯಸ್ ಬೆಂಚ್ ಅಲ್ಲಿ ರೀಚ್ ಆಗಿಲ್ದೇ ಇರೋದಲ್ಲ. ಎಸ್. 420 504 506. Forgery ಇದೆ?
ಅಲ್ಲ, forgery ಅಂದ್ರೆ see we have filed, we have lodged a complaint. On the basis of our complaint, criminal proceedings were initiated against the respondent number 2 and his wife and some others. And in those criminal proceedings there is an acquittal, judgment of acquittal. A document exhibit P5, a MLC register extract was marked by us. He takes after his acquittal, he picks up that document and then files a private complaint alleging forgery, my lord, and creation of false document. That is the complaint. And
sir, let the service happen.
Stay, my lord.
No.
And because there is no wound certificate produced, basically he has not produced the wound certificate at all.
79 is not the offense, it is forgery and using the document. Yes.
Using document, but that document itself is not produced in the
1
private
HCGP
complaint.
2 emergent notice returnable by the 2nd July, list on 2nd July. We'll consider on that day.
52,
Rajat,
State.
you are.
Sir, respondent to my lord.
You appeared before the committee?
Before committee and ನಮ್ಮ ರೂಲ್ 10 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀನಿ ಮೇಲೆ.
ಏನ್ ರೂಲ್ 10?
ರೂಲ್ 10 ಅಲ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ಫಾರ್ಮ್ ಸಿ ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ?
ಅಲ್ಲಿ ನಾನು PAP ಗೆ ಹೋಗಿದ್ದೆ 14% ಕಮಿಟಿಗೆ. ಅವರು ಇಲ್ಲ ರೂಲ್ 10 ಹಾಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು. ಸರ್ ರೂಲ್ 10 ಅಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಮೇಲೆ.
ಯಾರು ಹೇಳಿದವರು? ಎಸ್. ಆಯ್ತು, you want to file your objection ಹಾಕಿದ್ದೀರಾ?
ತಾವು ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ಹಾಕೊಂಡ್ಬಿಡ್ತೀನಿ.
3 rounds of objections have been filed.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Then we'll hear it after 3 rounds. Yes.
The problem
give
is
me consent, my lord, to appear this case. Kindly give me consent to argue my case.
No, we'll see. We'll rule 10 interpret. Yes.
Let's just take 1 minute of my lords. Anticipatory bill is pending before the trial court. Because there is a stay in operation here, my lords, I am not
I will
obtaining.
direct the court. This is the matter you moved.
Please, my lords, this is one.
I will direct the court to consider the anticipatory bail application independently. Stay ಇದೆಯಲ್ಲ ಇಲ್ಲಿ anticipatory bail ಹಾಕ್ಬೇಕು.
The problem is, my lords, that the respondent here is going and approaching the other people who are members of my WhatsApp group, which is the fulcrum of the issue, my lords, and they are being threatened to give statements against me. I am apprehensive, my lords, other coercive steps. Next complaint. The only problem.
Next complaint ಅಂದ್ರೆ next petition ಅಷ್ಟೇ.
ಸರ್ ಅದನ್ನ ರಿಪ್ಲೈ ಮಾಡಲ್ಲ ಸರ್ ಮೇಲೆ
ಹಾಕಿ.
ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ದೇ ಆರ್ ಯೂಸಿಂಗ್ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಲಿಟ್ರೇಟ್.
ಆಯ್ತು, we'll see. Stay ಇದೆಯಲ್ಲ.
This is against the.
I'll direct the concerned court to consider it.
And the petitioner is not social worker, my lord. He was extorting money from.
ಆಯ್ತು, we'll see. Yes.
Innocent.
There is an
builders.
interim order operating in the case at hand. The learned counsel Rajat appearing for the petitioner submits that the concerned court is not answering the application seeking anticipatory bail on the strength on the score that the present petition. There is an interim order operating in the case at hand. Therefore, if an application seeking anticipatory bail is filed, the same shall be considered on its merit with on its merit, notwithstanding the interim order subsisting in the case at hand. List after 2 weeks. Yes.
Request for a date, my lords.
List 20 or either 25th.
Sir, my lord, kindly give me consent to appear before this.
25th we'll see. Yes, next. Avat nodu. Notice. Notice. Yes.
Appear for the respondent.
Offense under section
Appear for the
7A.
respondent.
7A.
7A of PC Act. This petition is accused number 2.
ನೀವು ಯಾರು?
One submission.
ಒಂದು ನಿಮಿಷ ಸರ್, ನೀವು ಯಾರು?
Accused number 2.
ಏನ್ ಮಾಡಿದ್ರಿ?
Accused number 1, complainant gave a complaint for survey of the land. It was entrusted to accused number 2. Accused number 2, my lord, entrusted the work to the accused number 1. He surveyed the land. He demanded the bribe amount.
Who demanded?
A1.
A1. ನಿಮಗೆ ಕೊಡ್ಬೇಕು ಅಂತ.
ಹೌದು. ಅಲ್ಲ ಕೊಡ್ಬೇಕು ಅಂತಲ್ಲ, ಆಮೇಲೆ ಬರ್ತದೆ. ಫಸ್ಟ್ ಸರ್ವೆ ಮಾಡಿದ್ಮೇಲೆ ಡಿಮಾಂಡ್ ಮಾಡ್ದ.
ಆಯ್ತು.
ಡಿಮಾಂಡ್ ಮಾಡಿದ್ರೆ ನಾನು ಅಪ್ಲೋಡ್ ಮಾಡಕ್ಕೆ ಕಂಪ್ಯೂಟರ್ ಅಪ್ಲೋಡ್ ಮಾಡಕ್ಕೆ he has demanded 8,000 rupees. And you caught red-handed while accepting the money.
Who accused number 2?
A1.
A1. ನೀವು ಯಾಕೆ? Why are you in the fray?
On the basis of the statement of accused number 1, I have been implicated.
Who is the superior officer?
Both are surveyors.
Both are surveyors.
Both are surveyors.
But with the latest judgment ಬಾರಿ ಕಷ್ಟ.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನಿಲ್ಲ.
ಏನಿದೆ?
Except the statement of.
ನೆನ್ನೆ ಬಂದಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದ್ರಾ?
ಗೊತ್ತು.
ನೆನ್ನೆ?
ಇಲ್ಲ ಅದು ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಡೇ ಆಫ್ ವೆಕೇಶನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
My submission is that
2026 SEC online SC 960.
On behalf ಅಂತ ಹೇಳಿದ್ರು, work done by ಅದನ್ನ ನೋಡಿದೀನಿ ನಾನು.
On behalf of.
On behalf, demanding
Here
on behalf.
demand is enough.
No, not even seeing complaint ಅಲ್ಲಿ ಇವನ ಹೆಸರಿಲ್ಲ, ಡಿಮಾಂಡ್ ಇಲ್ಲ. And conversation ಅಲ್ಲಿ ಕೂಡ ಇವನ ಹೆಸರಿಲ್ಲ, ಡಿಮಾಂಡ್ ಇಲ್ಲ. Except the statement of the co-accused A1. ನಾನು ಅವನ ಪರವಾಗಿ ಇಸ್ಕೊಂಡೆ.
Objections ಹಾಕಿದೀರಾ?
Objection ready to file alert.
ಆಯ್ತು, ಹಾಕಿ. List on 17th. Objections if any by then.
Yes, please.
ಇದೆಯಾ?
Stay ಇಲ್ಲ.
7 ಎಲ್ಲಿ ಯಾರು stay? Yes, next. ಅವತ್ ನೋಡು.
54.
ಇವ್ರ ಮೇಲೆ
ಇಲ್ಲ ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಮಾಡೋಣ.
Appear the petitioner, my lords. Lords under Immoral Traffic Act, my lords.
Accused number?
Accused number 3, my lords.
Customer
ಇಲ್ಲ, on the basis of
Pimp is a pimp, my lords.
ಏನು?
Pimp.
ಅಲ್ಲ, on the statement of accused number 1, my lords, I have been arrested as accused in the charge sheet. ಅದ್ ಬಿಟ್ರೆ ಬೇರೆ ಏನ್ ಮೆಟೀರಿಯಲ್ಸ್ ಇಲ್ಲ, my lords. This matter was listed 3 times. My lord had directed the state, my lords, to say anything apart from the statement of the co-accused. Is there anything on the charge sheet, my lords? That is nothing there in the
List the matter on 10th. In the same stage, the state shall place on record material available against the petitioner accused number 3 apart from the voluntary statement of the other accused.
There's no interim order, my lords.
There's no interim. ಅವತ್ತು ಮುಗಿಸಬೇಡ ಇಲ್ಲ ಅಂದ್ರೆ.
The fresh matters list at least.
No.
Because it was listed thrice, my lords had
No,
listed in the
admission
fresh.
admission reach ಆಗುತ್ತೆ.
ಅಲ್ಲ, fresh matters ಎಲ್ಲ ತಾವು ಲಿಸ್ಟ್ ಮಾಡಿದ್ರಿ. Only for their instructions, my lords, apart from ಏನಾರ ಇದೆಯಾ ಅಂತ ಕೇಳಲಿಕ್ಕೆ.
55.
Lordship, the counsel on record is an argument in a different court hall, your lordship, kindly pass it.
Yes. We'll take it after 3 weeks.
Tomorrow, your lordship.
Tomorrow ಇಲ್ಲ. ಏನಿದೆ?
397.
390 ಬರ್ಲಿ. Yes. List the matter on 17th. Yes, next.
56.
It's 2014 matter. It could have been.
ಇದು 14 matter.
ಹೌದು.
76.
ಇಲ್ಲ 56.
56.
55.
55 2014 da.
FIR of 2014.
We'll post it tomorrow. Tomorrow ಆಗುತ್ತಾ ಮೇಡಮ್? ನಾಳೆ. We'll close it tomorrow. ಹಾ ಹೇಳಿ ನರಸಿಂಹಮೂರ್ತಿ.
ಇಲ್ಲ ಇಲ್ಲ.
ಹಾ ರಿಸ್ಟರ್ಬ್ 2 weeks, yes. 57 ರಮೇಶ್ ಮಧುಕರ್.
57 ಒಳಗೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಹಾ.
2 ಗ್ರೂಪ್ನವರು ಕೊತ್ತಂಬರಿ ಸೊಪ್ಪು ಮಾರ್ತಾ ಇರೋದು.
ಕೊತ್ತಂಬರಿ ಸೊಪ್ಪ
ಮಡಿವಾಳ ಇದ್ರೊಳಗೆ ಮಾರ್ಕೆಟ್ನೊಳಗೆ ಸಣ್ಣ ಪುಟ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಿದ್ರಿ?
ಏನೋ ಒಂದು ವಿಚಾರದೊಳಗೆ ಗಲಾಟೆ ಆಗಿ
ಕೊತ್ತಂಬರಿ ಸೊಪ್ಪು ಗಲಾಟೆ.
ಹೌದು.
ಹಾ.
ಇಬ್ರು ಪಾರ್ಟೀಸ್ ಕೌಂಟರ್ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಆಗಿದೆ. ನಾವು 109 ಒಂದ್ರೊಳಗಿದೆ. ನಾನ್ ಕಾಂಪೌಂಡಬಲ್. ಇನ್ನೊಂದು ಕೇಸ್
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದ್ಯಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದೆ.
ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ?
ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್.
ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
ಬೋತ್ ದಿ ಪಾರ್ಟೀಸ್ ಕಾಂಪ್ರಮೈಸ್.
ಸಿಂಪಲ್ ಇನ್ ನೇಚರ್.
ಹಾ.
ಊಂಡ್ ಏನು?
ಉಂಡು
ನೀವು ಬರೀ ಕೊತ್ತಂಬರಿ ಸೊಪ್ಪು ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ, ಊಂಡ್ ಹೇಳ್ಬೇಕು
ಅಂತಂದ್ರೆ ಇನ್ಫ್ಯಾಕ್ಟ್ ಮಲಡ್ ಅಂಡರ್ 482 ಬೋತ್ ದಿ ಪಾರ್ಟೀಸ್.
ನೀವು ಡೋಂಟ್ ವರಿ, ಏನಿದೆ ಹೇಳಿ ಉಂಡು. ನೀವು ಕೊತ್ತಂಬರಿ ಸೊಪ್ಪು ಕಟ್ ಮಾಡೋದನ್ನ ಯಾರನ್ನೋ ಕಟ್ ಮಾಡಿದ್ರೆ?
ಇಲ್ಲ ಇಲ್ಲ ಅದೆಲ್ಲ.
ಹಾ ಮತ್ತೆ ಅದೇ. ನಾಗೇಶ್ವರಪ್ಪ ಏನಿದೆ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್? ಸಿಂಪಲ್.
ಹೌದು. ಅಬ್ರೇಷನ್ ಒಂದು ಸಣ್ಣದು.
ಸಣ್ಣ ಅಬ್ರೇಷನ್.
ಆಮೇಲೆ ಅಷ್ಟೇ ಅಬ್ರೇಷನ್ ಆನ್ ಶೋಲ್ಡರ್, ಮಲ್ಟಿಪಲ್ ಅಬ್ರೇಷನ್
ಅಷ್ಟೇ. ಅದೇ ಕೊತ್ತಂಬರಿ ಸೊಪ್ಪು ಉಜ್ಜಿ ಬಿಟ್ಟಿದ್ದೀರಾ ಅಲ್ಲಿ.
Simple.
Simple. Yes, Jagdish will close it. The petitioners are before this court.
ಬ್ಲಡ್
ಆಯ್ತು. ಈ ಕಡೆ ನೀವು ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗ?
ಅಲ್ಲ,
ಇವ್ರು ಯಾರು ಪೆಟಿಷನ್? ನೀವ್ ಯಾರಿಗೆ?
ಅಲ್ಲ, ಇನ್ಮೇಲೆ ನನ್ ಕೌಂಟರ್ ಕೇಸು ಹಾಕಿದ್ದಾರೆ. 2 ಕೇಸು ನಾನೇ ಕ್ಲಬ್ ಮಾಡಿಸ್ತೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಬೋತ್ ದಿ ಪಾರ್ಟೀಸ್.
ಹಂಗ ನೀವು ಮಧ್ಯದಲ್ಲೇ ಇರಿ, ಒಂದ್ ಕಡೆ ಈ ಕಡೆ ಯಾಕೆ? Yes.
Both the parties are present before this.
The petitioners are before this court seeking the following prayer. The parties to the list are vegetable vendors in KR market.
Alla, Madiwala market.
In Madiwala market. A verbal squabble leads them to blowing of fists against each other, which leads to the complaint and the complaint for offense punishable under section 109 of the BNS, section 307 of the earlier regime, the IPC.
1152.
Other inter alia. The petitioner, the parties to the list have now entered into a settlement and wants these petitions to be closed as it is a case and a counter case. The learned counsel for the learned HCGP submits that the offense is the one punishable under section 307 of the ಸ್ವಲ್ಪ opposition irli. Submits that the offense is one punishable under section 109 and should not be terminated by way of a settlement. The notwithstanding the said submission in the delight of the judgment of the apex court in the case of Lakshmi Narayan 2019 5 SCC 482, where the apex court holds that the court should not be bogged down by the offense when the settlement is projected. It should notice if the wound is grievous or otherwise in nature. The wound certificate in the case at hand admittedly depicts that the wounds are simple. Therefore, there is no impediment for this court to close the proceedings on accepting this settlement. These terms of settlement reads as follows. In that light, the petition stands allowed. Petitions are allowed. Crimes quashed. The proceedings quashed in both the cases. We'll sign ಮಾಡ್ಬಿಡಿ.
Please.
ಈಗೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಅದೇನಾ?
ಇಲ್ಲ ಅಲ್ಲ.
ಕೊತ್ತಂಬರಿ ಸೊಪ್ಪೆ
ಈಗೆಲ್ಲ ಒಟ್ಟಿಗೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಒಟ್ಟಿಗೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಹಾ, ಸ್ವಲ್ಪ ಬೇರೆ ಸೊಪ್ಪು ಆಡ್ ಮಾಡಿ. All right. Yes.
I beg to appear for the petitioner, Maharaj. In this case,
I will take it another day. List
Yes.
on 17th interim order subsisting.
Petitioner may be directed to serve the copy on me.
Serve a copy.
I'll do that, Maharaj.
The petitioner shall forthwith serve requisite set of papers upon the counsel appearing for the complainant. List objections, if any, by the next date, 25th interim order subsisting will continue to the next date of hearing. Yes, next.
Much obliged.
Mahesh.
306. My lord, they entered into a business venture. So the petitioner, my lord, there was a giving and taking of.
Charge sheet ಆಗಿದೆಯಾ? ಬರೀ investigation. ಹೇಳಿ.
What has happened is, my lord, from 2016, whatever the amount he has received from the victim,
that has been repaid more than double. That, my lord, along with the charge sheet, the police have filed the statement of account also. Now during COVID, my lord, all his resorts got closed.
Resort?
Because he was running a chain of resorts.
All right, all right.
Thereafter, my lord, he was expecting the same returns. And he says, my lord, the victim says that he went into a depression. Even the complaint says, my lord, he was in depression from last 2 years with regard to the payments. So the only allegation is that, my lord, that due to depression, my lord, he committed suicide.
You accused number?
Sole accused.
Death note is available, your lordship.
Yes, my lord.
With the, as per the handwriting experts, it is the
ಅದೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, ಅವರೇ ಬರ್ದಿರೋದು.
other financial transactions is sole cause petitioner.
The petitioner is the sole accused, suffering an acts of abetment to suicide as obtaining under section 108 of the 306
306.
306 of the IPC. The deceased, the complainant yaru?
Complainant, they were into business, my lord.
Ayyo, complainant yaru?
Complainant is the wife of the deceased.
The husband of the complainant and the petitioner have had financial transactions for over the years. The transactions go wrong and the husband of the complainant commits suicide. The acts of suicide, acts of abetment to suicide has now fallen upon the petitioner. A perusal at the summary of the charge sheet is obtaining in column number 17 would clearly indicate that the abetment, the suicide happens on the financial transactions gone wrong and the complainant, husband of the complainant, getting into depression on the score of loss in the financial transactions. This cannot mean that the petitioner would be tried for abetment to suicide. Permitting further proceedings against this petitioner would run foul of the judgment of the apex court in Yogendra Yadav 2025 SEC online SC page 2332. In that light, there shall be an interim order of stay for the proceedings quay the petitioner to the next date of hearing.
And also your lordship's judgments.
Yeah. Saddik one sir.
Oblige.
Preliminary hearing 60.
The petitioner. Offences under section 341, 34, 504, 324 and 323 allots for accused number 2, 3 and 4. The allegation is that she takes the conjugal rights order, appears before the husband's house, and then it is said that the husband and the accused number 5, who was a minor at that point.
Main time. Yes, next.
Please, Your Honor.
Quoting settlement 61.
For petitioner, my lord, the matter has been settled in trial court. So short accommodation
ಎಲ್ಲಿದೆ
on
ಕೊಡಿ.
9th.
Mediation report ಇದೆಯಾ ಇಲ್ಲಿ? ಇದೆಯಾ ನೋಡಿ. When do you want?
On 9th, my lord.
9th. Rest on 9th at the request of the counsel appearing for the petition.
62.
Mediation report, I filed. Mediation report.
498A.
498.
Page.
My lord, page number 7.
Yes.
There's mistake in mentioning the number, my lord. Criminal RP ಬರ್ತಿದ್ದಾರೆ, criminal petition.
Yes.
Great.
ಆಮೇಲೆ ನಾಳೆ ದಿನ ತೊಂದರೆ ಆದ್ರೆ ನಿಮ್ನೆ ಇಟ್ಕೊಂತಾರ.
ಇಲ್ಲ ಇಲ್ಲ ಬರ್ತಿದ್ದಾರೆ.
Next.
63.
Angad.
490.
24th. Enter ಮಾಡಿದ್ರೆ continue ಮಾಡಿ.
64.
My lords, I appear for petitioner, my lords. ಇದರಲ್ಲಿ settlement ಆಗಿಲ್ಲ, my lords. By mistake ಆಗಿ reporting settlement.
Settlement ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ, my lords.
It was posted for orders, my lord. It's posted for settlement. I guess.
Vacating stay ಅಂತಿದೆ? ನೀವು ಹಾಕಿದ್ದೀರಾ vacating stay?
My lords.
Hey, this
Already
matter.
argument
50 lakhs.
Yes, my lord.
Please.
Range Rover. Oh,
Please.
yes. So we'll hear it.
We have argued at length, my lord. It was posted for orders on 12th March.
Oh, wait, madam. My memory is too weak. So we'll see. Yes. List the matter on ಯಾವತ್ತು 17th ಹಾಕಿ ಮುಗಿಸ್ಬಿಡೋಣ. 17th, yes.
Interim order, my lords.
ಬೇಡ ಹಂಗೆ. Oh, reporting settlement for dictating orders. Yes. Is that Hyderabad, right?
No, my lord.
Production of account statement before the NCLT, which is said to be for. Yes, all right.
My lords, interim order, my lords.
Interim order will continue.
Please.
ಯಾವ್ದು ಮೇಡಮ್? ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ಸ್ ಹಾಕಿ ಎಸ್ ವಿನೋದ್ ಕುಮಾರ್ ಇಬ್ರು ಇಲ್ಲ.
My lord, I am for the respondent in this 65 case, my lord.
ನಿಮ್ಮ ಹೆಸರೇನು ಸರ್? ಆಯ್ತು, ಎಸ್
230 mood matter.
ಕೊಡಿ.
My lords, the petitioners and the respondent number 2 herein are neighbors, and since 2020 they have been engaging in a lot of verbal spats all the time. But
6 years, too long a period. Consistency ಇದೆ.
No, my lords, it crossed a boundary last
Oh.
year. So last year they again got into a verbal spat, and then after that the respondent number 2 charged at the petitioner. So petitioner is an aged woman and her daughter. At them she charged. She's hit them. She has held both of their hair and pulled it. The neighbors had to come and intervene. Now, when I went to register and file an FIR, the police has not taken it. They have registered an NCR instead. I produced it at page number 83, Your Honor.
Land Additional SPP is directed to accept notice for the respondents.
My lords,
Emergent notice to the second respondent in the meantime.
my lords, the stay could be granted because here, when I go and file a FIR, it's not registered, but their FIR gets registered.
Stay you
and
don't want?
I want to stay, Your Honor.
Granted already, yes.
Oh, apologies, I did not hear that. Obliged.
Passed over matter. Passed over matter. List number 2, seal number 9.
I'm appearing for the petition. Senior counsel has a personal inconvenience. I request.
Special inconvenience.
Personal inconvenience.
Personal inconvenience.
Request Your Honor to adjourn it to Monday.
This is
I
the
kindly
matter.
request for
Tomorrow, my lord.
So serial number 9 list 2. List 2 sir.
ಇದು ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಅದ?
No, my lord. This is the
This is with respect to ED.
ED matter.
Freezing of the bank account.
ಹಾ, ಎಸ್.
May kindly have it tomorrow, my lord.
Monday or
ಅಲ್ಲ, ಇದು ನಾಳೆ ಇದೆ ಬೇರೆದೆಲ್ಲ. ಇವತ್ತು ಇನ್ನೊಂದಿತ್ತಲ್ಲ, ನಾಳೆ ಆಗಲ್ಲ. ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ.
Please.
Tuesday, same stage. Yes, next.
Obliged.
20.
Filed an application for renewal of passport, my lordship.
ಇದರಲ್ಲಿ lordship may see lordship's order, my lord. In fact, a lengthy argument was addressed in connected matter.
Connected matter, my lordship, different accused, not us.
Madam,
ಕೊಡಿ ಮೇಡಮ್ ತಗೊಳ್ಳಿ.
this is in connection with the FIR number 505. Now 505 and
ಅಲ್ಲ ಏನ್ ಫೋರ್ಜರಿನಾ?
No, my lordship, I may be permitted to explain in a nutshell. In the year 2017, the petitioner was the DGM of HL.
So, can we have it tomorrow?
At my lordship's
ನಾನು
convenience.
ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ.
At my lordship's
We'll have it.
convenience.
We'll have it tomorrow.
Oblige, my lordship.
Yes. Tomorrow fresh matters.
Oblige, my lordship.
Further hearing is continued.
ಮೋಹನ್ ಕುಮಾರ್.
67.
Poxo matter madam. ಇವರು ರಾಜ್ಯ ಆಗಿದ್ದಾರೆ. ರಾಜ್ಯ ಆಗಿ ಮದುವೆ ಆಗಿ ಮಗುನೂ ಆಗಿದೆ ಸರ್.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, ಇರ್ಲಿ ತಾಳಿ, ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ನಡೀಲಿ. ಲಿಸ್ಟ್ ಆನ್ 1st July. Interim order continues. ರಾಘವೇಂದ್ರ.
68.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್.
First matter, I think the petition by co-accused has been rejected and affirmed by the apex court.
ಹೌದಾ? ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆಯಾ?
ಅದರಲ್ಲಿ interim order ಇದೆ.
ಇಲ್ಲ, ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಯಾಕಿದೆ?
Your lordship was pleased to hear it for some time, not long back, very long back.
We'll release it from part third. Release the matter from the status of being part third, post the matter before the bench having roster. Interim order, if any, shall continue to the next date of hearing. Yes, next.
69.
Forest encroachment.
ಇದು ಒಂದ್ಸರಿ ಇದನ್ನ ಅಲೋ ಮಾಡಿದ್ದೆ, ಆಮೇಲೆ ರೀಕಾಲ್ ಮಾಡಿ ರೆಸ್ಟೋರ್ ಮಾಡಿ ನಾನೇ ಬರೀಬೇಕು. ಎಸ್, ಸೊ ವಿಲ್ ಟೇಕ್ ದಿಸ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಒಂದು ರೆಡಿ ಆಗ್ಬಿಡಿ, ಮುಗಿಸ್ ಮಾಡಿ. 10th ಎಂಟ್ರಿ ಮಾಡಿ ವಿಲ್ ಕಂಟಿನ್ಯೂ.
Much obliged.
ನಾಗರಾಜ್, ಏನಪ್ಪ ಇದು?
Bank lockers, my lord,
Black magic.
Yes, my lord.
Oh.
Pending from 25.
No, you did not ask Black Magic to show where are the lockers and what is the money inside the locker.
No, my lord, both complainant and accused will be benefited, no, my lord.
Black Magic ga?
Locker ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ ಇಬ್ರಿಗೂ ಬೆನಿಫಿಟ್ ಆಗೈತೆ, my lord. I've given representation, my lord. The IO should have break up on the locker or taken.
Sir, Black Magic ಅಲ್ಲಿ ಎಲ್ಲ ಆಗುತ್ತೆ ಏನು?
Like benefit has caused to him because its gold value has gone up.
Correct.
Yes, my lord. More than 2 crores, my lord.
ಏನು?
A value of the gold and diamonds, my lord.
Diamond?
Diamond is also.
ಅದು ಇದೆಯಾ ಅಲ್ಲಿ?
ಅದು ಇದೆ.
You can direct us, my lord. Otherwise, without direct.
Please, my lord, any direction.
ಈಗ you get open the locker and get drawn inventory as to what is there in the locker. Locker numbers ಎಲ್ಲಿದೆ? ಯಾವ ಬ್ಯಾಂಕು?
My lord, Kotak Mahindra Bank, my lord. Everything.
Details ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, yes, yes.
The petitioner is before the court seeking a direction to the state to open the lockers in the banks that are indicated in the petition. Therefore, the state shall cause the opening of the lockers and drawing up an inventory of what is found in the lockers. What is found in the lockers in the banks that are indicated, in the petition. The
seize or keep it back.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತೇವೆ ಒಂದು ನಿಮಿಷ. And draw an inventory and place it back into the lock. ಬೇಕಾ? ಯಾಕೆ? ನೀವೇ ಸೀಸ್ ಮಾಡಿ. And take the same into their custody as observed by drawing up an inventory and place the inventory before this court on the next date. ಆಮೇಲೆ ನೋಡೋಣ.
Log books also, my lord, because the entry and exit everything will be seen.
ಯಾವ ಲಾಗ್ ಬುಕ್?
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಬ್ಯಾಂಕ್ ಲಾಕರ್ಸ್ ಯೂಸ್ ಮಾಡೋದಕ್ಕೆ ಲಾಗ್ ಬುಕ್ಸ್ ಇರುತ್ತೆ, my lord.
Log book. And the respondent state also shall take copies of the entries in the logbook of entry and exit to operate the locker of the persons who have operated the locker.
Please.
Yes. And place the same before the court on the next date.
Deeply obliged.
Yes. Date ಕೊಡಿ ಮೇಡಮ್. ಒಂದು 1st July ಹಾಕ್ಲಾ? 1st July in the same stage.
Please.
Yes. Madam.
Made a short submission.
Short synopsis.
No, submission.
So yes.
Like 61 and 63 same case, my lord, like date on 9th.
Which 61? First list.
Serial number.
Settlement, what do you want?
On 9th.
All right, 9th.
63 and 60.
That's all?
Yeah. 61 and 63.
All right.
Nine, 61 and 63.